Morning, welcome. My name is Bill Hennessy. I am honored and humbled to serve as chair of the Real Property Probate and Trust Law section this year. I'd like to welcome you to the 40th annual Legislative and Case Law Update. That's right, 40th annual. You'd think that after 40 years there would be no surprises and we'd have all of this figured out. Unfortunately, 2020 has surprises for each and every one of us, and we can't be at the lovely Breakers Hotel in Palm Beach today. However, our Legislative and Case Law Update Committee has put together a fantastic seminar for you. I know you're going to love every minute of it. Before we get started, I want to thank our sponsors for today and today's seminar. The first is Attorney Title Fund Services, affectionately known to all of us as the Fund. You're going to hear a little bit later this morning from Melissa Murphy. I know that all of you already know what the Fund does. Melissa's going to tell us a little bit more about that. In addition to the Fund, Family Network on Disabilities, Fidelity National Title Group, Guardian Trust, North American Title Insurance Company, and Qualia are all sponsors for today's seminar. You know, normally we'd have a big exhibitor hall set up for our sponsors and you'd be able to stop by and see them. Unfortunately, we have to do that virtually. You can find a sponsor page on our app. I invite you to go to that sponsor page, check in with our sponsors, drop them a note, tell them how much you appreciate them, and let them know how much you enjoy this seminar. Without them, we can't do these seminars. They are an important part of what we do, so make sure you stop by and say hello. Finally, before I end today, I want to introduce a good friend of mine, Laird Lyle. Laird Lyle is going to talk to you about the PACs, the Political Action Committees that we have for the Real Property Probate and Trust Law section. All proceeds from today's webinar are going to support our PACs. The PACs are the lifeblood of what we do as a section. Without the PACs, we wouldn't have a legislative update. And so it's important that all of us continue to support our reptile PACs. Laird Lyle is going to tell us more about that. And so I hope you enjoy today's seminar, and I look forward to seeing you soon in person. Thank you very much.
Good morning. My name is Laird Lyle. Welcome to the annual Legislative and Case Law Update Seminar. I'm here this morning on behalf of the Real Property Probate and Trust PAC and the RPPTL PAC. These PACs are co-sponsors of this seminar, and the PACs were formed by like-minded individuals who recognize the importance of participation in the legislative process by supporting candidates for the Florida legislature and statewide candidates in Florida. Please consider joining the PAC. Regular memberships begin at $50 per year, and we're still looking for our first double platinum member at $10,000 per year. Thank you for being at the seminar, and please enjoy.
Welcome to the Real Property, Probate, and Trust Law Section Annual Legislative Update for 2020. I'm Melissa Murphy with the Fund, and I am so proud of our longtime sponsorship of this annual event because the Legislative Update is one of the best examples of what the section is all about. Advocacy, legislation, education, and leadership. Several hundred Florida attorneys look forward to this event every year. And because of the section's commitment to the profession, they have done what is necessary to bring the same content to you virtually. And it is this commitment to the profession that forms the foundation of why the Fund is so supportive of the section and its activities. Because the Fund lives this commitment every day through supporting its members with top-notch title information, underwriting support, practice support, and educational opportunities. And our advocacy on behalf of our members and the profession is such a strong part of our DNA, and it makes supporting this event, which is all about the results of a whole lot of legislative efforts, such a special occasion every year. So enjoy the program. Thank you for your support of the section, and thank you for your support of the Fund.
Good morning, and welcome to the 40th Annual Legislative Update. While we're all sad that we can't be together physically, we're fortunate to have this video platform available to us so that we can watch our colleagues do what they do best, and that is to educate the section members on legislative actions that impact our practices. I would like to thank my predecessor, Tom Carr, for all of his hard work in getting this program ready so that the last-minute transition to a visual format was seamless. I would also like to thank the members of the Legislative Update Committee: Theo Kiprios, Gutman Scrand, Jennifer Sloan Tobin, Kit Van Pelt, Salome Zakakis, Rob Friedman, Sangeeta Banerjee, and Chris Smart for all of their hard work. We've been working since November on this program, and they worked very hard to help us re-engineer something that we've been doing very well for a very long time. I'd also like to thank the faculty for their tireless efforts. This wasn't an easy time for any of us, so hats off to all of you who worked hard to make this program a reality. Finally, I'd like to thank the RPPTL PAC and the Real Property PAC for their generous donation of 4 prizes that will be given away during the program today, consisting of a 2-night stay at the Breakers and registration for the 41st Annual Legislative Update. So, I hope you've grabbed your coffee because the program will be packed with useful information that you won't want to miss a second of. And you certainly don't want to miss your chance to win a trip to the Breakers next year. Thanks and have a great day. The first presentation of the day is the Legislative Potpourri, an overview and random scraps from the Legislative Sausage Factory given by Peter Dunbar. Pete is a legislative consultant and has served in that role since 1998. He's also a writer and has recently published a book titled The Modern Republican in Florida. Get your copy.
Good morning and welcome to this year's Legislative Update. My part of the program will be to acquaint you with the exotic mix of legislative potpourri and the activities from the legislative chambers and the sausage factory, as we occasionally refer to it. By way of background, there were more than 3,500 individual pieces of legislation that were filed for consideration this year. In addition to that, there were another 2,500 approximately separate amendments that were offered during committee and floor deliberations. But in the end, only 210 measures actually made it all the way through the process, and that's 13 more than last year, but still a relatively small number compared to most legislative gatherings. I would observe that only 3 of the bills that actually made it all the way through the process were vetoed by Governor DeSantis, making for a relatively harmonious conclusion to this year's legislative gathering between the 2 legislative chambers and Florida's governor. The first part of your written materials includes all of the legislation that the section was involved with and monitoring during this year's legislative gathering. The major bills that will affect your practice areas will be discussed in significant detail during other parts of the program today. And in Chapter 1, you will find the written summaries along with the chapter law references that appear at the end of the summaries. I would remind you, as I often do, that the chapter law reference is the correct citation to this year's changes until the session laws are incorporated into the statute and the statutes are readopted during the 2021 regular legislative session. Let me also provide this information for you. You will find the full text of each bill, the bill histories, and the staff analysis at these websites that are shown here on the slide. You will also find these same references in your course materials in Chapter 1, and you will find them to be useful. Let me also mention that during breaks in the program, there will be a scroll on the screen that will highlight the members of the legislature that worked with us during the last carried our bills. They helped us with our issues. So if you see someone that you recognize and they are on the fall ballot, I hope that you will remember that they cared about our issues and helped with the legislation in our areas of practice. There are a series of miscellaneous items, some of them rather arcane, that will not be covered in other parts of the program today, and it will be my role to introduce those to you this morning. Let me start with a measure that was actually initiated by the section. It is Senate Bill 1362, now Chapter 2020-99 Laws of Florida, And the substance of this legislation is to repeal current Section 83-561 of the Florida statutes. The effect is that we now default to the federal standard that's found in Public Law 11122. And in the event that this federal law is repealed, the Florida legislation provides that its provisions will become part of the Florida statutes in a new Section 83.5615. The overall effect of the change is to provide a permanent minimum of 90 days of continued occupancy for a tenant following a foreclosure sale. Our next item of interest is found in Committee Substitute for House Bill 625. The current provisions relating to enjoining nuisances are found in Section 60.05 of the Florida statutes. They focus primarily on unlawful activities that occur on the property or in buildings on the property. And under the changes in this year's law, the legislation must provide for written notice. It must be given in writing. It must call for the nuisance to be abated within a 10-day period unless a longer period is agreed upon. And there's now a second notice that's required before formal proceedings can be commenced to enjoin the nuisance. When the notice is given, there is a specific content that is now required. It must include a description of the activities that led to the nuisance, the actions necessary to abate that nuisance, and a statement of the costs that will be assessed if it is not abated. The new law does create a presumption that criminal activities that occur on 2 or more occasions during a 6-month period are now a presumed nuisance, and if formal proceedings are commenced to enjoin the nuisance, the costs of the proceeding become a lien against the property of the person committing the nuisance, and if it is the property owner, the lien for the fees and costs become a lien against the property. Changing subjects for a moment, there are 2 related adoption issues of note from this year's legislation that may be of passing interest to you and your client. The first one is found in Committee Substitute for House Bill 61. And it is an expansion of the financial benefits that are currently provided for state employees under Chapter 409. And that financial assistance is now extended to veterans, to service members, and to OPS state employees. The second change relating to adoptions is found in changes to Chapter 63, and it provides for access to the identity of the birth parents of an adoptee without a court order when the adoptee is 18 years or older, and with the consent of the adopted parents, the adoptee under the age of 18 is entitled to the same information. For those of you that are occasionally engaged in litigation, 2 changes that may be of interest in your work in that regard. The first is Committee Substitute for Senate Bill or House Bill 103. The new law, which took effect on July the 1st of this year, now authorizes proper service on the entity's resident agent, or as authorized by its state of domicile, or through the internet where the corporation accepts service of process. The refusal of an out-of-state corporation, or for that matter, a Florida domicile business, is that the applicant is entitled to compel compliance with the service. The court may treat the failure to comply as indirect criminal contempt, and the fine for such conduct will be not less than $100 nor more than $1,000 per day for a maximum of 60 days. Once you're in the courtroom, you may want to be aware that there are potential changes in your jury pool. Under the provisions of Committee Substitute for Senate Bill 738, full-time students of 18 and 21 may now be excused upon request. This includes students that are attending high school, those in the community college system, attending a state university, or a private post-secondary institution are included as well as those in a Career Service Center program. Let me focus on real property for a minute, and I want to begin with some items that are found in a big bill that otherwise deals with essential state infrastructure. That would be a committee substitute for Senate Bill 7018, now Chapter Law 2020-57, Laws of Florida. Its primary components provide for staging areas on the state's turnpike network during declared, and it also provides for the development of a master plan for electrical charging stations in the state's or along the state's highway network. But for those of you with agricultural clients, there is a modification to the rights of landowners whose property is subject to a conservation easement. And those modifications are found in Section 4 of this big bill near the end. For those that have their property encumbered by a conservation easement, there are these new rights. They are now permitted to negotiate for additional easements across the land to accommodate both public and private linear facilities and related appurtenances, such things as solar farms, utility infrastructure, and other related facilities. In negotiating for these easement rights, the owner is also entitled to be compensated for these additional uses, but the compensation must be based upon the diminution of value in the property that result from these linear facilities and appurtenances. Also, in the real estate arena, there are some ad valorem tax changes that are now in effect, and some changes that are dependent on the pending November elections. Let me address those briefly as I reach my conclusion. First, beginning with the annual session tax package that's found in committee substitute for House Bill 7097. And I will say, because of this year's pandemic, this version of the annual tax package is pared down significantly with amendments that occurred on the final day of the legislative session. But there are two items of note for those of you with multifamily housing or affordable housing clients. First, for ad valorem tax purposes, there is now a defined distinction for multifamily residential housing based upon the size or the number of units on the property. For properties consisting of up to 9 units, they will continue to be defined as multifamily housing properties. And for those properties consisting of 10 or more units, they are now statutorily defined as commercial property. In the affordable housing context, the provisions of the ad valorem tax code have been modified to preserve the status of affordable housing properties in two ways. These modifications permit the classification to remain based upon the tenant's income at the time of occupancy and not as it changes during occupancy. It also permits the classification to remain when the units in the project are vacant. There are other changes to the ad valorem tax code that are found in committee substitute for House Bill 1249. Its provisions extend to the homestead tax exemptions for veterans and their surviving spouses. The exemption is now available for property that's acquired any time between January the 1st and November the 1st of any calendar year. And the homeowners will be entitled to a refund of any taxes that might have been previously paid during the period before the exemption has become officially recognized. In the world of property taxes, there are a couple of maybes for you to consider on Election Day. Both of these measures are tied to pending constitutional amendments, and their implementing legislation is dependent on voter approval in November. The first proposed amendment to the Constitution would include for Save Our Homes benefits to new homesteads. It will increase the portability period from 2 years to 3 years, and it will become effective on January the 1st of this year, or January the 1st of 2021, if the constitutional amendment is approved. The second, or the other amendment, relates to homestead benefits for surviving spouses of disabled veterans. This change will entitle the surviving spouse to retain the benefits of the ad valorem tax discount while continuing to reside in the homestead, and it will also make the benefit transferable to a new homestead. The benefit does expire when the surviving spouse remarries, and this amendment too would take effect on January the 1st if it is approved by in November by the voters. As I conclude, let me leave you once more with the reference to the legislative websites that are an available source of additional information on all of the information you'll receive today. It's also referenced in Chapter 1 of the materials, as I discussed earlier. The sites are in Chapter 1, and they contain a wide range of background material on activities from the 2020 legislative session, ranging from amendments offered and adopted to reports and analysis by legislative staff. With your introduction to this year's potpourri and the scraps from the sausage factory, my time is up. Thank you for your attention. I hope you will enjoy the rest of the program.
Good morning, everyone. Our next speaker is Sean Brown. Sean Brown is the managing attorney in the Tampa office of K. Bender Rembaum. He's board certified in condominium and plan development law, and he's a member of the Condominium and Plan Development Committee, the Real Property Litigation Committee, and the Problem Studies Committee of Reptile. Mr. Brown's going to be speaking on the aftermath of the 2020 legislative session on community associations. Thank you, Mr. Brown.
Good morning. Welcome to the update of the 2020 legislative session and what happened that involved community associations. In other words, wait a minute, we now have to follow that? As we know, one of the most dangerous things in Florida is when the legislature gets together for community associations and starts deciding what they want to do and impose on us. We're going to take a short journey through what the legislature did impose, and we're going to highlight some really interesting things that flew under the radar, and then we will get into those items that didn't pass that we do expect to come back next year, which will dramatically affect how we practice law. One of the first ones that came up and is in your materials was Senate Bill 374. Now, to note, at the time this was pending, we were unsure whether or not this would make it to the governor's desk. It did not ultimately get to the governor's desk, but it got pretty close. So I would call your attention to note what it is, and there will be a renewed push for this. What it did first off was for Chapter 712, for those of you who are real estate practitioners, which is the Marketable Record Title Act, was going to address unlawful discriminatory covenants. As we know, that is a huge topic in today's environment. So what it provided for was that any discriminatory restriction, any title transaction was unlawful, it was unenforceable, it was completely void as a matter of law. If you filed a MARTA preservation notice, it would not preserve the discriminatory restriction. And more importantly, for a community association, which some of you who work in more rural areas might find this if you go back far enough within your title, will notice that these still show up for community associations, homeowner associations. So a parcel owner could request the board to amend out the discriminatory restriction that existed within the covenants, regardless of any amendment threshold that was required. There was also a push to amend how we handle housing discrimination. Parties, as you know, bring civil actions all the time, discrimination, and one of the most common defenses that everybody raises is you failed to exhaust your administrative remedies. However, that was going to be substantially changed. And the only limitations to that now is going to be if a conciliation conference had been agreed to or an administrative law judge had started a hearing. The idea here was to make the Florida Fair Housing Act equivalent to the federal act, mainly because there was a funding component tied to it. The next piece of legislation, again a minor one, but one that you should be aware of, was HB 529. This dealt with association insurance. It amended Section 631.57 of the Florida statutes. And what it did was change the amount of insurance coverage that the Florida Insurance Guarantee Association, or FIGA, had to provide for each condominium unit and association. It changed it from a maximum of $100,000 times the number of units in the condo to $200,000 times the number of units. It's unlikely that you will end up having to deal with this, but be aware of it in case you run into some sort of substantial casualty loss and your insurer lacks the ability to make you whole. The next one we will get into is HB 255, Florida Commission on Human Relations, amending Chapter 760. The first notable one for those of you that do a lot of unique community association work, which is housing for older persons, was it deleted the registration requirements for facilities and communities that were going to claim an exemption for this type of housing. Deleted the related forms, deleted the related fees, deleted the related fines. So you can rest assured now that if you have a community that is a designated housing for older persons, or HOPA as it's called within the industry, you no longer have to comply with all of this stuff. They also amended, and interestingly, the statute of limitations. So if the Commission on Human Rights fails to determine if there's a civil rights violation within 180 days, then the claim becomes subject to a 1-year statute of limitations. I encourage all of you to look at HB 255. All of these pieces of legislation are in your materials. Understand how it's worded, because this, I expect, will be an area of concern and will be a potential trap for many people who practice in this field. Next, we get into one of my favorite pieces of legislation, Senate Bill 140, fireworks. Now, you may wonder what in the world is a fireworks piece of legislation doing talking about community association legislation. As I explained at the beginning, Tallahassee does some interesting things when they all get together. So what we do is we amend Section 791.08 of the Florida statutes. This now defines designated holidays as January the 1st, July the 4th, and December the 31st. Why are we defining certain holidays? As you will find out, it's to ensure the associations do not promulgate rules that restrict the use of fireworks by parcel owners on those designated holidays. Now, the statute is clear that it does not supersede any local government regulations or prohibitions in the Declaration of Covenants. So if you have a declaration that says no fireworks, you're fine, you're not covered. However, if you do not, and most communities do not, and you decide to pass rules, this statute will now preempt those rules. And people will be free on January the 1st, July the 4th, and December the 31st to shoot off fireworks to their heart's delight. Well, one of the items I put in your materials, and I quoted just because I found it absolutely fascinating, was a March 9th, 2020 quote in the Tampa Bay Times by Lauren Book, who sponsored the amendment to the statute. And her justification of the fireworks was, there are neighborhood associations that think they can place rules and disallow individuals from wanting to exercise their patriotic duty to scare birds or fish away from their property by a rule when not in their covenant. I don't know about many of you out there who celebrate and use fireworks on the holidays. I have never once contemplated that the fireworks I'm shooting was designed to scare birds away from my property or fish and exercise of my patriotic duty. But I just found that quote absolutely fascinating, and when that came out, I literally saved it for when I would have to do a legislative update. So I am encouraged to share it with all of you, and you can all read into it what you want. The next one that is a major community association one was SB 476, law enforcement vehicles. Now, a little backstory on this one. Up here in the area where I practice, the Tampa Bay area, there was a news article that came out online, and it talked about a local homeowner association that was prohibiting a law enforcement vehicle from parking within the community. I remember being home that day specifically. For some reason, I was going into the office a little later. I saw that and said, watch, we're going to get legislation because of that battle. Well, lo and behold, it came up really quickly within the legislative session, and it went through really quickly within the legislative session. So what they did was they created 3 new statutory sections in chapters 718, 719, and 720. 718.129, 719.131, and 720.318. What it means is community associations cannot prohibit a law enforcement officer, whether they're an owner, tenant, guest, or even an invitee, from parking their designated assigned law enforcement vehicle in an area where one would have the right to park. I don't know why the association up here felt that they needed to have this challenge with the law enforcement, My experience with these is that anytime you decide to pick a battle between a community association and a law enforcement agency, the law enforcement agency generally wins every single time. But for whatever reason, they decided to pick the fight, ended up on the news, I want to say sometime in August of 2019. And several months later, we have laws dealing specifically with this. So for those of you that deal in community association world and beyond the law enforcement vehicle issue, think carefully when picking and choosing your battles. Do not pick on the law enforcement, especially in today's environment where the Florida legislature is always looking to protect them as best they can. You're going to pick a battle you're not going to be able to win. The next one was Senate Bill 838, business organizations. Now, many of you may wonder, why are business organizations tied to community associations? Well, as we all know, community associations, especially the newer ones, are all nonprofit corporations. And so the business law section of the Florida Bar had an amendment to Chapter 617.0825 dealing with board and advisory committees. So unless the articles or bylaws provide otherwise, the board of directors may create executive committees or other committees of the board. The board may appoint directors or other persons to serve on the committee. Majority of the persons do have to be directors in that context. A committee may have less than a majority of directors if the committee is otherwise authorized by the articles or bylaws, or the committee relates to election, nomination, qualification, or credentialing of directors. So in those instances, the board can have a committee of less than a majority of the directors. A committee member who is not a director does have the same fiduciary obligations as a director, along with the same liability protections. So this is designed that when the board decides to create these executive committees and they want that non-board member who is really active or has that special knowledge and skills that they'd like to have, that person comes in, picks up a fiduciary duty, but also gets the same type of protections as the other board members would in exercising their authority while on the committee. They also now provide for advisory committees. Associations can create as many as they want to, with as many members being non-directors. Advisory committees are deemed not to really be a committee of the board of directors. It may not act on behalf of the board, may not exercise powers of the board, and may not bind the corporation. As the law makes clear, the advisory committee is there solely to advise the board and give them recommendations and nothing else. One thing to note that came through in the statutory revision process here was that for whatever reason, it seems the statutory draft did not go far enough in acknowledging the type of committees that you run into in community associations, and more specifically, Chapter 720 homeowner associations. So these revisions do not pick up fining committees or architectural control committees of community associations. I do expect that we will see revision that will ensure that this oversight is corrected, but be aware of that for the time being. And now I want to get to what I feel is one of the most substantive pieces of legislation that has passed that affects all of us in community association land. It is SB 1392, court jurisdiction. Now, many of you may wonder, what in the world does court jurisdiction have to do with my community association? I encourage you to read this, understand this, as you'll see in the materials and you see in the PowerPoint. The county court to circuit court appellate route is effectively deleted. Everything in county court is now going to end up going straight to your local district court of appeal. There are very limited exceptions to this. Appeals of final administrative orders from basically Code Enforcement Board, and there's some other limited appeals that are referenced in the statute. One thing to be aware of is this statute doesn't take effect till on January 1, 2021. So if you're in the middle of county court litigation right now and you have a final judgment or final order entered and you want to appeal, you will go to county court to circuit court. You will then have to handle your appeal all throughout circuit court, regardless of when the law changes. However, if you're litigating right now and you're going to have that issue, you may want to consider moving your case a little slower, as it's my opinion personally that you're going to get a much stronger level of appellate review on the district court of appeal level. So if you're concerned about the results of the case, you want to take that in. What this does, it effectively eliminates county courts certifying questions to the district courts of appeal. Now, how does this all play into community association? Think about community association, contracts, litigation, collections efforts. Given the recent revision to court jurisdiction on amounts in controversy, as we know, the county court jurisdiction went up to $30,000 and will subsequently move up to $50,000. For, I would say, 85 to 90% of association litigation and collection, you're going to be under those jurisdictional amounts. So now at the outset of the case, contemplate that you're going to have potentially a district court of appeal review of whatever final judgment or order is entered in your county court case. That could be your final judgment of foreclosure. Or think about the battles that community associations always get into with landscaping companies or other vendors. Those amounts generally are a few $1,000s, maybe $10,000 to $15,000. Well, now when you're facing those issues and those contractual claims, you now have to contemplate that whether the association loses or the other side loses, that the appeal will go to the district court of appeal. And as we all know, that's their primary job, to look and solely handle matters from an appellate context. You're going to get a much closer look at it. The courts are going to take it much more seriously. As my experience with circuit court appellate work is, they try to do the best job that they can, but the issues they run into is that's not their primary job. Their primary job is as a trial court. And so an appellate court is effectively a second job for a circuit court judge. Now you're going straight to the district court of appeal. What do you need to do? You need to have a good strategy for your case at the outset. Plan, think where you're going, think of the issues. More importantly, you need to build a very good record. As we know, those of us that do appellate work, you live and die on the record in your case. So many times I've handled these cases and you look at what's in the file, there's not much in the way of pleadings. It's a lot of bare bones, basic, especially in the foreclosure land. Given that many times you may not bring a court reporter to court because your client doesn't want to spend the money, think about now whether you want to have those arguments that you're going to make at the hearing in your pleadings. If for no other reason, then the pleadings will be part of the record, and at least then you have the argument that you made the argument at the trial court level and you preserved it for appellate review. If you fail to consider this, you do run the risk that your foreclosure case that you thought was a slam dunk on summary judgment gets reversed and sent back down because of issues in lack of a record. Now to legislation that did not pass. And for all of you who do community association work, even though this didn't pass, take a look at House Bill 623 in depth. This will come back next year. This legislation has been roughly 2 years in the making. It did not make it through in the 2019 session. It did not make it through in the 2020 session. It will be back for 2021 with the expectation that it most likely will pass in some form way. What is in there that are worth noting? Condominiums, official records, and a checklist for official records. There is a big push legislatively to address the official records issue and mandate a form the association maintains as to what records are in its possession. Be aware of that. The condominium board term limits. We all know the 8-year term that exists in the statute. Was it prospective or was it retroactive? This legislation clarifies that it truly was a prospective piece of legislation. Condominium transfer fees. There is a transfer fee provided in the statute that the association can charge. That fee is being increased. The conflict of interest provision. There's a direct conflict with the conflict of interest provision and another provision of the Act that is getting addressed. Those of you that deal with alternative fuel vehicles and you use 718, 113 when it comes to electric vehicles, there's now a push to expand that for natural gas installation for vehicles. I haven't seen many natural gas vehicles. I'm aware they exist, but there is a push to at least have that provision in there as well. So in addition to providing for charging stations, you may now have to address natural gas lines, fuel tanks, and the like. One of the big ones to me personally coming out of 623 was condominium arbitration. And what this now did was create a opt-in process for those of us who are in association attorneys of whether you want to go down the road of condominium arbitration pursuant to 718-1255, or whether you would rather, instead of going to arbitration, offer pre-suit mediation, and if you did not resolve the matter, mediation, then go straight to court. The system would be set up to be an opt-in. The party filing the action would pick and choose where it is. So one of the main questions that I imagine many of you have watching this is, well, what about recalls and elections? If you stick with the status quo, you could simply stay where you are and you would go forward under arbitration. However, there was the option to provide that you could also go straight to a court of competent jurisdiction to address your election or your recall issue. And that, coupled with the change to court jurisdictions that will take effect in about 5 months, would create the possibility that we could actually have a recall or election dispute at the District Court of Appeal and actually have an appellate decision interpreting that. Those of you that practice on the probate side of the aisle or represent the few condominium co-ops that exist, there was a change to provide that a cooperative unit was an interest in real property for homestead purposes. That is a major issue for those people who practice in probate land. That was in House Bill 623, and we do expect it to return as well. Also within 623, for the one issue that I've been harping on for everybody who's attended any update I've ever done, was HOA rental restrictions. We're all familiar with the condominium rental restrictions that if an association passes an amendment, it only binds those who consent to the amendment and those that purchase after. If you're subject to a different level of rental restriction at the time and you choose not to go along with it, you're under the old scheme, especially as it relates to frequency and duration. That similar style level is coming back into the HOA land. We saw this legislation pop up year after year, and each year it got a little bit further along in the process. This one made it all the way into 623 before it died at the Senate. Given that the HOA rental restriction is a priority of House leadership, those of you that represent homeowner associations want to take a hard look at this provision in 623, understand that it will come back more or less in the same form, highly likely to pass. So if you want to address any rental restrictions in advance, you will have roughly from now until sometime in the spring of next year to address this issue before the legislature will curtail your ability. And finally, HOA election disputes. That was also covered in House Bill 623. We may also see additional items added into what would be a new version of 623 for the 2021 session, dealing with the emergency powers issues that those of us who represent community associations have dealt with. I highly expect that to be a hot button issue when we reach the next legislative session, given the confusion that has emanated from utilizing emergency powers. So be aware that that will also likely come through. And with that, I have nothing further, and that is the end.
Good morning. It's my pleasure to introduce your next speaker, Caddy Huss. Caddy is an estate and trust lawyer with Spivey & Huss, PA, in Sarasota and St. Petersburg, Florida. In addition to serving on a number of section committees, Caddy is also the chair of the estate planning and probate section of the Sarasota County Bar, as well as the vice chair of the Florida Bar's Probate Rules Committee. So without further ado, take it away, Caddy, with some highlights from the 2020 probate bill.
Okay. Well, thank you to the Legislative Committee for having me here today in this very unique situation. For those of you who do not know me, my name is Katie Huss. I'm an estate and trust litigator out of Sarasota and the Tampa Bay area. I'm sad that I'm not seeing you all in person today, but hopefully we'll be able to cover this material from the comfort of your own home and here from the comfort of the Carlton Fields office. So today I'm going to be talking about House Bill 505, which is what I refer to as the probate bill from 2020. This bill was signed into law on June 20th, 2020, and it can now be found in the laws of Florida, Chapter 2020, Section 67, So if you want to pull that up, or you can also look at my materials for the excerpts that I'm going to be talking about today. I'm only going to be addressing a few of the sections of the probate bill. I think there's some other presentations that will be addressing the rest of it. I am going to go through the various committees that worked on these proposed amendments that are now law, and the research that they did, and I've included in my materials the white papers so that if you want additional information or additional color on the topics I'm addressing, please go and look at those white papers, because these subcommittees and the chairs, they put a lot of time and effort into those materials, and I do not want to take credit for them, so please take a look and reach out to them if you have any questions or want to know more. The first section of House Bill 505, now Chapter 2020-67, is the creation of a new statute regarding precious metals, and that's Section 731.1065. This statute addresses coins and bullion and those precious metals that are usually held for collectible value, historical, artistic value, those not used as legal tender for payment. So we're not talking about nickels and dimes and quarters here. We're talking about things that are kept for historical or artistic or collectible value. The section that worked on this, or the committee that worked on this, was a subcommittee out of the Probate Law and Procedure Committee, chaired by Dan Siegel. And what they did is they reviewed the treatment of these precious metals according to Florida law. Interestingly, they found that there was no probate code statute that addressed precious metals, and there was no Florida case law on the topic either. There was a difference of opinion amongst practitioners on how to treat precious metals, or gold and bullion, and whether they could be passed pursuant to a separate writing as tangible personal property. So in order to clarify this confusion, they proposed this new statute, which is now Section 731.1065, and this statute clarifies that precious metals in any tangible form are considered tangible personal property. Like I said, this does not include precious metals used as legal tender for payment. I understand there's a shortage of those coins right now. We're not talking about those. We're talking only about those that are acquired for their historical, artistic, collectible, or investment value. And the statute even says that. The subcommittee intended this law to be clarifying existing law, so it applies retroactively to all written instruments executed before, on, or after July 1st, 2020, and proceedings pending or commenced before, on, or after July 1, 2020 as well, assuming that the disposition of the precious metals has not already been determined by a court. So if you have a question over your precious metals and you have a pending proceeding about how they're going to pass, it might be worth looking into this new section, 731.1065, because it'll tell you how they should be treated. The next section that I'm going to address from House Bill 505 is from Section 3 of the statute, or of the bill, and it's related to the formal notice statute, Section 731.301. Here, the Reptiles Ad Hoc Jurisdiction and Service of Process Committee reviewed a series of cases from the 2nd DCA and the 4th DCA that held that interested persons may be subject to personal jurisdiction through service via formal notice, pursuant to Section 731.301, subsection 2. The committee did a pretty thorough review of these decisions and determined that the result was actually inaccurate. It was never the intent for formal notice to convey personal jurisdiction. Formal notice is not the same as judicial process under the Florida Rules of Civil Procedure. And probate proceedings have always been in rem proceedings. So the court acquires jurisdiction over the decedent's will, if there is one, the decedent's tangible and intangible property, including their coins and bullion, if they have it, and real property located in the state of Florida. formal notice invokes that in rem jurisdiction to the extent of that person receiving notice interest in the estate. It does not invoke personal jurisdiction. So the committee concluded that it was better to preserve the safeguards found in the Florida Rules of Civil Procedure for obtaining personal jurisdiction, and they just amended the statute on formal notice, 731.301, to clarify that formal notice to a person is sufficient notice for the court to exercise its in rem jurisdiction over the person's interest in the estate property or in the decedent's protected homestead. And then, as if there were any other questions to be asked at this point, the committee also added that the court does not acquire personal jurisdiction over a person by service of formal notice. It could not be any clearer. You do not get personal jurisdiction by serving formal notice. The committee also wanted to note that this is a clarification of existing law. So it also applies to all proceedings pending on or before it became law. So if you've served someone to acquire personal jurisdiction via formal notice, you may want to reevaluate that procedure in your case and take a good look at the service of process rules and the Florida Rules of Civil Procedure in order to effectuate that jurisdiction. The last two changes, or the last two sections of House Bill 505 that I'm going to address relate to the Notice of Administration statute. So here we're talking about 733.212. And these changes actually relate to the content of the notice. So the first one is related to the elective share notice. Here, the Probate Law and Procedure Subcommittee, chaired by Jeff Goethe and Greer Presley, reviewed the elective share statutes, and in particular, the right of a surviving spouse to request an extension of time to make an election. And what they determined was that the notice of administration was actually insufficient because it does not notify a surviving spouse of his or her right to petition the court for an extension of time to make an election for good cause shown, as allowed under Section 732.2135, subsection 2. They felt that the notice itself was insufficient to provide the surviving spouse with a notice of their rights to do this, and therefore proposed a change to subsection 2E of 733.212 that notes that unless an extension is granted pursuant to section 732.2135 subsection 2, an election must be made in the time according to this statute. So now a surviving spouse is on notice of his or her option to request an extension of time to make an election for an elective share, or be barred by the timelines in the Notice of Administration statute, the 6 months or the 2 years, depending on the notice received. So at the end of the day, they think that this change makes it just a little bit more clear and the notice a little bit more sufficient for a surviving spouse to be aware of their rights to petition the court for an extension of time to make an election. Now, the last change is found in Section 5 of House Bill 505, or Chapter 2020-67, and this relates to the Pasquale case. And for any of you who have attended reptile meetings over the last several years, I am certain that you have heard the name Pasquale. The Probate and Trust Litigation Subcommittee, chaired by Sean Leibowitz, looked into this 4th District opinion in Pasquale versus Loving. And for those nerds out there who might want to read this decision, it's found at 82 Southern 2nd, 1205. It's a 2012 case from the 4th District. Here, this is a very convoluted case, but at the end of the day, one of the things that the court determined is that when a will incorporates a trust by reference, both the will and the trust must be timely challenged. The subcommittee had some concerns about this holding because of the different statute of limitations that apply to challenge a will versus challenging a trust. So if you are challenging a will, you may have 20 days to respond to a petition for administration or 3 months to a notice of administration. But on the other hand, if you're challenging a trust, you may have anywhere from 6 months to respond to a notice of a trust, to challenge a trust, all the way up to 4 years. So the subcommittee was concerned that there could be situations where a person, a beneficiary, has timely challenged a trust, but has not challenged the will that incorporates that trust by reference, and therefore might waive their rights to challenge the documents. They wanted to provide some level of notice to these beneficiaries of those rights and that potential waiver. So what they did was add a subsection to the notice of administration that requires this notice. And it states in subsection 733.212, subsection 2F, that under certain circumstances and by failing to contest the will, the recipient of the notice of administration may be waiving his or her right to contest the validity of a trust or other writing incorporated by reference into a will. So now at least the recipient is on notice. There's some red flags waving that they may need to consider challenging this will if it incorporates a trust by reference that they have issues with. At the end of the day, these statutes have affected some of the probate rules as well. And so I have a few minutes, so I'll just mention that the probate rules are also being updated to reflect these new requirements in the Notice of Administration statute, particularly the Pasquale fix. I believe that's Rule 5.240, and also a note in the formal notice rule just to further clarify that formal notice does not convey in personam jurisdiction, but only in rem jurisdiction. So at the end of the day, if you're preparing a notice of administration, if you are serving someone via formal notice, or if you've encountered precious metals in your estate, I would urge you to look at House Bill 505 and Chapter 2020-67, because these things all affect your potential cases. And again, thank you to all the subcommittees that did all this hard work in drafting this legislation and the white papers that correspond with them. I really appreciate it. You made my job here very easy today. And thank you again to the Legislative Committee, and I am looking forward to seeing you all in person very soon. Thanks so much.
Hello. Your next presenter will be Susan Spurgeon. Susan is a shareholder with Pennington, PA in Tampa. Susan serves as a co-vice chair of the Problem Studies Committee, is a long-standing member on the Eminent Domain Committee, and is a member of our Executive Council. Susan will now present Now Boarding in Group 1, All Peacocks, Hedgehogs, Squirrels, and Bunnies, Emotional Support Animal Protection under Senate Bill 1084.
Good morning. My name is Susan Spurgeon, and I'm a co-vice chair of the Problem Study Committee and a shareholder at the Pennington Law Firm. This morning, we're going to learn about Senate Bill 1084, which was adopted by the Florida legislature this year. It prohibits housing discrimination against a person with a disability who needs an emotional support animal. A sight-impaired person who needs a guide dog. A hearing-impaired person who needs someone to alert them to sounds, or a combat veteran who looks into the soulful eyes of their support dog and finds the reassurance that the battle has stopped. No one is shooting. These are obvious examples of a genuine need. On the other hand, when we discuss emotional support animals, there's a tendency to look at the more extreme examples and to poke a little fun. As we speak today, I never want you all to mistake a lighthearted approach as belittling those whose well-being depends on their emotional support animals. My constitutional law professor, Georgiana Stoplow, taught me an important truism of freedom. The more freedom we give our neighbors, the less we have ourselves. Permitting emotional support animals is a balancing act. When one resident has allergies or a paralyzing fear of dogs, we must balance the needs when we give our neighbor the freedom to have an emotional support animal. With those two principles in mind, respect for those who need the animals and a respect for those whose freedoms are affected by them, then come on, Group 1, let's get on board and bring your hedgehogs and your bunnies. Sorry, no peacocks and never any snakes, but let's go on board and learn about this legislation. When your condominium association thought it would prohibit large dogs, it now may have to accept a miniature horse in the building as an emotional support animal. Well, not really. Under the federal guidance, persons who request to keep a barnyard animal face a substantial burden to show the need for this particular type of emotional support animal. In 2020, the Florida legislature adopted Senate Bill 1084, which creates Florida Statute Section 760.27. This takes effect July 1st, 2020. It defines what an emotional support animal is, and it is the heart of the legislation. An emotional support animal is an animal that does not require training to do work, perform tasks, provide assistance, or provide therapeutic emotional support by virtue of its presence, and which alleviates one or more identified symptoms or effects of a person's disability. All of the animals that you see on the screen, and many more, may qualify as emotional support animals. But the federal law also provides protection, and Florida's new law provides protection only to the extent required by federal law, rule, or regulation. Further, case law has held that the federal law preempts the state or local law, which purports to require or permit any action that would be discriminatory housing practice. So it's not clear how the Florida law will grant additional protections. It is clear that the Florida law cannot be less protective than the federal law, and so we look to the federal law and the federal guidance documents for direction in Florida. There are three main federal acts that we look at for service animals. The Fair Housing Act, under which emotional support animals are protected, the Americans with Disabilities Act, which is most commonly used to protect service animals, animals which require training, and guide dogs for the blind are the most common example, and the Air Carrier Access Act. The Air Carrier Act has very different rules than the housing acts. So, can you bring your peacock on? Well, the airlines are never required to accept snakes, no snakes on the plane, and me not screaming during the flight, no reptiles, ferrets, rodents, sugar gliders, or spiders. Peacocks? No. In 2018, Dexter the peacock was barred by United Airlines for many reasons, including size and weight. Hedgehogs? Maybe. Themby the hedgehog was spotted on the tarmac at JFK while traveling with its owner. Themby was a registered service animal, and though Delta doesn't normally allow hedgehogs in the cabin, they made an exception. Squirrels? No. Squirrels are rodents, and they're barred by the airlines. Bunnies? Yes. In 2018, Coco the bunny took a flight from San Francisco, California to Japan. So if you want to fly with your squirrel, maybe you have its ears bobbed and its tail bobbed. No, just kidding. So what is your duty if a resident requests an emotional support or a service animal? Well, some physical and mental impairments are readily observable. A sight-impaired person, for instance. And if the impairment is readily observable, you should then determine whether there's a connection between the disability and the animal. Sight-impaired person needs a guide dog, the accommodation is nearly automatic. But other impairments are not observable, and frequently those that form the basis for an emotional support animal may not be observable. In that case, the the disabled person has a duty to request a reasonable accommodation, and if they do, the housing provider may request information regarding both the disability and the disability-related need for the animal. It is the requester that has the burden to show that they have a disability, and information to show a disability may include information from a healthcare professional, a determination of disability from a federal, state, or local government agency, receipt of disability benefits or services, and eligibility for housing assistance related to their disability. The housing providers, however, may not second guess or request the diagnosis. Your property manager cannot require disclosures of details about the diagnosis, the severity of the disability, or medical records. Once the requester has shown that they have a disability, they must provide information that reasonably supports that their animal does work, performs tasks, provides assistance, or provides therapeutic emotional support with respect to the individual's disability. If you Google emotional support animal, the first 4 results that you get are advertisements to make your pet an ESA in 24 hours. Don't want to pay that pet deposit? Sign here and we will certify your pet. So what do you tell your client if your property manager is presented with one of these internet certifications? Under the Fair Housing Act, a housing provider may request reliable documentation when an individual requesting a reasonable accommodation comes forward. Under the federal guidance, documentation from the internet is not, by itself, sufficient to reliably establish that an individual has a non-observable disability or disability-related need for an assistance animal. And yet, by contrast, many legitimate licensed healthcare professionals deliver services remotely, including over the internet. During this pandemic, I know I have had a Zoom visit with my doctor, and I'm sure many of you have as well. So how do you tell the difference? Well, a note from a person's healthcare professional that confirms the disability and the need for the animal, where the provider has personal knowledge of the individual, it is a reliable form of documentation. This is especially true if the provider has an ongoing and pre-existing relationship with the requestor and is not simply there to provide the certification. Now you've got a known disability or a certified disability and a certified need for an animal. Do you have to let this particular animal into your building? Well, if the animal is a small domesticated animal that's traditionally kept in the home, like a dog, cat, small bird, rabbit, hamster, gerbil, other small rodent, fish, or turtle, then the answer is probably yes. On the other hand, if the animal is a reptile, no snakes ever, barnyard animals, monkeys, kangaroo, or a non-domesticated animal, the answer is not automatically yes. If the animal is unique, then the requester has a substantial burden of demonstrating a disability-related therapeutic need for that specific type of animal or that specific animal. The most common example is the need for a monkey who has opposable thumbs and can use its hands as opposed to using a dog which has only paws and does not have opposable thumbs. So you'll have to keep that in mind when you get the request. And you must also balance the needs of the residents. What do you do in your no pets building where one tenant has medically documented severe allergies to animals and another requests a support animal? In Iowa, the landlord's waiver of the apartment building's no pet policy to allow a new tenant's emotional support dog was ruled to not be a reasonable accommodation. Because of the existing tenant's medically documented severe allergies and the fact that the court noted that the tenant with allergies was first in time to the request for the emotional support animal, the accommodation was overruled. But keep in mind, these issues are case by case. While the Iowa court mentions first in time as one factor, we don't know how significant a factor it will continue to be. And also, because these laws are fairly new, you may have to reason from other disability cases. For instance, in Michigan, a unit owner's request for a smoking ban due to her asthma was not a reasonable accommodation to the association's policy of allowing smoking in the building, since it would require a fundamental change and not a moderate adjustment of policy, and would intrude on the rights of third parties. The federal guidance also advises that the requested accommodation is not required under the Fair Housing Act, where it would be a direct threat to the health or safety of other individuals or would result in substantial physical damage to the property of others. So if one of your residents has an emotional support animal and that animal is tearing up all of the furniture in the common areas, you may well be able to not allow that as a reasonable accommodation. If you've ever litigated in federal court, this one will not surprise you. Federal judges think that litigants who are sworn enemies have been involved in multiple years of multi-hundreds of thousands of dollars worth of litigation can be ordered to hold hands and sing Kumbaya. And so it comes as no surprise that before denying accommodation request, the housing provider should engage in good faith dialogue with the requester in an interactive process. You should try to work it out. This is an area that's new and evolving. The decisions are case by case. But to learn more, the reptile section is presenting a webinar, Fair Housing and the Fake ESA, on September 9th, 2020, from noon until 12:50. I suggest that you turn in and get even more information about emotional support animals. And now I'd like to thank Doug Christie and Joanne Nesta Burnett of the Becker firm, who helped with content, and to my law clerk, Logan Egan, who was my PowerPoint ranger. Thank you.
Our next presenter is Jenna Rubin. Jenna practices in Boca Raton and currently serves as Vice Chair of the Trust Law Committee, the Ad Hoc Committee on Electronic Wills, and the Elective Share Review Committee. Jenna's presentation will be on virtual estate planning, how to use the new eWills technology in your practice.
Hello. Today I'm going to be presenting on how to utilize the new electronic wills and remote notarization statute in your everyday practice. I think this topic is particularly relevant today given everything that's going on in the world, as I know a lot of my clients and peers have been asking whether they can sign documents remotely, and most people are either working from home or working from a limited office capacity, and really clients don't want to come into the office and have to sit in a room with two witnesses and a notary when they want to sign their estate planning documents. So this statute came out at the perfect time, and as many of you know, the statute became effective on January 1st, 2020, with the exception that the statute became effective for estate planning documents on July 1st, 2020. So I was asked to do this presentation a little bit before July 1st of this year, and I thought, perfect timing. Once July 1st rolls around, I'll log onto my computer, I'll try to find a remote notary and witnessing program that is doing estate planning documents, and I'll sign up and I'll do almost, my own set of estate planning documents from start to finish on one of these platforms, so then I could come and speak to you guys today about how it worked, at least for me in practice. So July 1st comes and it goes, and I get on my computer, and I'm not really seeing a lot of software providers that are providing this technology that we thought they would all be providing, especially given the rush and the push we had to get this legislation passed here in Florida. So I thought, I'll give it a few weeks. A few weeks go by, I get back on my computer, still not seeing a lot of remote online notaries who are providing services related to estate planning. So I gave it a little bit more this morning, even before I came to do this presentation. I looked again, and they're still not really providing these services. So what I learned is that while the remote notarization component of our statute is in effect, is in full force, and people are really utilizing it, especially now, on the estate planning side, things are a little bit more tricky. And I'll explain to you why they've become a little bit more tricky, but it's because most of the service providers have not really begun selling this essentially as a product where they're following the statute from beginning to end. And there are a lot of traps in the statute that make it dangerous for just an online notary to attempt to notarize and have remote witnesses on estate planning documents without having a remote online service provider doing it the way the statute prescribes. So I'll start my presentation today by walking you through from beginning to end how an online notarization takes place. And then, because I can't show you an example of a remote estate planning signing because I couldn't find anyone that was really doing them, I'll walk you through what the statute requires from a technological perspective and explain to you how we think this will play out and where some of the pitfalls are, so that if you have clients who are coming to you and saying they want to use this software and they want to take advantage of the new legislation, you can explain to them what the pros and cons of doing so actually are. So I'm going to start with online notarization. And online notarization is actually extremely simple and user-friendly. I went on and tried to do my own documents, and I found that the software and the programs being used right now are very user-friendly. Even the least tech-savvy clients should be able to utilize these programs and get documents done remotely without having to come into your office and meet with a notary or go to a bank or wherever they may have gone in the past. So it's a simple procedure. They utilize a program either through their computer, their iPhone, anything with a camera. They're going to upload the document that needs to be notarized. They're going to use the software to be paired with a program that does identity proofing and credential analysis, which I'll explain in detail, but basically tries to figure out whether the person is who they say they are. Then they'll connect with an online notary, actually go through the process of electronically signing the document, and then ultimately they'll end up with a recording of the whole thing from start to finish that serves as their actual online notarized document. It's been very simple. The clients are using it. I find it's especially effective right now where there's nursing homes that are not allowing visitors. If you have a client in one of those facilities, it's a great way to get documents done. I've even done it myself for documents for my children from the comfort of my own home. So very user-friendly. I'll explain how it works, and you'll see how simple it actually is in practice. Now, many attorneys have asked whether they or someone in their office should become an online notary and begin providing these services to their clients themselves rather than going to a service provider and giving them the fee. So to become an online notary, you have to already be authorized to act as a traditional Florida notary public. You'll take a 2-hour training course. You'll pay a $10 fee. You'll need to identify the remote online notary, or RON, as you'll see on the screen, service provider. That's the acronym that's used throughout the statute and in the lingo talking about these programs. You'll need a $25,000 bond, and you'll need to be covered for up to $25,000 errors and omissions liability policy. Once you are registered and become a notary public, you have to understand what an online notary public can do. And essentially, an online notary public can actually do anything that a traditional notary public can do except solemnize a marriage. Now, that actually becomes relevant today in our world of Zoom weddings and people not wanting to gather and trying to socially distance. So while you can have a Zoom wedding and you can have all your friends and family there on the screen, the notary does actually still need to be in person. But that's the only limitation on what an online notary can do, other than the limitations that I'll speak about later in this program for electronic estate planning documents. The online notary needs to be located in Florida, but both the principal and the witnesses do not have to be in Florida. They can be anywhere else. Florida law will govern an online notary who's located in Florida, and the statute provides that an online notary can charge up to $25 per online notarization. So now that we've got the basics of how to become a notary and what an online notary can do, let's walk through an actual notarization process so you can see how simple and user-friendly the process actually is. The software will first try to ascertain whether or not the principal is the person they say they are, and it involves a two-step process. There is a credential analysis and identity proofing, and together, those are the methods by which the online notary determines whether the person is who they say they are. Traditionally, they would either know the person or take a look at their driver's license in the office or bank, wherever they were notarizing. This is a little bit more complicated simply because there's just so much opportunity for fraud. And while I say it's complicated in that there are certain requirements that need to be done and fulfilled. It's not that complicated for the client who's actually going through the procedure. So the first part of this is the credential analysis. And this is when the principal is going to remotely present their government-issued identification. So that's typically a driver's license. And as you can see in the photo, they're simply holding up that driver's license to their iPhone camera or their laptop camera so that the notary platform is able to view it and take a image of it and run it through their software, which verifies the authenticity of that credential. Assuming that the software concludes that this is a proper identification and that's a valid ID, you move on to the second stage of determining whether the person is who they say they are, which is known as identity proofing. Identity proofing is where the online notary uses an online service in which a third party affirms the identity of the principal through what is typically called knowledge-based authentication. So the way this is done is the software will ask 5 or more questions of the person to verify their identity. So for example, you'll see on the screen one such question. They'll say, which of the following addresses is associated with you? And they'll have 4 make-believe addresses, and the 5th one could be the address you used when you lived in the sorority house your sophomore year of college. And you might not really remember it, but you might think you do, and hopefully you get it correct, because these tend to be pretty confusing. But you do have to get 80% of the questions correct in order to pass this phase of the identity proofing. So you'll go through 5 such questions. Every question will have 5 choices, and you'll have 2 minutes per question to answer. If you get 80% correct, you can move on to the online notarization. And if you fail the test, you'll get 1 extra opportunity to prove who your identity to the online notary platform. Something interesting that I just learned about in talking to people who are using these softwares is that some of the software providers are actually doing this in a 2-step process. So what they're doing is they're having you sign up on their platform, do the credential analysis, do the identity proofing, and assume you pass both parts of that, you'll get either an ID or a password or maybe a link emailed to you and an appointment set up for a later time with the online notary. So there's part 1 where you're proving who you are who you say you are, and part 2, which is the actual remote online notarization. Now, this seems like it could cause problems for security reasons because of the possibility of somebody intercepting that code. However, based on the statute as it's written today, it is an option available to these providers, so we're seeing some of them doing that. So I would just caution your clients to be aware of that, to be protective of the information they get, make sure they don't share that password with anyone so that someone else can't use their online notarization to say they're that person and sign some other document that they don't want being signed. Assuming you've passed these 2 steps and you've either logged on to the link they provided you or just continued to click through the process, at some point you will be paired with an online notary, and the principal and any witnesses if necessary and the online notary will all be joined together in the online notarization into an audio-video recording. So you'll have an audio-video recording. It's going to look a lot like maybe one of the Zoom calls you've been doing with your friends or meetings with your clients where you see the different faces around the screen and a document presented on the screen. And there are requirements in the statute for the contents of that recording. So the online notary is required to make sure that the recording contains all of the following. It has to contain the appearance by the principal and any witnesses before the online notary public. It has to have a confirmation of the identity of the principal and any witnesses, a general description or identification of the records to be signed, a recitation by the online notary public of information sufficient to identify the notarial act, a declaration by the principal that his or her signature is on the record is being knowingly and voluntarily made, and all of the action and spoken words of the principal, notary public, and the witnesses during the entire online notarization, including the signing of any records before the online notary public, have to be part of that recording. The recording is required to be maintained for at least 10 years. And with that, once you've participated in the signing, you have everybody there, everyone on the recording, the complete package will be saved together as one recording, and that will be your file that is your online notarized document. And that will be the same as having a piece of paper that was notarized with a notary stamp that we're used to. When it comes to estate planning documents, this procedure is just part of the procedure. So there are additional safeguards in place because we want our estate planning documents to be done in a way that is a little bit more formal and protective of our people signing estate planning documents. So there's additional procedures in place that I will go through, but again, some of or not all of these are not being implemented at this time here in Florida. As a threshold matter, there are certain documents that can and cannot be signed electronically in Florida using the new legislation. So wills, trusts with testamentary aspects, healthcare advance directives, waivers of spousal rights, and powers of attorney are all documents which may be done electronically. And I say may because there's a caveat to that. Certain documents signed by vulnerable adults, which is a defined term that I'll go into in some detail, cannot be signed with remote witnesses. They can only have physically present witnesses in order for those documents to be valid. So a will signed by a vulnerable adult with remote witnesses will not be a valid document. Note that it's void, not voidable, which is a harsh result, and we can talk a little bit about that more as I get into the vulnerable adult question. The other documents that can't be done with remote witnesses are the powers of attorney with superpowers. So these are the estate planning superpowers that we viewed as important enough to require the principal in a traditional setting to initial each of these superpowers if they want to grant that authority to their agent. And these are the things like the power to create an inter vivos trust, to amend or revoke a trust created by the principal, to make gifts, to change rights of survivorship, to change beneficiary designations, to waive rights to annuities, or to disclaim property. Again, these used to require or still do require when you're doing them in the office a signature or initialing next to each of these powers. And when you're doing an online remote document, those need to have witnesses physically present. So again, documents executed by vulnerable adults and powers of attorney with superpowers need witnesses to be there in person. Now, because of the very harsh result that a document executed by a vulnerable adult is void, it's worth spending some time understanding both what a vulnerable adult is and how the technology is used to determine whether or not somebody is a vulnerable adult, because that's where your clients are really going to get tripped up and may think they've done an online document that is effective and really is not an effective estate planning document. So let's first focus on just simply the definition of what is a vulnerable adult. The statutes define a vulnerable adult as a person 18 years of age or older whose ability to perform the normal activities of daily living or to provide for his or her own care or protection is impaired due to a mental, emotional, sensory, long-term physical or developmental disability or dysfunction, or brain damage, or the infirmities of aging. And I think it's so important to really focus on that definition, read it again, understand it, because I believe that this is a very complicated definition that will result in so many documents that people think are valid being not valid. And that's because arguably, I think an estate and trust litigator can find a way to pigeonhole pretty much any adult who's signing an estate planning document online into one of these definitions. Until we have a thorough body of case law defining truly what is a vulnerable adult, this definition is incredibly broad. The infirmities of aging could cover pretty much any client over a certain age, and somebody with a sensory disability is being considered a vulnerable adult, even though that would have no impact perhaps on their ability to understand what they're signing and perform the, online notarization and signing of the documents. So this is a dangerous definition that really precludes the effectiveness of this statute. Because it's so important to identify the vulnerable adults for purposes of moving forward with signing with remote witnesses, the statute first requires the remote online notary service provider to require the principal to answer certain questions prior to facilitating the remote witnessing. And we're envisioning these questions being some sort of pop-up on the screen or like a click-through that you would just simply see the questions, answer them, and move along quickly before you can get into the meat of the matter, which is the actual execution of the document. So the statute requires the RON service provider to ask the testator or the person signing the documents these questions, and they have to answer yes or no to all three questions. Are you under the influence of any drug or alcohol today that impairs your ability to make decisions? Do you have a physical or mental condition or long-term disability that impairs your ability to perform the normal activities of daily living? And finally, do you require assistance with daily care? Now, if you look at these questions, and then I'm going to flip back to the definition of a vulnerable adult, what you'll notice is these are not the same. The questions don't exactly tie in to the definition of a vulnerable adult in the statute. So I think there's a lot of risk here that you're going to have a client who answers no to all of these questions and then feels pretty good about moving forward when in fact they're not realizing that maybe something that's not being asked here could qualify them as a vulnerable adult, and therefore the documents they're signing are about to be invalid. So these questions, I think, are a little misleading, and especially the fact that the service provider is going to be the one asking the questions instead of the online notary themselves make it even more problematic. If the principal answers any of these questions in the affirmative, the RON service provider should not let the principal proceed unless witnesses are physically present with the principal. So again, they're supposed to sort of kick them off the platform if they don't have witnesses physically present, but I'm not sure in practice how exactly that's going to work, particularly if the person then just clicks through and says one thing but knows that they're not telling the truth. And I'll note that the important thing here is that it has to be physically present witnesses. The notary can still be an online notary. You just have to have witnesses in the room present if you answer any of these questions with a yes. Now, the legislation recognizes that a lot of people are either going to move too quickly through those questions or they're not going to understand the purpose of answering those questions. So in order to avoid people slipping through the cracks and again continuing forward to use the platforms, even if they are a vulnerable adult, the legislation also requires this consumer protection warning to be placed on the screen before the principal continues. So this says, note, if you are a vulnerable adult, as defined in 415.102 of the Florida statutes, the documents you are about to sign are not valid if witnessed by means of audio-video communication technology. If you suspect you may be a vulnerable adult, you should have witnesses physically present with you before signing. Now, this warning is problematic for several reasons. The first one being nobody's going to read it. It's going to pop up on the screen, you're going to say okay, and you're going to move on. But it's also problematic because the definition of vulnerable adult is tied to a statute that's not in front of the person who's answering the question. So your average layperson is not even going to know what a vulnerable adult means, and they're just going to click through and think that's not me, this doesn't apply to me. Great, but I'm moving on because I want to do this today, and I've already made the decision that I'm using this platform to sign my will today and get this over with. And there's so many reasons why someone who is a vulnerable adult might not identify. They might be embarrassed. They might not self-identify as someone who needs help. Perhaps their disability is something that has nothing to do with their ability to understand a will, and therefore they just don't think this applies to them. Or there's going to be people who know full well that they might satisfy the definition of a vulnerable adult, but maybe they don't care because they're going on a trip in the morning and really want to get the estate planning documents done. So they're just going to continue to click through these things and move forward with the software. Now, this is where we're beginning to see some problems in practice. While an online notary might know that the legislation requires this warning, the RON service provider may not have actually added this consumer protection notice to their platform because they're not actually selling in the business of selling and doing electronic estate planning documents. So your traditional online notary is able to legally notarize a estate planning document online with remote witnesses, but the platform, because they have decided at this point not to start using taking advantage of electronic wills and selling that as a product to their clients, might not have this built in. So the statute says it's the RON service provider that has to make this warning to the user. And if you have an online notary who knows that and they read this warning to the person, it might not be effective. So there's another problem there with the statute that really needs to be worked out before people can feel truly comfortable executing these documents online. There's been some people who believe that this automatic invalidation of the documents, if they're done by a vulnerable adult with remote witnesses, is a harsh result. But I'd remind you that Florida law has always stuck to strict wills formalities, and this is not something new. We don't allow, mistakes and reformation for execution errors, so this would just be in line with sort of that idea, but for the fact that the definition of vulnerable adult is so problematic. Assuming you've clicked through all the questions and the consumer protection warning, then once you're on the online platform and you're paired with your online notary and your remote witnesses, the principal will be asked to verbally answer the following questions, which are used to make a video record of the principal's capacity. So the online notary will actually ask the principal the following questions. Are you currently married? If so, name your spouse. Please state the names of anyone who assisted you in accessing this video conference today. Please state the names of anyone who assisted you in preparing the documents you are signing today. Where are you located and who is in the room with you? Now here, an incorrect document will not invalidate the document, but will be allowed to be introduced as evidence of the principal's capacity. When you have these questions being asked, it is beneficial because the goal here is a good one. The goal is to make sure that the testator is mentally competent and not subject to undue influence, and we want to protect the testator and have documents that are exactly what the testator intended. But a lot of the same problems that arise when we talk about whether or not to videotape our will execution ceremonies in our office come up here. Some people might just not look great on camera, whether because of age, infirmity, or just the way they present themselves, hold themselves. You always have the client who makes a joke that falls flat. I have a colleague who has an elderly client who is sharp as a tack, knows what she wants, yet every time she comes in, she makes the same joke that she doesn't even know what she's signing. And so if you've got that elderly client making those kinds of jokes on camera, there's nothing you can do. You've got this evidentiary record, and it's going to be part of the record that is forever tied to those estate planning documents. So you have to be aware of that. And when you have a client that asks you whether or not they should use these platforms, keep that in mind, how they're going to present themselves on video, because that video record is part of the will. Once these questions have been asked, at that point, it'll be similar to an online notarization where the document is brought up on screen and the electronic signature is placed on the document and the will or other estate planning document is executed. I'll note that an online notary is under the same ethical obligations as a traditional notary. So a notary public may not notarize a signature on a document if it appears that the person is mentally incapable of understanding the nature and effect of the document at the time of notarization. Nothing in our new legislation changes that ethical standard that all notaries act under. In fact, this legislation explicitly directs that the online notary should consider the responses to these questions in carrying out his or her notarial duties. So they're going to ask these questions, and then they're required actually to affirmatively think about the responses they got and think about whether they're comfortable moving forward. So it's a little bit more of a burden on the notary. So if you're thinking about whether or not you or someone in your office wants to act as an online notary here, it's just something to keep in mind. It's not intended to change the standard by which the notary acts, but when you're asking these questions that you may not have asked in the office, it's definitely a different scenario. Assuming they do proceed, it's again going to look a lot like the online notarizations, which we already discussed. So again, I think it'll be extremely interesting to see what these platforms look like if and when they finally come to fruition and become more popular and really implement the procedures that are required in the statute for the technology. I think for now, we'll have to continue wearing our hazmat suits and doing parking lot will signings for the near future. But someday, maybe this technology, the kinks will be worked out and we'll see a lot more electronic wills and estate planning documents, just like we're seeing more online notarizations. Thank you.
I am pleased to introduce Jason Ellison. He is a business and real estate litigation attorney and a partner with Ellison and Lazenby PLLC in St. Pete. Jason is an active member of the Repsol Executive Council and is a vice chair of the Real Property Finance and Lending Committee and a vice chair of Action Line. I had the honor of co-presenting a webinar with Jason a few years back. That was actually his first seminar presentation. He's a veteran by now, so be prepared to learn what you need to know as Jason presents on the somewhat uniform Commercial Real Estate Receivership Act.
Hello, my name is Jason Ellison. I'm a commercial and real estate litigator from St. Petersburg, Florida. Today we're going to talk about the Uniform Commercial Real Estate Receivership Act, also known as Florida Statute 714, brand new this year. House Bill 783 unanimously passed both houses of the Florida legislature and became effective July 1st of 2020, so this law is already effective. The bill is an adaptation of the uniform law, which was drafted by the National Conference of Commissioners on Uniform State Laws. Interestingly, 714.26 has a provision to promote the uniformity among states that have enacted a similar law. That's the benefit of uniform laws, of course, is that we're not the first to have it, we won't be the last to enact it, and so case law and other law that interprets a similar law from another state, say Georgia or another state that has enacted this particular law, will be effective or at least persuasive in analyzing this particular law. Florida, of course, has a long established history and precedent for the appointment of receivers in real property litigation. The authority for court-appointed receivers typically has come from two sources. The first is contract, which in many instances is a mortgage, and of course the second is Florida's common law. The directives for the court and the receiver have historically always been governed by Florida case law. Of course, for a practitioner that has never had a receiver appointed or doesn't know how to appoint a receiver, it becomes a little difficult to track down all of the various laws and how the laws are applied when there is no statute. So this law codifies a lot of those case law and common law concepts into statute. We're going to talk about two major umbrella issues today, the significant legal issues in the Act that are, for the most part, already Florida law, and then secondarily, significant legal issues in the Act that are brand new to Florida law. So under existing Florida law, you have the right or the ability to appoint a receiver in commercial real estate litigation cases. This is not new, but this is now codified into statute. Typically, notice is required before you're going to appoint a receiver. You have to provide all parties, and especially the defendant, with notice that they're getting ready to lose the possessory rights of their commercial real estate. However, notice is not absolute. There's an exception to notice, and this exception to notice has existed in case law. But you must comply with and satisfy the injunction standard. Same injunction standard that you would find in Rule 1.610, the Florida Rules of Civil Procedure, have typically been applicable to commercial real estate receiverships. Now this has been codified into statute, taken directly from 1.610 and case law. Both De Silva and Dixie Music Company are provided in your materials, but you must provide a verified pleading or affidavit. There must be immediate and irreparable injury, and there must be a certification in writing of all attempts to provide notice to the defendant or reasons why the notice should not be required. And just like an injunction without notice, the only thing that the court is able to consider is the affidavit or the verified pleading, nothing else. You can't have a unilateral evidentiary hearing and put on 5 witnesses for the court. The only thing that the court is allowed to consider is the affidavit or the verified pleading. The injunction must be endorsed with the date and time of entry. Such it is with the order appointing receiver without notice. It must be filed with the clerk's office. It must specifically define the injury, stating the findings by the court as to why the injury may be irreparable, and it must give reasons why the order was granted without notice if no notice was in fact provided. So when can a receiver be appointed? Well, just as under prior Florida law, a receiver can be appointed before judgment or after judgment. But now we're going to put this into the statute. This is 71406. Before judgment, you need to establish waste, loss, substantial diminution in value, dissipation, or impairment. That was under the case law that was provided. And the case law is still going to be very important towards this analysis. The statute doesn't necessarily define, there's a lot of definitions in the statute, but it doesn't necessarily define every single one of these issues and instances. So to the extent that case law will tell us or describe to us what waste happens to be, for instance, that still can help a court determine what it is that is going to be grounds for the appointment of a receiver. Somewhat new, alternatively, a plaintiff can demonstrate that the property has been or is about to be the subject of a voidable transaction. This would be a fraudulent transfer, for instance, something that the court would ultimately have to set aside were the case to go forward. So that may be grounds for the appointment of a receiver. In essence, before judgment, the goal has typically been preservation of the property and the status quo. That changes a little bit with the new statute, which we'll get into in just a bit. After judgment, uniquely enough, you do have the ability for a post-judgment appointment of a receiver. Think about carrying the judgment into effect, a partition action, maybe a complex foreclosure action, or how about a multi-unit foreclosure? I once had a commercial foreclosure on 60 condominium units. This might be a perfect opportunity to utilize this statute for post-judgment appointment of a commercial receiver to sell those individual units one at a time for highest and best value instead of the fire sale or courthouse step sale. All right, the rights, powers, and duties. Let's first talk about the grounds. Again, we talked about waste. We talked about we hadn't talked about. Let's talk about the mortgagor has agreed in the loan documents. Typically, and as you can see here with this case, this is not dispositive of the issue. Even if the mortgage says you're entitled to the appointment of a receiver, that doesn't guarantee you the appointment of a receiver. But it is the statutory ground that the court should consider. Insufficiency of collateral, failure to turn over rental proceeds. These are also grounds that the court should consider when determining whether or not to appoint a receiver. The rights, powers, and duties of a receiver are now governed by statute. The receiver is charged with collecting, controlling, managing, conserving, and protecting receivership property. In many instances, a receiver will operate a business. Typically, this will involve the maintenance of or defending causes of action. Consider a shopping center that is in commercial receivership. In such instances, the commercial receiver will have to evict non-paying tenants. He or she may have to defend lawsuits that are filed against the shopping centers, such as a slip and fall. Importantly, a receiver, and this did not change, but a receiver can only be sued with approval of the court appointing the receiver. That's now codified into statute 714.18 sub 2. So you need the permission, not of any court, of the appointing court in order to sue the receiver. And also under the statute, the receiver has the ability to engage professional help. The receiver needs court approval for that. That can be and typically is in the order appointing receiver. But it also outlines how the help is, the new statute outlines how the help is appointed, how it's managed. You get identity, qualifications, compensation questions, all addressed in the new statute. Also, importantly, a receiver is not inherently disqualified simply because it has a prior relationship with a plaintiff or a creditor. And now there's also a requirement to itemize time spent, work performed, rates, expenses. That's somewhat new. It would just be good practice under prior law so that the receiver doesn't get a giant bill and nobody has an explanation of how this bill was accumulated and for what services. All right, new law. This is, in fact, some of the new aspects of the law that have changed Florida law. First, we now have a shall. Under common law, this was not a shall; it was a may. The court would consider various elements or various grounds for the appointment of a receiver. Now the court is required to consider each one of these enumerated grounds for the appointment of a receiver. First, waste, loss, substantial diminution in value, transfer, dissipation, impairment, all the things that we had seen previously in case law for the appointment of a receiver. It's now statutorily required that the court consider it. Also, agreement and a mortgage, still not dispositive. Note, we're just considering these factors. Also, agreement after default. I think this is one of the most critical changes to the statute, and something that practitioners that only practice, that do not practice litigation, that are only transactional lawyers should take a look at. Agreements after default, thinking about forbearance agreements. In a forbearance agreement, you already have a default. And under such circumstances, many times you might say, the loan agreement still applies and all those terms. Consider adding a new provision that says, in addition to all the terms it's already provided in the loan or in the mortgage, the mortgagor again says that we agree to and are willing to have a receiver appointed over this property. And that is an additional ground that the court shall consider. Sufficiency of other collateral. Where are the rents and the proceeds? If the rents and the proceeds are making their way to the Cayman Islands and not taking care of the property or paying taxes, one might suggest that we have a little bit of a problem, and maybe the court should appoint a receiver. Also, potential rights of subordinate lien holders. The court is required to consider that, which I think is interesting and might lend its hand to the appointment of a receiver as opposed to simply just a foreclosure and wiping out all those liens altogether. Let's talk about the issue of bond. A bond is optional. So we have two ways that we can appoint a receiver. One is with notice and one is without notice. We now have an optional bond in the event that the receiver is appointed without notice. I think this is key. Under an injunction standard, there is a bond that is absolutely required without question. Now, that bond is optional. And that's, of course, to pay the defendant in the event for damages in the event that something was awry and the receiver should not have ever been appointed. There is a bond requirement for the receiver himself or herself, the receiver. That's under 71408. There's a mandatory bond unless the receiver posts alternate security with the court. That alternate security can be, I would imagine, a myriad of things. It cannot be the receivership property. You can't post the receivership property as your alternate security for the bond. Additionally, there is a brand new notice requirement once a receiver is appointed. This is 71420. The receiver must provide notice to the creditors of the owner about his or her appointment as receiver. The notice must be made by U.S. mail and publication as directed by the court. And if the court doesn't direct, the receiver may be better served by just sending the notice by U.S. mail and by publication. There's an exception to this notice requirement in the event the receivership property is likely to be insufficient to satisfy the claims of each creditor holding a perfected lien. In other words, all secured creditors. So if the property is underwater, the receiver may not need to, under the statute, may not need to serve those notices. Of course, this may be a pitfall and something that the receiver would rather err on the side of caution and send out the notices anyway. Finally, ancillary receiverships. 71424. As mentioned at the beginning of the presentation, this is the somewhat uniform Commercial Real Estate Receivership Act. Other states have enacted similar laws. To the extent that a receiver is appointed in another state that has this law, yet that receivership also includes real property in the state of Florida, there may be grounds or cause or need for an ancillary receiver to be appointed here in Florida, and that's vice versa. If a Florida receiver needs to reach into another jurisdiction, an ancillary receiver can be appointed in that other jurisdiction. Receivership can be terminated by a dissolution motion on 5 days' notice. Of course, in the statute, flexibility is given to judges. I can't get a hearing in 5 months, so 5 days is going to be a little tight, but hopefully the judge is able to advance it on the calendar. The receiver has a statutory lien right And that was common law before, but now it's statutory. And that statutory lien is superior to all other creditors. The receiver has a right to turn over to all receivership property, and importantly, there's a stay of other actions. You can see how this statutory stay of other actions can be very valuable. Think about a construction lien foreclosure. Actually, not just one. Let's talk about 10, okay, because 10 different construction liens were filed and 10 different construction lien foreclosure suits are going on. Maybe it's better for judicial economy purposes that the mortgagor, the senior debt on the property, files a foreclosure action, asks for the appointment of a commercial real estate receiver over that property, and stays all other actions, which would include those other lien foreclosure actions. There's obvious exceptions for government regulation, criminal proceedings. You can't get out of jail just by having a receiver appointed. All right, this is what you came here for today: alienation of real property. For the very first time under Florida law, a commercial real estate receiver is able to alienate real property prior to the entry of a final judgment of foreclosure. This is in 714:16. I would read that entire statute front to back. With court approval and with notice to all parties with an interest, including lien holders, and a hearing. Now, you can get this consent, or you can get this by one of two ways. First, with court approval and consent of the owner. You can imagine how many times that may happen or may not happen. So most often you're going to be on this second category, which is court approval and the failure of the owner to object. That's in 714:16(2)b. If the owner fails to object before the hearing, after the receiver in good faith does everything the receiver can do to provide reasonable written notice to the property owner of the transfer, and the transfer is necessary for all the reasons enumerated in the statute, the court can approve the sale and alienation of this real property pre-judgment. Of course, the big question that I'll be excited to hear is what happens if a defendant borrower doesn't come and object, yeah, I made every single mortgage payment, nothing's wrong with the property, there's no waste, but instead just walks into court and says, I object. Without any basis, reason whatsoever. The statute's silent as to that. It'll be curious to see what the courts do. Also, under this statute, service to lien holders is required to be service of process, not an email, not a letter to to the bank down at the corner. It has to be by service of process or better. All right. Most importantly for everyone here is the exclusions of this act. The act does not apply to homestead. So that's good. Everybody can breathe a sigh of relief because that was really what everybody was worried about when this act started swirling around. The exceptions to the act, it does not apply to actions expressly authorized to be taken by a state agency, actions authorized by federal law. But check out these next four areas that are carved out that I wanted to point out to you, because from our standpoint and when we saw this bill tracking through, it was important to note the protection of homestead. So real property improved by one or two dwelling units, which includes the homestead of an individual owner or an affiliate of an individual owner. Next, property exempt from forced sale, such as homestead. Next, personal property used for personal, family, or household purposes, presumably in homestead. And finally, this chapter does not limit an individual's homestead rights under the laws of this state or federal law. So at least four different sections in the exceptions throughout the statute that note that this particular statute is not going to be applicable to homesteads. You cannot get a receiver appointed over homesteads, and you cannot forcibly sell homestead property under this particular statute. The definitions provide an individual owner and an affiliate. They are extensive and involve anybody that could conceivably be living in the property for the most part. Other interesting thoughts and considerations are title considerations. A transfer of receivership property before or after judgment, first of all, may be free and clear of any liens on the property at the time of such transfer. So if you have a foreclosure case pending and you have 5 junior liens and the property is sold pursuant to 714:16, all of the liens are wiped out. the plaintiff's mortgage lien, as well as those 5 junior liens. All of those mortgage liens are no longer encumbering the property. They are transferred free and clear. The proceeds of that sale, the liens attach, all the liens attach to the proceeds of the sale in the same priority that they had before. So it doesn't affect the validity of those liens. It just, or their priority. It just moves them from the actual real estate, and it moves it over to the sale proceeds. And very interesting, a reversal of an order allowing the sale of real property on appeal does not affect the validity of the transfer to a good faith transferee. So you can envision a foreclosure action where a lender ultimately prevails, but during the pendency of the foreclosure action, the property was sold to a bona fide purchaser, a good faith purchaser for value. And then subsequently to that, the defendant takes the case up on appeal and wins. When the defendant wins that case, it does not unwind the real estate transfer. The real estate transaction is not unwound. The bona fide purchaser still has good title to the property and can continue to take their title as they ordinarily would. So that appeal, and there's an exception, of course, for a stay pending appeal. All right, that is pretty much the time that I have allotted. If you have any questions, my email address is here on the screen. You can email me. Also, I used this statute for the first time about 2 weeks ago. I'm curious to know if anybody else out there has used the statute yet, and feel free to email me and let me know if you used it before me or even after me. I'm curious to know what your experience has been. Thanks so much.
Hello again, everyone. Our next speaker is Liz Hughes out of the Miami office of Greenspoon Martyr. Liz specializes in probate trust and guardianship litigation. She is currently the vice chair of Reptiles Guardianship Committee and also the vice chair of the Dade County Probate and Guardianship Committee. Liz knows her topic as well as anyone on the planet. She's going to be speaking about HB 505 and standing to recover estate assets. Thank you, Liz.
Hi, good morning to all of you out in the virtual world. My name is Liz Hughes, and I'm an attorney at Greenspoon Martyr down here in Miami. My practice is predominantly probate, trust, and guardianship litigation. And today, courtesy of COVID, I am presenting to you via Zoom from my dining room. So welcome. Today, I get to talk to all of you about House Bill 505, which relates to the proper party to pursue causes of action on behalf of the estate. I've presented on this topic a few times before today, and I think it's an interesting one because most probate litigators would assume that you can't adjudicate a dispute involving a decedent's property without including the personal representative of the estate as a party to the case. It seems logical, right? A good example is a very common scenario of a plaintiff who believes that a sibling defendant unduly influenced their parent during the parent's lifetime to make inter vivos transfers to the defendant. But really, if you think about it, depending on the testamentary plan of the parent, who's to say that the plaintiff has any stake in the outcome of the recovery of those assets? So in other words, the plaintiff may not necessarily be a beneficiary of that asset or of the decedent's estate at all. And even if the transfer is successfully set aside by the plaintiff, you would ultimately need a probate proceeding to tell you who takes from that parent's estate anyway, or who the beneficiary of that particular asset is. And again, it might not be the plaintiff. So naturally, I think a lot of probate litigators would think that the law in this scenario requires the deceased parent's estate to be a party to this kind of lawsuit. And you would be familiar with that concept because for wrongful death actions in Florida, that is the scenario. The personal representative is a statutorily required party. But does that same rule apply to the scenario that we just talked about, the type of inter vivos transfers during the decedent's lifetime? Well, prior to House Bill 505, there was a divide in Florida case law, and some courts said no, the estate was not a required party, which is a somewhat counterintuitive response. One of those cases being the 2016 4th DCA case of Parker v. Parker. This is the decision that prompted the beginning of the changes in the legislation that you'll see in House Bill 505. I think what House Bill 505 does to change the probate code clarifies when the estate needs to be involved and that the personal representative is the proper party to recover assets for the benefit of the estate. So what I'd like to do is walk us through the Parker decision, because I think it gives a setting for these type of issues, so it's sort of less amorphous. And then I'll explain how the new legislation in House Bill 505 fixes things to clarify when the estate is necessary. So what happened in Parker? Joe Parker Sr. found out that he had a terminal illness, and 15 days before he passed away, Joe and his wife transferred 7 pieces of real property to their son, Sean Parker, and Parker Quest LLC. This was an entity that his son, Sean, recently formed, basically in order to receive those assets. About 7 months after Joe passed away, Joe's children from a prior marriage, so Sean's step siblings or half siblings, initiated a lawsuit against Sean and their stepmother and Parker Quest LLC for the return of those properties. They alleged undue influence, unjust enrichment, tortious interference, and replevin, all claims essentially to set aside those warranty deeds that conveyed the properties right before their father's passing. The defendants, again, remember that is the wife and the child of the decedent when at the time he passed away, filed a motion to dismiss those claims, basically saying that Joe's estate needed to be a party to these types of actions. They cited to the probate code section 733-607 for the proposition that the estate is an indispensable party and the plaintiffs individually were not the proper ones to bring these type of actions for the benefit of the estate. The trial court judge agreed and granted the defendant's motion to dismiss for failure to join the estate as an indispensable party. The plaintiffs appealed. So what happened at the fourth? The fourth DCA reversed the trial court's decision and said, no, you don't need to join the estate in order to pursue these causes of actions. The children can do so individually. But how did they get to that result? So the fourth DCA, they also looked to the probate code 733-607, which again addresses the personal representative's duty to take possession or control of the decedent's property. And I say decedent's property because they use that definition or that term to say that that was no longer the decedent's property because it had been transferred prior to his passing. So since it was no longer in his name, they no longer consider that to be the decedent's property as contemplated in 733-607, and therefore they didn't apply the probate code at all. They essentially, with that threshold determination, stopped working within the framework of the probate code since those assets were no longer in Joe Parker's name. The court also cited to several other Florida decisions that had permitted children or family members individually to pursue causes of action to set aside these type of inter vivos transfers, which did allow the Parker case to proceed without requiring the estate to be joined as an indispensable party. But notably, none of the prior decisions that the fourth DCA raised, none of those, the litigants didn't raise standing as one of the issues. So this all sort of sounds like probate litigation mumble jumble, but the practical problems with the holding in Parker that prompted the legislative changes in 505 are quite significant. So first, the litigants in the Parker case didn't identify that the causes of action themselves for the recovery of the estate assets are assets of the estate, and that the personal representative has a specific statutory authority to recover assets of the estate and determine title to them. The Parker decision also didn't recognize that an individual heir, beneficiary, surviving spouse, they don't necessarily on their own in their individual capacity have standing to bring such claims for the return of assets. What I'm saying is no one in the Parker court case alleged that the plaintiffs lacked standing to bring these claims. The fourth DCA decision basically presumes that as heirs or children of the decedent and the wife of the decedent, that they would be the ones with standing to recover assets for the estate, but they didn't take into consideration that those individuals might not have an interest in the decedent's estate at all. The personal representative or administrator ad litem is the one tasked with pursuing claims for the benefit of all recipients under the will. And personal lawsuits by the individual beneficiaries would duplicate or compete with the personal representative's duty to pursue recovery of these estate assets. Not to mention that beyond other overarching themes in the probate code, 733-609 specifically provides that any person taking, converting, or intermeddling with the property of a decedent shall be liable to the personal representative or curator for the value of that property or the damages that were caused to the estate. And finally, in a broader sense, the Parker decision essentially circumvents the probate process altogether. By allowing the pursuit of these causes of action without joining the estate, it allows for parties to settle without including other necessary parties because there's not a fiduciary appointed. So other beneficiaries, charities, priority payments for final death expenses, creditors, funeral expenses, administrative costs, they would be left out of any type of settlement that could be received or come into being by these individuals, essentially circumventing the entire probate process. If cases played out like the Parker decision would have allowed going forward, it would essentially disregard the testacy or intestacy status of the decedent. Again, there's no one charged with the fiduciary duty to protect the estate overall. So what does the new legislation in House Bill 505 do, and what will it change? The new law adds language to 731-201 subsection 32, which clarifies that causes of action themselves are assets of the estate or property of the estate. So specifically, there's changes to 731-201 subsection 32, which serve to clarify that the personal representative's authority over all the decedent's property, including causes of action for the return of assets. The new law also adds language to 733-612 subsection 20, which establishes the personal representative's duty to prosecute claims and causes of action of the estate or that the decedent had at the time of death, which could include claims for the return of these fraudulent transfers or other improper inter vivos gifts. The additional language in 733-612 subsection 20 essentially rejects the distinction drawn by the Parker Court and clarifies that the personal representative's duty to prosecute or defend claims for the protection of the estate and for the return of the decedent's property. The changes to the probate code will go into effect later this year in 2020 in October. And I would like to add a special thank you to Katie Huss and the other subcommittee members who worked on this legislation with me, and our probate and trust litigation committee who passed what we suggested. I hope you all enjoyed the Zoom version of this presentation, and I hope that this very short discussion gives you some food for thought on how to approach your next probate litigation case where you have issues like this one. Thank you.
Hello again, everyone. Our next speaker is Christopher Smart. Chris is a shareholder at Carlton Fields in the Tampa office who specializes in real property litigation. Mr. Smart is the chair of the Reptile Title Issues and Standards Committee. I believe that Christopher is a double gator. Christopher will be speaking to you about making your real estate transactions easier, correction of obvious errors in deeds, and an elimination of subscribing witnesses and leases.
Welcome, and thank you for attending. My name is Chris Smart, and I'm pleased to be here because this is my very first presentation at a legislative update, and it's also the first all-virtual legislative update, so a momentous occasion for that reason alone. I'm excited about the legislative materials that I have the privilege of presenting to you today because they're going to help facilitate your real estate transactions by making them simpler and easier. The two pieces of legislation that I'm going to be talking about today are amendments to Florida Statute 689, and the first is a brand new statute that provides a procedure for curing obvious errors in legal descriptions in deeds that will help save the time, money, and effort that you would otherwise have to expend in bringing an action to quiet title or to reform that deed. The second is an amendment to 689.01 that eliminates the requirement for two subscribing witnesses in a real estate lease. So let's begin by talking about the new statute, the curative statute, which is 689.041 Florida statutes. Many of you have been in this situation. You're getting ready to close a real estate transaction and you notice a problem. There is a blatant error in the legal description of the seller or the grantor's deed or the borrower's deed in a refinance transaction. It may even go back several deeds in the chain of title. That likely means that you're going to have to delay or cancel the transaction, get the buyer and the lender to agree to something less than marketable title, or seek out the original grantor to try to get a corrective deed from that individual, or failing all of that, file a reformation or quiet title action. And none of those options are particularly palatable when you're trying to get a real estate transaction closed. But now there is a statutory cure. The new statute allows you to follow the simple procedure of examining record title and recording a notice in the official records where the real property is located, and voila, you have marketable title to the real estate and can proceed with the transaction. The new statute is importantly based on the intent of the parties, like the lodestone for any contract in Florida. It applies only where the error is obvious and you can tell what the party's intent was from the record alone. Florida, in adopting this statute, follows a handful of other states that have adopted similar curative legislation. And as I mentioned, the purpose of this is simply to help facilitate and expedite closings. So let's talk briefly about what exactly the types of obvious errors the statute will correct are. First, it is designed to correct a single error in one of the following three categories: the lot or block of a platted lot, the unit, building, or phase of a condo or cooperative, or the directional designation or numerical fraction in a section, township, or range. So, for example, if you were dealing with a platted lot and the description in your erroneous deed was lot 1, block 11, when what in fact was intended was lot 1, block H. Just think about the similarities between those two numbers, particularly when you're dealing with an old copy of a deed that's hard to read. That's particularly the case when there is no block 11 in that platted subdivision. See, it just doesn't exist, so you know what the party's intent must have been. Even though the statute, as I mentioned, only corrects a single error, note that the transposition of the lot and block number in this instance will constitute one single error, and the statute will correct that problem. So, for example, where it says lot 11, block 1, when what was meant was lot 1, block 11, the statute cures that situation. When you're dealing with a unit, building, or phase, think Unit 1, Building 1, Phase 4, when what was intended was Unit 1, Building 1, Phase 3. Again, particularly the case if there is no Phase 4. And finally, with the directional designation, think of Section 1, Township 2 North, Range 3 East, when what was meant was Section 1, Township 2 South, Range 3 East. Importantly, the statute doesn't cure all errors in legal descriptions. It doesn't apply to metes and bounds legal descriptions, and it won't cure multiple errors. There's just too much room for error in those situations. The statute only applies also if three conditions are met. One is the original grantor has to have held title to the intended property at the time of the original erroneous deed. Second is that the original grantor didn't own any other property in the same area as the intended property as defined by the statute. And finally, and importantly, a curative notice has to be recorded in the official records where the property is located. So let's talk a little bit about the curative notice. The curative notice is set forth in detail in the statute, and it basically recites that the record has been searched and examined and that the statutory requirements have been met. The one thing I want to note about the statutory form of notice is that it contains an earlier form of the jurat. So if you're using the statutory form, make sure that you substitute the form of jurat that was adopted in Florida in January of 2020 and not the one that's currently in the statute. Once the notice is completed and recorded, it operates as a correction of the legal description relating back to the original erroneous deed and including all subsequent erroneous deeds. It also operates to release any cloud or encumbrance on title to the intended real property that may have been caused by the erroneous deeds. And as I indicated, you now have marketable title. So hopefully that will help facilitate your real estate transactions. Anecdotally, I can tell you that even though it was only adopted in July of this year, I've already had occasion to use the statute to great effect, and I've heard stories of others who have done the same. So I hope it helps you in those transactions as well. Let's move on now to talk about the amendment to Section 689.01, which is the elimination of subscribing witnesses in residential and commercial leases in Florida. You've been in this situation. You need to get the lease signed. The prospective tenant is ready to move in and start paying rent. Your lease is beautifully drafted, but your landlord is working in a remote location in British Columbia. He's got access to the internet, scanning devices, and all the other necessary technology, but he is isolated, and so there are no witnesses to be found to witness his signature. So your lease is going to be, unfortunately, delayed, the tenant's occupancy similarly delayed, and the landlord's income cut short. So what's the solution here? Eliminate the witnesses, of course. Not really. It's much simpler just simply to eliminate the requirement for two subscribing witnesses. And that's what this amendment does. But before we get to that, let's start by mentioning briefly the original purpose of having two witnesses, which is that it allowed for and enabled the proof of execution and the circumstances surrounding it at a later date to avoid fraud and other misdealing. But there were problems with the statutory requirement as it was codified in 689.01. First, it didn't require witnesses to subscribe in the presence of the grantors or each other, or even before the delivery of the lease. That's the Medina versus Orange County case in your materials and on the slide in front of you now. Moreover, it arguably did not technically require that the tenant's signature be witnessed, although that was frequently done in practice. And finally, and perhaps most disconcertingly, it created the potential for a gotcha situation, which is described in the Skylake case there in your materials as well as on the PowerPoint slide. In that case, the landlord signed the lease, the tenant signed the lease, the space was completed and it was ready to be occupied by the tenant. And only at that point did the landlord decide he was going to repudiate the lease because it wasn't witnessed by two subscribing witnesses. The court case went on and went up to the appellate court, and the appellate court ruled that in fact the tenant could not enforce the lease because it was not in compliance with Florida Statute 689.01 because it lacked the two witnesses. So the landlord basically pulled a fast one on the tenant, although the tenant did have other remedies at law against that landlord. It just seemed, like I say, a gotcha situation. More importantly, than all of the other reasons that are given for making this amendment, the main problem with the witness requirement is that it just slowed transactions down and in the end proved more of a burden than a benefit. That's particularly the case given that the chance for sharp dealing or fraud or other abuse is just less likely in this context than in that of, say, a deed. So today, commerce moves at the speed of your iPhone, and it's simply no longer practical to have these witnesses as part of the transaction. Moreover, Florida was in the minority of states that required subscribing witnesses on real estate leases. And as you can see from the map that's on the screen currently, there were only 11 states in total that had these requirements, and now one less. There's only 10 currently that have that requirement. There's a list of the requirement that's current through the date of when the legislation was being adopted, if you want to take a look at that. So there you have it. You have Florida Statute 689.01 amended to eliminate the witness requirement for real estate leases and related instruments. And with that, that is the end of my presentation. I hope that these two pieces of legislation will help facilitate your real estate transactions. And of course, feel free to let me know if you have any questions. Thank you for your time.
Hello, everyone. My name is Jennifer Tobin, and I am a member of your steering committee for today's event. I'm coming to you from my remote office in the beautiful Daytona Beach Shores, Florida, and we're very glad that you're participating today remotely. I'm happy today to have the opportunity to introduce several of your speakers, and very fortunate, the first person I have to introduce is Bill Hennessy. As many of you know, he is from West Palm Beach, and he is currently the chair of Gunster's Probate, Trust, and Guardianship Litigation section. And of course, more importantly, he's the current chair of the Real Property Probate and Trust Law section. And with all that he has going on, with meetings on, meetings canceled, and everything else that comes with being a section chair this year, we're very fortunate that he is joining us today on our faculty to present, get it in writing, letters every lawyer should have when accepting fiduciary appointments.
Good afternoon, everybody. Welcome to the legislative update this year. My name is Bill Hennessy. I am your section chair. I am very disappointed we're not able to meet in person this year at the Breakers, but hopefully you're enjoying the update so far, and you're learning an awful lot. Hold on one second. I've got to take this. Sorry. Hello. Yeah. Of course I met with her. I met with her for like 45 minutes. Yeah, we talked about, the fact that I could serve, that anybody could serve. Yeah, I told her that I'd get paid. Look, I don't have time. Carl, just give me one more second, please. Look, I don't have time. Writing? No, I didn't. I talked to her all about it. I explained it. I'll call you back. Gosh, I can't believe these greedy kids, challenging my appointment in court, making me look bad. Awful. Well, okay, you see, that can happen very easily and very simply, and it's not a good place to be. I'm going to share a case with you right off the bat. But before I do, I want to give you a little bit of background. In addition to being your section chair, about 10 years ago, I chaired an ad hoc committee that was created called the Ad Hoc Conflicts of Interest Committee. It was created by the reptile section of the Florida Bar. We created that to study two significant issues. One is lawyers receiving gifts under testamentary documents. That ultimately resulted in a statutory change, which the Florida legislature adopted a number of years ago. In addition, we studied the issue of lawyers being named as fiduciaries in documents that they prepare. The reptile section, after studying that issue for some time, came out with two positions. One is a Florida Supreme Court rule change, which actually took effect February 1st of last year, 2019. And the other is a statutory change. That statutory change prevents a lawyer from getting compensation for serving as a fiduciary unless they get certain disclosures in writing or make certain disclosures in writing to the client. And that change takes effect October 1. It was passed by the legislature this year. And so today we're going to be talking about both issues. But by way of background, that little story I told you comes from a case called Rand versus Giller. And what happens in Rand versus Giller is a lawyer meets an elderly client for 45 minutes or so in his office. It's a new client. He prepares estate planning documents wherein he's named as a fiduciary with one of the testator's family members. The family ultimately asks him to step down and resign. The lawyer refuses to do so, and ultimately the family brings a removal claim. Now, regardless of whether that lawyer did anything right or wrong, I have found as a practicing lawyer that many times we do not have good writings which explain the fiduciary appointment that we've undertaken to the client. And so in Rand versus Giller, this lawyer is sitting before the judge that he practices in front of all the time. And the family is accusing him of essentially self-dealing, unduly influencing the testator to nominate him so that he can earn a lucrative fiduciary fee. And that lawyer doesn't have a writing. And ultimately, what the court says in that case, and I'm going to bop ahead, the case is Rand versus Giller. It's up on your screen. There's the citation to it. What the court ultimately says in ultimately not removing him is that for the benefit of the bar, we strongly suggest that attorneys establish procedures for such cases, meaning when they're appointed in documents, appointed to fiduciary positions in documents for their client, which allow for evidence other than the self-serving testimony of the attorney involved, of the care taken to avoid the appearance of impropriety. So the Rand versus Giller case a long time ago warned us that we need to get these disclosures or disclosures to the client in writing when we're accepting a fiduciary appointment. And my mother often said that sometimes a stapler to the head is the best motivator, right? And so the end result of this is regardless of whether you do anything right or wrong, regardless of or have done anything right or wrong, there might be very good reasons why you've been appointed as a fiduciary. The failure to get disclosures in writing, particularly now under our existing law, is going to create problems for you. And so we're going to talk about how we navigate that in the current environment today in connection with our rules and our new statutes. And so, again, we're talking about fiduciary as a lawyer as a fiduciary. There are many, many good reasons why a lawyer might serve. And I am not today indicating that there's any ethical violation associated with a lawyer serving. You know, we're appointed for good reasons. In many cases, we have a familiarity with the client's family. We have a familiarity with the client's assets. We may have been involved with the business affairs of the client. And not only that, we're trained in analytical skills and we're trained in administering estates and trusts. So there are good reasons why we might serve. So the ACTEC commentaries, and I'm going to take a quick aside and tell you, if you don't know, the ACTEC is the American College of Trust and Estates Council. You can go to their website, actec.org, and they have a set of commentaries to the model rules that are available for free on the public side of their website, which talk about ethical issues involved in trust and estates. And you can find commentaries dealing with a whole myriad of issues. We're going to take a look today at what they say about lawyers serving as fiduciaries. It says a lawyer should be free to prepare a document that appoints the lawyer to a fiduciary office, so long as the client is properly informed, the appointment does not violate the conflict of interest rules, and the appointment is not the product of undue influence or improper solicitation. So let's stop there. They make it clear you can serve. They also make it clear that there are some conflict issues involved, and you need to navigate through those. And also, and we need to focus on this, they make it clear that you should not solicit appointments. And so in Florida, we're going to talk about our rule change. Our rule change is very similar to this, and it talks about solicitation. And so the Act Tech commentaries talk about the fact that the appointment can't be the product of improper solicitation. So what does the client need to understand in making the appointment? What type of disclosures are necessary? The Act Tech commentary says that a client's properly informed if the client is provided with information regarding the role and duties of the fiduciary. In other words, what does a fiduciary do? They need to understand that in order to appoint you. The ability of a layperson to serve with legal and professional assistance. In other words, they need to know generally that anybody can serve, that it doesn't require a lawyer. And finally, they need to understand the comparative costs of appointing the lawyer or another person or institution as a fiduciary. So that's what the Act Tech commentaries have to say. The importance here is we need to work on getting our disclosures in writing in what we say to the client. Put it in writing, and that is going to be the focus of our Florida bar rule change as well as our Florida statutes when we get to those. Now, the ABA model rule also discusses these issues, Rule 1.8. And we've changed this rule, but let's look at the model rule first. It says, the rule does not prohibit a lawyer from seeking to have a lawyer or partner or associate of the lawyer named as executor of the client's estate or to another potentially lucrative fiduciary position. So they recognize that lawyers make money doing this, and they actually say, in the model rule, that it doesn't prohibit a lawyer from seeking appointment. That goes to that solicitation issue that I mentioned earlier. It says, nevertheless, such appointments will be subject to the general conflict of interest provisions when there's a risk that the lawyer's interest in obtaining the appointment will materially limit the lawyer's independent professional judgment in advising the client concerning their choices. So if there's a risk that the fees that you will earn could impact your judgment and the advice that you give to a client, you can't appoint yourself in a document that you prepare. So that begs the question, every lawyer, of course, is going to say, of course my judgment wasn't impacted by the fees that I was going to be earning under these circumstances. And so it creates a bit of a conflict between the lawyer and the client, and it again sets up that self-serving testimony issue. There's an ABA opinion that's very good on these issues as well. It's 02426, 02426. And it says when a client's considering the appointment of a lawyer, the lawyer must inform the client that the lawyer is going to get paid for serving, whether the amount is subject to statutory limits or court approval, and how the compensation will be calculated and approved. It also says the lawyer should inform the client about what skills the lawyer is going to be able to bring to the table. The lawyer should learn from the client about what they expect in the appointment and the like, so they can make an informed decision. And it talks about, again, the fact that the lawyer should discuss with the client the fact that the lawyer, acting as a fiduciary, may select himself or his firm to serve as the lawyer for the trust or the estate, with the result that additional fees may be earned. And that's the double dipping issue which occurs essentially when the lawyer is a personal representative and also hires his own or her own firm. You're able to get compensated for serving as personal representative, of course, and you're able to get compensated for the legal work that you perform. There's nothing wrong with that. The issue is simply one of client disclosure, making sure the client understands. So what have we done in Florida? Well, we, for a long time, had an ethical canon which said that a lawyer should not consciously influence a client to name him as a fiduciary in an instrument. In those cases where the client wishes to name his lawyer, care should be taken to avoid even the appearance of impropriety. And that brings us back to the Rand versus Giller, right? Get it in writing. That avoids the appearance of impropriety because you can show that you made disclosures to the client, and the client consented to your appointment in writing. So that brings us to what we've done in Florida. The first thing we did was we advocated for a Florida Supreme Court rule change. That rule change took effect February 1 of last year. And what it does is, you see the first part of the change, it says this rule does not prohibit a lawyer or partner or associate of the lawyer from serving as personal representative. We took out prohibit a lawyer from seeking to be appointed because we did not believe that a lawyer is able to solicit an appointment in Florida under circumstances where they're being named in a document by a client. So it says it doesn't prevent a lawyer from serving if a client asks, essentially, in a lucrative fiduciary position in connection with a client's estate planning. A lawyer may prepare a document that appoints the lawyer or person related to the lawyer to a fiduciary office so long as the client is properly informed, the appointment doesn't violate the conflict rules, the appointment's not the product of undue influence or improper solicitation, and the client gives informed consent confirmed in writing. We now in Florida, by virtue of this rule change, February 1 of last year, require disclosures in writing that are confirmed in writing by the client. And it also goes on to say that in obtaining the client's informed consent, the client must, in writing, understand who's eligible to serve, that a person who serves as a fiduciary is entitled to compensation, and that the lawyer may receive compensation for serving as fiduciary in addition to any lawyer's fees that they may earn. And that disclosure is now required by the Florida Bar rules. So in conjunction with this rule change, we also advocated for a statutory change. And this statutory change is what we're going to focus the remaining time which we have today on. And essentially what this statutory change says is that a lawyer serving as a personal representative or a trustee is not entitled to compensation for serving in that role. In other words, you can't get compensated as a fiduciary if you as a lawyer prepared or supervised the execution of the instrument making the appointment, unless you as a lawyer, or if you've appointed somebody related, the related person is also related to the testator or settlor. In other words, you'll be entitled to compensation if you are related to the settlor or the testator, or you make very specific disclosures to the client before the document is executed. You have to have a discussion with the client about certain basic issues and have the client sign off, and I'm going to show you the sign off in a second, in order to be compensated for serving as a fiduciary if you were the one who prepared the document or supervised its execution, or if you have appointed anyone related to you or in the same law firm as you. So let's walk through the disclosures first. What does the client need to know? The client needs to know that, subject to certain limited exceptions, a corporate fiduciary or any person, including a spouse, an adult child, a friend, or an attorney, is eligible to serve. In other words, the client needs to understand that almost anybody can serve in the role, that any person, including an attorney, who serves as a fiduciary is entitled to reasonable comp, and that the compensation is in addition to the attorney's fees payable to the attorney or the attorney's firm. Very simple. 3 things. You need to talk to the client about who can serve. You need to tell them you're going to get paid for serving as a fiduciary, or that you'll be entitled to be paid. And you need to explain to them that that payment for serving as a fiduciary is in addition to any fees that you will earn in that role. The client is required to sign a written statement acknowledging that the disclosures, those 3 very simple disclosures, were made prior to the execution of the document. The written statement can be part of the document. It can be included in it, for example, at the end, after they sign the will, there can be a separate statement at the end where they acknowledge in that statement that the disclosures were made to them. The disclosures, though, have to be made before the document is signed. The client can sign that writing at any time. So if you forgot to do this, as long as you made the disclosures to the client in advance, they can sign it before or after the will is signed or the trust. It can be part of the document. It can be attached to it. So we have this concept of related persons that's part of the statute. And the statute says that it doesn't apply if the lawyer is related to the testator or settlor, or the person being appointed is related to the testator or settlor. Related person is defined very broadly. It covers two things. One is whether the lawyer is related to the client. It also covers whether the person being appointed is related to the lawyer. One of the things that we've seen happen, and there are a number of cases around the country on, is the lawyer doesn't appoint himself or herself. Instead, the lawyer appoints a paralegal, a partner, another person in the law firm, his brother or sister, or spouse in the document to a fiduciary position. And the term related persons is very broad enough to include spouses, lineal ascendants or descendants, siblings, anybody whom the person has a close familial relationship, which can become a factual matter, of course. And then anyone related as a spouse to such person. So for example, if you appoint your brother, you can't appoint if you can't appoint your brother, you wouldn't be able to appoint your sister-in-law either. That exception applies both ways. So if the lawyer is related, for example, prepares mom or dad's documents, prepares a sibling's documents, the disclosures don't have to be made in that instance. At least they don't have to, they're not implicated by the statute. Whether they should be made is for another day. But for purposes of the statute, they're accepted out if you prepare a document for a family member. Now, again, it's important to remember that a person in the same law firm, your partner, your paralegal, if they prepare the document or supervise the document appointing you, it has the same effect. The statute deems that person related essentially for purposes of the disqualification or impact on compensation rules. And so you can't get around the rule by appointing your partner. That's going to require you to, make sure that when somebody comes in and is asking for a fiduciary appointment, that you're confirming who the related persons are to them and running appropriate conflict checks, because you don't want to have a partner disqualified from serving because you didn't realize that these rules were somehow implicated in some way. If you have a partner in another office, for example, and you didn't even know that they were related to the client. So you're going to want to run some names through checks in order to catch those issues. A lawyer is deemed nominated in a document under these rules if, and hang on one second, is deemed nominated in these rules if they're nominated as the personal representative, a co-personal representative, a successor personal representative, or they have the power to appoint someone and they appoint themselves. And so it doesn't just apply to direct appointments, it also applies to what I'll call ancillary or additional appointments. If you're named as a successor, you still need to get the disclosure. If you're given the power of last resort to make the appointment, and then you decide to appoint yourself or somebody in your law firm, you're not going to be entitled to compensation for serving, even under that more remote scenario, unless you have the disclosures in writing. Now, these statutes do not impact the validity of the will or the trust document. They only prevent the lawyer from getting compensated for serving in the fiduciary role. The lawyer would still be entitled to compensation for serving as a lawyer for the fiduciary. The statutes can be found in two places. One is 733-617, which is the statute dealing with compensation for the attorney of the personal representative. The other is in our trust statute, 733-0708. Both of those statutes contain new sections that essentially incorporate what I'm talking about today. Before I jump to forms, I want to go and talk about the application of this new statute to existing documents. It applies to any will or trust executed by a resident of the state of Florida on or after October 1. That gives you a chance to get your documents up to speed and get this process in place before the statute takes effect. It also applies to any will that's amended by codicil or trust that's amended that appoints a lawyer as a fiduciary after October 1, if the lawyer who prepares the amendment or supervises its execution is the lawyer being appointed. In other words, if you did a document 5 years ago and you're named as a fiduciary and you don't have the appropriate disclosures, and the client goes to a new lawyer to update a minor provision of the document, for example, and you are not part of the preparation of that, nor did you supervise its execution, the statute will not apply to you. It will only apply if you are the one preparing the amendment or supervising its execution, or someone related to you is. So, a couple of points just drafting wise when you're named as a fiduciary: consider exculpatory provisions. If you're waiving the prudent investor rule, you need to think about whether that's appropriate when you've been appointed by a client. You want to consider the removal provisions in the document. How is it that you're going to be removed? You want to go over some of those issues with your client and make sure you're talking about them. I'll save that for another seminar. I want to jump to our forms, which are most important. We have a statutory form that is in both the will statute 733-617 and the trust statute 736-0708. And I want to read the introductory language because it's important. It says that the written statement signed by the client must be in substantially the following form. This is the form, we'll call it a safe harbor, that you need to have the client sign as an attachment to the will or separate from the will. It says, I've designated whomever they've designated as nominated personal representative in my document. Before executing the will or codicil or trust, whatever the document is, I was informed that, subject to certain statutory limitations, most family members, regardless of their residence, any other individuals who are residents of Florida, including friends and corporate fiduciaries, are all eligible to serve as personal representative. Any person, including an attorney who serves as personal representative, is entitled to receive reasonable compensation for serving as personal representative, and that the compensation payable is in addition to the lawyer's fees. Very simple, very straightforward disclosures, which are consistent with the bar rule change. We have a trust form, safe harbor, that's very similar. It says, unless specifically disqualified by the terms of the trust, any person essentially can serve as a trustee, and it requires essentially the same type of disclosures. You need as a minimum to get this form signed. I have also included as an attachment to your materials a proposed letter which goes through some of the ABA issues that we talked about today. Talking about in more detail some of the options with the client, talking about in more detail a little bit more about the compensation related issues. It includes a paragraph which says that and discusses our compensation statutes, for example, and how they apply in Florida. And so I would suggest and encourage you to take a look at my form that I've placed in there. Of course, feel free to edit it. I can't guarantee that form is going to keep you out of trouble, but it's a form that I start with when I'm asked to serve in those fiduciary roles, and I thought it might be helpful to you. Well, I thank you for your time, and I hope you enjoy the rest of the program today. Thank you very much. Bye-bye.
Hello, Jennifer Tobin back again. The next speaker I'm happy to introduce is Ben Diamond. He is from St. Pete, where he's a partner in the Diamond Law Firm. As many of you are aware, he is also a member of the Florida House of Representatives, where he serves for Pinellas County. In that line, he is here to talk to you about The House Will Come to Order, a look inside the legislative process.
Well, all righty. Good afternoon. It's great to see so many of you virtually. I wish, of course, that we were all together in Palm Beach for this legislative update seminar, which is something that I look forward to every year, and I know that we all look forward to every year. But obviously, this year we're not together. I'm here in a law office in Tampa recording this talk, and my name is Ben Diamond. I'm a member of the executive committee of the Real Property Probate Trust Law section of the Florida Bar, and also privileged to serve in the Florida House of Representatives. I represent House District 68 in Pinellas County, which includes the city of St. Petersburg. And today, Tom Carr and the committee that has worked so hard to put on this CLE, they very graciously invited me to come and give a little talk on how this legislative process all works. You know, we all come to our section meetings and we spend a lot of time in our committees working on draft legislation, and then 6 months later we come back to this meeting and hear from Pete Dunbar and from our legislative team, you know, what passed and what didn't pass. But there's a big process in between, which is when I and so many of my colleagues head up to Tallahassee to work on these bills, and we thought it'd be fun to provide a little insight. So today I'm going to talk a little bit about the mechanics of the legislative process, some strategies that we use to pass our legislation through the legislature and hopefully have it signed by the governor, some of the tools that you can use as practitioners to follow section initiatives along through the legislative process and to research the legislative history of bills, which can be helpful when you're presenting arguments on behalf of your clients. And lastly, I'd like to conclude with some remarks on ethics, because I understand that the CLE committee would like to get a part of an ethics credit out of me. So I'm going to try to accomplish all of those things in a short 20-minute period. So let's get started. You know, we have this very rudimentary idea, many of us, as to how a bill becomes a law that we learned in maybe middle school civics or high school civics, that a bill, you know, has to pass through the House and the Senate and be signed by the governor. And of course, it's actually far more complicated. I have this other slide that has a bunch of arrows and boxes. And the point is that in Florida, we have a very short legislative session. It's only 60 days. We're all part-time members of the legislature. Is considered a part-time job, even though, of course, it's far more than that. And so it's actually a very complicated process. We had, in this past legislative session, the 2020 Florida legislative session, 3,517 bills filed by members of the legislature, and only 210 actually pass. So I think it's important that all of us in the section keep that in mind first when we're considering what our legislative agenda is going to be. You know, while there may be a whole bunch of ideas we want to pursue, we obviously have to be selective and pick our best ideas. And secondly, just to have an appreciation for the incredible work that our legislative chairs do and their committee, and of course our team that the section retains of legislative consultants and lobbyists to help us push push our bills through the process. So let's start off and talk a little bit about what I'm calling the mechanics of the process. The first is the introduction of a bill. So bill ideas obviously come from a variety of sources. Members themselves may decide they want to work on legislation. Constituents can bring you bills. Obviously, for our section, we are generating our own bill ideas through our committee work. And while we are doing in our section a tremendous amount of the drafting, it's interesting to note that the House and Senate both have bill drafting offices that help us actually draft legislation, so that if you have ideas that aren't fully baked, you can take it to the House Bill Drafting Office. They're staffed with attorneys and policy experts that will help us produce legislation. Members of the House are limited to filing 6 bills. So I can only file 6 pieces of legislation each session. The Senate are not subject to any restrictions on the number of bills that they can file. So it's important to keep that in mind, when you're looking for someone to carry a bill through the legislature, that members of the House are limited in the number of bills they can file. There are deadlines, just like in the practice of law. There's deadlines in the legislative process for the introduction of legislation. In both chambers, the bills must be approved for filing by noon on the first day of session. And during odd-numbered years, meaning next year, 2021, the session is scheduled to begin on the first Tuesday after the first Monday in March. March 2nd, 2021 will be the starting date. So there are also deadlines for when the bills have to be submitted to the House and Senate Bill Drafting Office. And obviously those deadlines occur prior to the start of the legislative session. So it's important to keep those deadlines in mind. The committee process is at the heart of the legislative work, and that is really the process where these ideas get vetted. These bills get a real careful look, hopefully. And the committees meet in a series of weeks leading up to the start of the legislative session. There are usually about 6 committee weeks, and typically they begin in December. So in this coming legislative year, we'll have our election in November, and then there's an organizational session, and then the committees get started. The policy subcommittees and committees eventually stop meeting. So back to the point about deadlines, the bills that we file get referred to committees, and in order to be eligible to be passed by the full body in the House or the Senate, they have to pass out of their committees of reference. So the first step is to get your bill heard in the committees that it has been assigned to, and that can sometimes be a challenging task because there are a lot of bills for a committee to consider and only so much time that the committee will be meeting. Once your bill passes through the assigned committees, it is eligible to be heard by the full body of the House and the entire body of the Senate. And in order to be called up onto the floor of the House, the bill must be placed on special order. So the special order calendar is set by the chairman of the Rules Committee, and the Rules Committee meets regularly. And so that is yet another hurdle. Your bill has passed out of all of its committees of reference, but then the decision has to be made whether the bill will be pulled on to the floor of the House or the floor of the Senate. And that's a decision that the Rules Committee and the Rules Chairman makes. And then obviously, once your bill gets on the floor, it has to be passed both in the House and the Senate in order to be enrolled and sent to the governor. And as the outline explains, this can happen in several different ways. If the House passes the bill, we can send the bill over to the Senate in what's called a message. and the Senate can pull up the message, and if it passes the message without any changes and sends it back to the originating chamber, in this example the House, then the bill is enrolled and transmitted to the governor. And so sometimes you get into situations at the end of session where the bills are being changed, where the House passes the bill and sends it as a message over to the Senate. The Senate amends the bill, sends it back to the House. And when that happens, the bill is bouncing. And it's a very nerve-wracking experience for the member who's responsible for passing that bill, because eventually the hanky drops and you run out of time. So just to recap, your bill has to work its way through the committee process. It has to be eligible to be on the special order calendar through the Rules Committee, and then it has to pass both chambers in the same form. In the midst of all that, members can try to amend the bill, and there's a lot of very complicated and interesting procedure, which I don't have time to go into today, about the amendatory process, but it is the key part of the legislative process in terms of how the sausage is made. And once you have mastered the amendatory process, it is a lot of fun. As the section knows, it's part of the process that I like quite a bit, because as a member of the minority party, often our bills are not necessarily getting on the agenda, but we still have the ability, all members still have the ability to offer amendments and try to make other legislation better through the amendatory process. There are amendment deadlines, so you have to make sure your amendments are in order and filed according to the deadlines. And then there are rules as to which types of amendments are considered in which order. By mastering those rules, you can have a lot of fun in making sure that your amendment is being considered sometimes in lieu of another member's amendment or another party's amendment. And the outline goes into a little bit more detail on the amendment process and the notice requirements. The notice requirements basically mean that you have certain deadlines by which the bills, the agenda, have to be published. And if your bill has not listed on those agendas by those deadlines, then your bill is dead. So all that is to say that it is a very challenging process to navigate. And the fact that the section is so effective in passing as much legislation as we do every year is really a testament to the fact that we have a terrific team of lawyers and lobbyists that are following the bills and advocating for the bills each step of the way. Let me talk a little bit about that in terms of strategies for getting your bill passed. So I thought it might be helpful to put together a couple observations on this issue from my experience now, concluding my second term in the Florida House. The first thing is, like anything else, start early. Begin working your bills early in the process. The session is so short and moves so quickly that it's really important to have spent the time in the months leading up to the start of the session meeting with your key members and laying the groundwork for the fact that there is legislation that needs to be passed to address a specific issue. Making sure that you're communicating with everybody who will be impacted by the proposed legislation is critical. As we've learned in the section, we are not operating in a silo when we are looking to make changes to Florida law as it relates to real property or probate and trust law issues. And so identifying the affected or interested groups, whether it's the Florida Bankers Association, other sections of the Florida Bar, and really spending the time with them early to try to build consensus and support for what we're doing is critical. Making sure you have the right bill sponsors is also a very important decision. You want the sponsors that will be dedicated toward working to pass the legislation. as I was explaining in the first part of this talk, there's so many bills that are getting filed, and there's so much activity in Tallahassee in such a compressed amount of time that you really need a bill sponsor that's going to go into the office of the chairman of the first committee of reference and basically be very persistent in trying to get that bill on the agenda. The chair is hearing from so many different people about so many different bills that it's great to have a sponsor that is dedicated to actually working your bill through the process to try to pass it. And then building support for the bill and trying to make your bill bipartisan, which is something that the section has done such a terrific job of over the years, is particularly important. So, you want a bill sponsor that's going to work the bill and actually try to build bipartisan support for the bill. You can have folks sign on to your bill as co-sponsors. Staying in touch with the staff is critical. I have a terrific legislative aide, and the committee staff is very important, and the staff really helps the members move legislation through the process. And then following up, like everything else in life, it's all about following up regularly, following up with your committee chairs. Mr. Chairman, I came to see you last week about this section bill, and you were kind enough to say that you liked it and you would agree to put it on the agenda. I just wanted to confirm that it would be on the agenda because I know the agenda is going to be released today. So, it's helpful to have a system in which you're following up with your key members. And then in the event that you cannot get the bill heard, there's always the possibility that your bill could be amended or your idea could be amended onto another bill. And we see this happen all the time in the legislature. So if you strike out and your chairman says, well, I'm so sorry, Diamond, my plate is full, you can look to see what else he's hearing and say, well, Mr. Chairman, you are hearing this other bill. It's somewhat related to this issue. I think these ideas are germane, and then you could go and start working your idea as an amendment. And then lastly, of course, just like in the practice of law, mastering these rules and deadlines is critical to being successful in getting the bill passed. So all that's just a little inside baseball, but I think it's kind of fun to understand in a little more detail just how much goes into seeing these section initiatives become a part of Florida law. Let me just take a minute and share with everyone some tools to research and follow along as this process is happening. I've really appreciated all my friendships in the section, and it's been fun to be serving in the legislature when we have bills that are moving through the process, because I'll get calls from people, hey, what's going on with this bill or that bill? And I'm happy, of course, to share what I know, but you can always look. There's a tremendous amount of information on the House and Senate websites. And I just wanted to walk through that so that everybody could take a minute to understand how that works. So there are separate websites for the Florida House and Florida Senate, and they're listed in the outline and on the PowerPoint. And they both have a search feature at the top that makes it, I think, fairly easy to follow legislation. You enter the bill number in that top tab where I have the arrow, and then you get pulled up a page, the sort of current legislative status of the bill, including the staff analysis, which is usually very helpful. It's written by a member of the committee staff that tries to explain what the bill does, and sometimes you get into arguments that the staff analysis has shaded the bill one way or the other or left out some key information. But for the most part, the legislative staff does a terrific job of summarizing the bill for you to look at. There's a lot of information here in terms of where the bill is, what committee of reference it's currently in, if it's already passed out of a committee, what the votes were. You can click to see who voted in which way. So I use this website all the time, all day long. You can also look back for prior years. So in addition to tracking the current legislative session, you can be tracking to see, what happened to legislation that has passed in previous sessions. Let me see what I've got on this slide here. This is just more information about when you sign up to use this bill tracking system, you can get an automatic email sent to you on selected bills that you have a special interest in, so that you don't have to be logging in every day to see what happened. And you do that by signing up on the website. It's pretty straightforward. You can also track a bill and learn what lobbyists are registered to lobby on that legislation. And that can be very helpful in identifying who's working in support of your bill, who's working perhaps in opposition to the bill, or who's simply an interested person or party to the bill. So it's very helpful in identifying potential stakeholders. In addition, you can learn more about all of us serving in the Florida House and Senate by clicking on the Representatives or Senators tab, and that will give you a little bit of information. So a lot of you have become Florida Channel junkies as a result of our work through this section, and will actually log on to the Florida Channel website, which I've included in the materials, to watch some of these meetings as they're happening. And so I just so appreciate the involvement of everybody in the section in our legislative process. Lastly, I just wanted to share a few notes, comments about ethics, because the CLE committee wanted to obtain an ethics, part of an ethics credit from this talk. And so I've included some materials in the slides or in the outline on ethics. The parts that I wanted to highlight were, which I thought were important, were the parts about the restrictions on members from soliciting for contributions during the legislative session. That is prohibited by House and Senate rule. And very interesting and important is what we call the gift ban, which basically prohibits members of the legislature from accepting any gift of value from a lobbyist or the principal of a lobbyist. And there's more information about some of those restrictions in the outline. Basically, I just wanted to say that it is such a privilege to be working in the Florida House and working on these issues. And we have term limits now in the Florida legislature, which means that you have a short amount of time to master a very complicated process. It means that the legislative staff has become more important in helping members navigate issues. It means that the lobbying corps has become very important in helping bills move through the process. Some people have been critical of that fact, and I can say that now that I've served 2 terms and I understand a little better the complexity of how these bills need this legislative process, I think I'm in that camp that agrees that having a few gray-haired folks around is probably a good thing. Folks that have served longer than what the term limits currently allow. But anyway, it's been a privilege to be with you all virtually today. Thank you for the opportunity to present some comments to the section at the CLE. I've included in my outline and here in this last slide of the PowerPoint my email and telephone numbers. If anybody wants to reach out to me, particularly as it relates to learning how to track the bills through the process or how to research what happened to legislation in prior sessions, I'd be happy to spend time with you on the websites and guide you through that. Thank you very much and have a great day. Thank you.
Hello. Your next presenter is Lauren Detzel. Lauren is the chair of the Estate and Succession Planning Department with Dean Mead in Orlando. Lauren is the chair of the Elective Share Review Committee, a liaison with the Tax Law Section, and a member of our Executive Council. Lauren will now present on the new Grantor Trust income tax reimbursement power.
I'm going to talk today about the new Grantor Trust income tax reimbursement power. Grantor trusts are among the most used tools that estate planners have today. Why? What is a grantor trust and why is it so good? So a grantor trust is nothing more than an irrevocable trust that a grantor creates for the benefit of beneficiaries and makes gifts to that trust. But it is done in a way, of course, that the grantor doesn't have any rights to the income or principal of the trust because we want it kept out of the grantor's estate. The whole purpose is for these assets to be outside of the grantor's estate for estate tax purposes. But the trust is also drafted in a way that the grantor is the deemed owner of the trust for income tax purposes. So all items of income, deduction, loss, gain are taxed through to the grantor, and the grantor pays all tax related to that income. And why is that a good thing? That's a good thing because if you're a trust beneficiary, it's a great thing because the trust is going to be able to grow at a substantially faster rate because it's not diminished by the payment of income tax. And if you're the grantor, it's actually a good thing also because the payment of the income tax is not treated as a gift to the beneficiaries. If the grantor paid my income tax, it would be a gift and he would have to use exemption against it. But when the trust is drafted in a certain way that it is a grantor trust under the Internal Revenue Code, then paying that income tax is not a gift. Okay. And well-drafted trusts would normally have a provision for the grantor trust to terminate grantor trust status because, after all, the grantor has to pay the income tax. And whereas this might be a good thing for tax purposes, sometime it may be onerous for the grantor to pay those income taxes, and they may want to terminate grantor trust status so they're no longer responsible for that income tax. And most well-drafted trusts would have that provision in there. The problem is that's on or off. So you're either a grantor trust or you're not a grantor trust. And sometimes the mere conversion of a trust from grantor to non-grantor can have tax consequences on its own. It's not unusual for grantors to sell assets to an irrevocable trust and take back a note and have it paid over a long period of time because then the assets in the trust and all appreciation on that asset are outside of their estate. And the big thing is that there's no income tax when you do that sale. It doesn't matter how much appreciation is because the grantor is essentially selling something to himself, and Revenue Ruling 85-13 tells us that's not a tax event. And so, and that's great. But if you have one of those situations and you've got that note outstanding and you terminate grantor trust status, then you're going to pick up income tax. All of that unrealized income that you saved before, a large chunk of it could be taxable to the grantor. There are other reasons why we would want a grantor trust to continue to be a grantor trust. For example, if it owns S corporation stock, it might be easier to qualify to hold S stock as a grantor trust than any other method. And so the absolute best possibility that we could have for grantor trusts would be for the trust to contain a power giving the trustee a discretionary right to reimburse the grantor for income taxes instead of having to turn the grantor trust status off altogether. And that would be the perfect storm of dealing with grantor trusts. Have it be a grantor trust for as long as we want to, be able to turn it off as completely, or to be able to reimburse the grantor for taxes in a particular year. The problem is that before 2004, we were uncertain what the tax consequences would be of retaining that kind of power, putting that kind of a power into an irrevocable trust. We were concerned that having that power just having the mere existence of the power might cause the trust to be included in the grantor's estate for estate tax purposes. And in fact, it's for this reason that a lot of trusts actively prohibited the ability of a trustee to reimburse a grantor for income tax purposes. But then in 2004, we have Revenue Ruling 2004-64, which clears up these our concerns about having this kind of a power in a trust. And it specifically says that the existence of a power does not by itself cause the value of the trust assets to be included in the grantor's gross estate. However, there's always a however with the IRS. However, if there is a prearranged agreement between the trustee and the grantor that they are going to always reimburse, then it could be included in the gross estate. And also, if local law would cause the trust assets to be subject to the claims of the grantor's creditors, then it would cause this trust to be included in the grantor's gross estate. And we all know that in Florida, that if a grantor has a right to something from an irrevocable trust, his creditors have the same right. Okay. So we had to get busy after that and nullify the situation where having this power would cause it to be included in the gross estate because of the availability of it to the grantor's creditors. So in 2007, as part of the new Uniform Trust Code, we included section 736.05051C, which specifically says that the existence of a discretionary power granted to a trustee to reimburse a grantor for income tax would not cause the trust to be subject to the claims of the grantor's creditors. So problem solved. Okay? So at this point, we would have the best possible situation is to have the trust be a grantor trust, have the ability to terminate grantor trust status, and have a power in the trust that allows the trustee from time to time to reimburse the grantor for income taxes. Unfortunately, not all trusts had those provisions. So I told you that a lot of us drafted trusts that specifically prohibited the ability of a trustee to reimburse a grantor. And there's also a lot of trusts that just didn't say anything. It's just silent with regard to any kind of a reimbursement power. So for those two types of trusts, a trust that has a prohibition or a trust that doesn't specifically authorize a trustee, we still have a problem. So and when you look at a trust that has a prohibition, you might say, well, we can fix that, okay? We could go to court and have that amended or changed somehow, maybe not. Maybe the grantor doesn't want to do that. But they said, then you look at, well, we could decant that trust and take out that provision forbidding the reimbursement to the grantor and put a provision in that says the trustee has the power. Unfortunately, you can't do that. You can do the first part of it, which is you can decant the trust and take out the provision that forbids it, but you can't also add in a provision that gives the trustee the discretion to pay. And that's because that would be treated as though you were adding another beneficiary to the trust. And we all know that the decanting rules say you can remove a beneficiary, but you can't add a beneficiary. So decanting in that circumstance only gets us halfway there. And for trusts that are silent, we don't have a result. We don't have anything. So we got to work and drafted new section 736.08145, which provides specifically that a trustee has a discretion, an independent trustee has the discretion, but is not required to reimburse a grantor for income taxes that are due as a result of the income of the trust being included in the grantor's income tax. And so this would solve the problem. We are now giving this discretionary power to the trustee, and in those circumstances, then we would have our trifecta of having the grantor trust, being able to terminate the grantor trust, and now having a power to reimburse the grantor when it is deemed to be a good thing to do. We had to include some additional safeguards designed to prevent some adverse federal gift and or state tax consequences. For example, we had to make sure that if there was any insurance owned by or on the life of the grantor owned by the trust, that those proceeds, the cash value, loans from the life insurance could not be used to reimburse, because that would cause it to be included in the gross estate. And we have some restrictions on the exercise by a trustee. Trustee can't be a beneficiary, can't be a related or subordinate party. And in addition, we have a provision that if there would be a problem, if the application of this new statute would prevent a contribution to the trust from qualifying for an annual gift tax exclusion, for the marital deduction, the charitable deduction, or direct skip treatment for generation skip tax purposes, then the power just doesn't exist. Okay, so it would not apply at all in any of those circumstances. When is this law effective? Well, it was effective July 1st, 2020, but it applies to trusts created at any time. After all, the whole purpose of this trust was to be able to fix all those trusts that are out there that did not have these kinds of provisions in them. There is a provision in the statute to allow the trustee to opt out of the application of this new law. So if the trustee says, I really don't want this power, I don't want to have a grantor asking me, I don't want to have to deal with this at all, I just want to opt out entirely, they can do that. They have to give 60 days notice to the grantor, but a trustee can just opt out of the application of the law. And why did we do an opt-out statute instead of an opt-in statute? And it is because we thought that more trusts and trustees would want to have opt into the statute than opt out, and so we want it to be effective for the most number of trusts. There's also a very important special addition in this statute that provides that a person is not going to be considered a beneficiary of a grantor trust solely by reason of the application of the law. This is really important because without this provision, it is possible that an irrevocable trust could come back into the elective estate for elective share purposes, and we've already seen that you have a problem decanting if the grantor is treated as a beneficiary. So we don't want the grantor to be treated as a beneficiary of this trust at all, simply because there is this discretionary right. So we provide that. We also, we're not going to be a beneficiary for trust accounting purposes. So you're not going to be required to give an accounting to this grantor who might receive funds at some time in reimbursement of income taxes. That is what the statute says, but the story doesn't end there. We also have to look at fiduciary liability of a trustee. Anytime that we like to build in flexibility and trust, and anytime we have a lot of flexibility and give trustees discretion, you always have to look at what is the liability on the trustee for exercising that discretion. And so it may be that in a particular case that it would be a very good idea to reimburse, and none of the beneficiaries would have any problem with that. But it is also very possible that this would put the trustee right in the middle of a problem. And as a result, there was a movement when we were drafting this statute to provide an exculpation clause. So that if a trustee exercised this power and their discretion to make a distribution or pay rather the income tax of the grantor, they would not have any liability as a result of doing that. We thought about that and discussed it at length and decided that that was not appropriate, that it was more appropriate for this to be determined, trustee liability to be determined on a case-by-case basis, looking at all the factors. Just like any discretion that a trustee has, you would look at various factors in determining whether they exercise that discretion in an appropriate manner. We didn't want this to be treated any differently than all of the other trustee powers. And so we are very lucky that now we have great flexibility in the trust for tax purposes, but you have to be aware that it is possible that there could be some trustee issues, and the trustee may not want to exercise this discretionary power to reimburse the grantor. And that's it.
I am pleased to introduce Vinette Gadelia, who practices growth management law as a shareholder with Hopping Green and Sam's in Tallahassee. Vinette is an active member of the Executive Council of the Reptile Section. She chairs the Development and Land Use Committee and is a co-chair of the Membership and Inclusion Committee. Vinette certainly has the expertise and the nimbleness to navigate the quagmire of governmental land development regulations. We are fortunate to have Vinette presenting on growth management and local government governance. Myriad changes, but what real effect?
Hello, Vinette Gadelia here to talk with you today about growth management and local government type regulations that were looked at by Florida's legislature this year. We're going to deal with a couple of issues. First, impact fees. Talk about what the legislature did this year on impact fees following from pretty significant changes it made back in 2019. Next, we're going to move to neighborhood improvement districts. Minor changes there, but we will talk a bit about those as well. And then finally, we'll do a postmortem on SB 410. 410 was the omnibus growth management bill for this year. However, it was vetoed a day before it was to go into effect, and so we'll talk a bit about what resulted in that bill being vetoed. So for impact fees, Florida Impact Fee Act is codified in the statutes at Section 163.31801. We'll talk just a bit about what happened in 2020 in SB 1066, right? We need to look at what happened in 2019 in order to understand what all happened for 2020. And to start us off, as a general reminder, and I'm sure you all are aware of this, impact fees are assessed against new development. And the impact fees are used to pay for roads, schools, water, wastewater, solid waste facilities, drainage, other types of facilities. And so we'll talk a little bit about what happened with impact fees. So for 2019, the legislature enacted or put in place the dual rational nexus test into Florida statutes. This has been a part of impact fee law. It's something that when you were a first-year law student, you likely were taught about the dual rational nexus test. That has been a part of the Constitution and a part of case law. But last year in 2019, the legislature went ahead and put that into Florida statutes. And so as a reminder, the dual rational nexus test requires an impact fee to be proportional, right? Have a reasonable connection, or in other words, a rational nexus between the impact of new development, right? And then the benefit and the cost that a local government is trying to assess against that development. So that was finally placed into Florida statutes last year in 2019. In addition, in 2019, the legislature put in place in Section 163.31801 sub 5 of the Impact Fee Act, a provision that says if a local government increases its impact fee rates, the holder of any credits, regardless of how those credits came about, if they came about through a concurrency provision, through a GRI provision, or otherwise, but any credits which were in existence before the increase is entitled to the full benefit of the intensity or density prepaid by the credit balance, right? And so what that means, in other words, is if you paid in 2018 for 100 residential units, impact fee credits, in 2019, the local government then amended its rules to increase the cost of an impact fee credit for a residential unit, that it may not then determine when you come in for development that you have less than the value of 100 units. What you paid for in 2018 remains true moving forth, and they cannot devalue the value of your 100 credits that you paid for. So that language was put in place to address that issue. So now real quickly, let's look at 2020 amendments. SB 1066, signed by the governor on June 20th of 2020 and effective as of July 1st. So the world in which we live is now controlled by these provisions. One of the first changes that was made was to prohibit the application of a new or increased impact fee to pending permit applications unless the result is to reduce the total number or total impact fees or mitigation costs imposed. And so, in other words, again, this ties back to the concept of zoning in progress, which those of us that practice land use and zoning law deal with typically. What happens when your application is in process and a change is made to the regulations before you can get to adoption? And sometimes, if you have a large project, for instance, a local government may consider it best to try to get a change or an increase in an impact fee approved ahead of that project being approved from a permit perspective in order to apply the larger fee. So what this says is, no, if your application is in, what applies to you is the state of the law on impact fees as it existed on the date that you got your application in, not the change that may have been processed while you were going through review. So this is very important, and that is a part of what is approved in this year's bill. In addition, the legislature determined that it was necessary to add the following language to the statutes. Notwithstanding any charter provision, comprehensive plan policy, ordinance, or resolution, a local government must credit against the collection of the impact fee any contribution related to public education facilities. And so this was a way to ensure that language they had previously adopted, saying that for schools where a developer may have paid concurrency fees or otherwise agreed to construct a school, for instance, that the value of that those costs had to be balanced or applied against the impact fees. And a local government could not determine, for instance, that it would only give a proportion of credit against what the developer did. And so where a developer is doing, in particular, large projects, and as a part of that project, it decides to construct a school. It constructs a school. It dedicates the land for the construction. It does the planning, the permitting, all of those efforts. The local government must give the developer dollar for dollar credit against impact fees for that construction effort for getting the school up and running. So it clarifies that you may not, as a local government, then go back and amend your charter, amend your comprehensive plan, amend through an ordinance your land development code, or use any other way of making changes to have a developer not get full credit for the construction of the school, for the payment of fees under proportionate share agreement or any other type of agreement. And then the other final major thing that the legislature did this year on impact fees is to provide that impact fee credits are assignable and transferable at any time after establishment within the same impact fee zone or district or an adjoining zone or district. This is further clarification on this issue. And there are numerous local governments in the state that have language in their codes that will say that you may not assign extra credits or transfer credits outside of the district where the development that you paid for exists. And this makes it very difficult where you have, for instance, constructed a project, you have extra impact fee credits left to really be able to market that or to use that. The legislature now says that those credits can be applied within the zone or in an adjoining zone. And there are several local governments that have provisions that would run counter to this. First, Palm Beach County No credit may be assigned, delegated, or otherwise conveyed outside the boundaries of the development that originally received the credit. And then there are similar provisions in Manatee County and again in Hillsborough County. And these provisions are all addressed in your materials. You can see them there. So quickly, neighborhood improvement districts. And there are not many of these. There are 25 by count of the Department of Economic Opportunity, such districts in the state. Not what we're most familiar with when we think about special districts. We typically think of CDDs, for instance, community development districts. But these districts had some changes this year. The legislature went ahead and said that for ordinances adopted implementing such districts, increase the number of members that can serve on a board to allow 3, 5, or 7 members, and increases the term of board members to 4 years, requires members to now be landowners rather than residents within the district boundaries, and therefore subject to ad valorem taxation, and requires counties or municipalities to specify the number of directors in the ordinance creating the district. There were other minor cleanup changes in the language, but that really was it for special neighborhood improvement districts. And so now to SB 410, which, as we discussed early on here, it was the Omnibus Growth Management Bill of this year, and it was vetoed based on issues really tied to annexation and some local government advocacy on that issue. Why talk about it now? Because there are particular provisions within that legislation that we think will come back up. And so likely or hopefully next year or the year after, when we give our presentation, these things may come up. One of those things was language directing DEO, the Department of Economic Opportunity, to give preference when awarding grants to a county that has a population of 200,000 or less, and municipalities within that county for assistance in conducting MCOR's land use studies. And for anyone who's been paying attention to growth management over the past several years, this concept of the MCORs has been significant. And these roadways are proposed to go through very rural local governments. And so this would direct more funding to those local governments to be able to do studies to discuss the impact of the MCORs. In addition, there's an important provision on development agreements that would be helpful that says that within the boundaries of the project, typically now, you would have to get all property owners to sign off on a request to amend a development agreement or to cancel it. And so this new language would say that only those who would be directly impacted by the change are required to sign off on an application to amend. And so that will make things a bit easier as well. So why was 410 vetoed? The language in the governor's veto bill says, the legislature passed SB 410, which in part provides that a county charter provision or comprehensive plan policy adopted after January 1, 2020 may not impose a limitation on lands within a municipality unless the municipality adopts the same limitation. This broad provision preempts, and this is key, preempts charter county powers and unnecessarily risks frustrating the will of the voters in Charter County. And for these reasons, I withhold my approval of Senate Bill 410 and do hereby veto the same. And so this veto memo came again after significant advocacy by counties, and in addition by those in support of counties generally. But the real issue was annexation and about what happens when property is annexed into a municipality. Who gets to determine what development happens, what type of development happens? Typically, cities govern cities, counties govern counties. And this language was making it clear that a county could not create law saying that certain types of development could not happen on an area, even after a municipality annexes that area. And so the governor, I think, based on the lobbying, determined that that was inappropriate. And so that got vetoed. And again, objections and proponents of the legislation was significant, and you'll have those in your materials. It kind of reflects what the basis was of that objection. Another change that the local governments took issue with that was a part of that bill and ultimately also resulted in significant opposition was a property rights element requirement that said you had to adopt property rights as an element in your comprehensive plan and gave you some model language that you could use for that. But local governments took issue with the impact of that kind of property rights requirement and how it would potentially create issues for them as they tried to govern within their jurisdictions. And so that also became one of the reasons that the bill was vetoed. So that, in summary, is what was looked at, reviewed by the legislature this past year, and we'll see what of the things that were vetoed in SB 410 come back next year. Appreciate your time. Thank you.
We are now going to take a break for lunch. We will resume the program at 1:30, and you don't want to be late. There's a lot more information, and you don't want to miss the chance to win one of the 2 remaining trips to the breakers for next year's Legislative Update program.
Hello, and welcome back from the lunch break. Our next topic will be co-presented by Michael Hargett and Patrick Duffy. Michael is a partner with Barnett Bolt in Tampa. Michael is the chair of the litigation committee, a member of the Real Property Problem Studies Committee, the Law School Mentoring Committee, and a member of our executive council. Patrick is an attorney with Holland & Knight's Private Wealth Services Group in Tampa. Patrick is the vice chair of the Model and Uniform Acts Committee and a member of our executive council. Michael and Patrick will now co-present on Florida's Uniform Partition Heirs Property Act, the off-ramp on the partition highway.
Good afternoon and welcome to our guided tour of the Florida Uniform Partition of Heirs Property Act. Florida's Act, which I'll refer to as just the Act today for purposes of brevity, is a version of the Uniform Partition of Heirs Property Act, which dates back to 2010. Florida's Act and the Uniform Act were created to deal with a very specific set of issues that we see with inherited real property, particularly inherited real property that's owned as tenants in common. Now, those issues we'll get into a little bit later, but they all stem from one thing, and that's that there's not clear title to the property and that there's then opened up for partition, which is inherent to ownership as tenants by the entirety, or excuse me, tenants in common. This is a popular act. In fact, as I understand, it's the most popular act ever promulgated by the Uniform Law Commission. It's been enacted now in 20 jurisdictions, including Florida, but other jurisdictions like Georgia, New York, Illinois, Texas have all enacted versions of it. Now, Florida's Act was enacted not just to deal with those problems that the Uniform Law Commission has identified, but also to help Florida farmers. That might sound counterintuitive, but this all ties into the 2018 Federal Farm Bill. That Farm Bill did a lot of things, but among them was tying two particular kinds of benefits to adoption of the act by a state. So without getting too far into the weeds, the first benefit is a special kind of farm loan. And that's very helpful to farmers, but even more helpful is the ability to get a farm number, the easy ability to get a farm number, which is equivalent to an EIN for farms and gives the owners access to a whole host of federal benefits. So I think by now we beg the question, what exactly is heirs property? Heirs property is probably about what you think it is. It's defined now in 64-202 sub 6 of the Act, and it really has 5 ingredients. First, real property, no personality, no tangibles, no intangible personal property, just real property. Second, it's got to be owned as tenants in common. None of the other tenant ownership forms will apply. Third, it can't be subject to a written agreement. If the tenants all agreed to have property, have an agreement governing the property, the act doesn't apply unless you opt in. Fourth, you have to have property that is inherited. The actual definition is that it's been acquired by a relative, but the purpose of that requirement is simply that it's not for people who opted into tenants in common ownership on their own. They didn't go and buy the property on their own with some strangers and then wanted to get into this act. Finally, it's got to be substantially family owned. Now, the act provides 3 prongs to determine this requirement, and they're a little bit technical. They're numbers based. The first, 20% or more of the interests are held by relatives. Relatives is a defined term in the Act, but again, doesn't depart too much from what you think it means. So 20% of the interests. 2, 20% or more of the interests are held by someone who acquired it from a relative. 3, 20% or more of the co-tenants are relatives. So the third prong differs from the first 2 in that it doesn't measure the percentage of the interest, it just measures the number of owners. So if those owners own 10% of the property collectively, as long as they represent 20% or more of the number of co-tenants, that problem is satisfied. So what are the problems that the Uniform Law Commission saw and that the Florida legislature saw that they wanted to act on? First, as I mentioned, title issues. This property that we're dealing with typically is inherited across multiple generations through intestacy, so it doesn't have clear title. That then trickles on to other problems, and the owner, the owners, but particularly the occupant, can't qualify for state and federal benefits. But there's a lot of other things they can't do too. They can't get a mortgage on the property, for example. Third, and most acute, is what I'm going to call weaponized partition actions. I urge you to go look, if you're interested, at the comments to the Uniform Act, because they document this in great detail. But in a nutshell, what I mean by this are partition actions that were brought by developers who purchased interest in property from a laughing heir. They did an heir search and they found someone who owned a tiny fraction of the property, maybe didn't even know they owned it, purchased that interest, got standing, brought a partition action, and then forced a judicial sale of the property. And then at the judicial sale, bought the property often for pennies on the dollar. Mike might get into this later, but the reason that they can do that is because of the judicial sale. Not only is there not much public notice of the judicial sale, but generally there's a requirement that you pay in cash at the sale. So the financing, there's no opportunity for financing contingency, which is the way so many people own property. The Uniform Commission got into this in their comments in more detail, but this problem is particularly acute for poor, minority, and Black communities. And that is why this act has become so popular and enacted in so many states to fix this problem. So we're going to go through a little bit the flow chart here. This was created by Mike and his team back when we were examining the Uniform Act last year. We've since updated it, of course, so it applies to the Florida Act, but I think it gives you a good perspective on what we need to do. So, as we talked about, is there written agreement? If there is, that controls. If there isn't, now we look to heirs property. Is it heirs property? Go through the definition we just talked about. If it's not, regular partition action applies. Now, the twist is parties, whether there's written agreement or not, can opt in to the to the act. So once we've determined that the act applies, we now move on to the determination of value by the court. This is a very important step. It's the first step in the process, and it really, to a large extent, influences the later steps, directly and indirectly. So first, in determining value, which the court has to do, the court will adopt the value that the parties agree on if they can. Let's assume for a second that it's a partition action and there's going to be a disagreement on value. In that case, the court appoints an appraiser who goes, appraises the property, files an appraisal with the court. Then the court has an evidentiary hearing. They review the appraisal. They look at other evidence. Parties at that point can object to the appraisal. They can give their own they can produce their own appraisals. They can produce their own evidence. And then the court makes a determination. Now, the court is empowered to sidestep the appraisal part of the process if the appraisal is essentially too expensive. It doesn't make sense in relation to the value of the property. Now, given that most residential appraisals are relatively inexpensive, we don't anticipate this to be an issue that will cause problems. That said, it's a possibility for the court to deal with. Now, the next steps in the process are going to be determined a little bit by how the petition for partition was worded. And so Mike's is going to take you through that part of the process.
Good afternoon. Before I start, I do want to thank the members of the Real Property Litigation Subcommittee who studied the Act for over a year and provided the legislature with technical support during its adoption. Additionally, I'd like to thank two University of Florida law students Andrea Hartung and Stephanie Velo, who were instrumental members of the subcommittee and who created the first drafts for the flow charts that are in your materials. As a starting point, I recommend that you open the second page of your materials to the big flow chart that you can see on the screen with me so you can stay oriented. From a big picture perspective, following the course determination of value that Patrick just discussed, you're going to enter this in one of two ways. If the petitioner is either going to have requested a partition by sale or a partition in kind. And you can come out of the act in one of three manners. On the far left, all the interest could be reallocated as part of the buyout process. The property could be sold as part of an open market sale, or a partition in kind could be completed. With those three alternatives in mind, as a roadmap this afternoon, we're going to provide you with some practice pointers and cover the remaining key concepts of the Act, which include 1, the buyout process, 2, strengthening Florida's strong preference for partition in kind, 3, the concept of volunty, and the open market sale. First is a practice pointer, and Patrick mentioned this. You very likely may have to establish ownership. A partition action itself does not do that, so you may need a quiet title action and probate proceeding to eliminate any outstanding ownership issues. Unfortunately, there's no statutory authority allowing a determination of heirs property in a quiet title action or a probate proceeding. Therefore, if you have disputed ownership and you desire a farm number that Patrick mentioned previously through the determination of heirs property, your complaint is going to have both a quiet title action or probate proceeding and also a partition count. Now, once the determination of value has been made that Patrick discussed, we will assume, for the purposes of our presentation this afternoon, that the petitioner has requested partition and sale. At this point, you hit one of the Act's key features, the mandatory buyout process. This process is similar to what many of you may have seen in a limited liability company operating agreement. The interests of the party requesting partition are offered to the remaining co-tenants pro rata with their ownership interests. Let's walk through an example. And assuming that the court determined that the value of the property was $100,000, there were 3 owners, a 60% owner, a 30% owner, and a 10% owner. And the 10% owner is the plaintiff, and they were the one that requested partition by sale. The 10% owner's interest is offered to the other 2 members, 2/3 to the 60% owner and 1/3 to the 30% owner. If each of the owners pays their share of the $10,000 cost, that would be $6,666 to the 60% owner and $3,333 to the 30% owner. Then the ownership is reallocated and the resulting ownership is now 2/3, 1/3. However, if one of the tenants, the co-tenants, fails to pay, then there's a second round. In our prior example, assume that the 30% owner could not come up with the $3,333. Then the 60% owner is given the right to buy that portion, and if the 60% owner pays the entire $10,000, they then own 70% of the property, and the ownership is reallocated. A couple of practice pointers at this point in time. First, help your judge with the notice requirements. One of the Act's weaknesses is that it is judicially driven, not attorney driven. During the buyout process, there are multiple notices that the court is required to send on a schedule. We recommend that you provide your judge with draft notices to support the court's understanding of the new Act and aid this process. It's going to be new for everyone, and it's unusual for courts to be required to send out so many notices on such a short timetable. Practice point number 3, which is consolidation utilizing section 64.2077. Going back to our example, if the 30% owner did not appear in the lawsuit, then the 60% owner, if they have the resources, we recommend that the 60% owner request to purchase the 30% owner, and if they pay the $30,000, then the property ownership would be consolidated and the 60% owner would end up with a full, clean ownership of the property. However, if a single co-tenant requests partition in kind, then you do not end at the buyout procedures. And there are a set of mandatory considerations that are designed to strengthen Florida's already well-established preference for partition in kind. Those mandatory considerations are in addition to traditional economic concepts. For example, the duration of ownership, a co-tenant's use and sentimental attachment to the property. Further, the commissioners who are responsible to make the determination may not consider any one factor as determinative without weighing the totality of all the relevant factors and circumstances. Essentially, the commissioners may not look at raw economics to avoid partition in kind. Hopefully this image of a Fort Myers burrowing owl will get your attention after lunch, and even if you have no interest in partition actions, at least will expand your vocabulary this afternoon. The Act includes the concept of owlty, which is the addition of cash to a parcel in a partition action, which is designed to eliminate prejudice and equalize their values. As a practice pointer, if your client desires partition in kind and has the resources, we recommend that you notify the court and the commissioners of this fact to increase the probability of partition in kind without prejudice. Now, absent prejudice, the partition in kind is completed. However, if there is prejudice, then a partition in kind cannot be completed, and we hit the final key feature of the Act, which is the requirement for an open market sale. The only way to avoid an open market sale is for the court to find that a sale by sealed bids or an auction would be economically advantageous. In an open market sale, the parties have 10 days to agree on a licensed broker to offer the property for sale. Following the 10-day period, the court appoints a disinterested broker, establishes a reasonable commission, and sets the terms and conditions for the sale. If the sale is not completed within a reasonable time, the court has flexibility, including extending the time period. The court could revalue the property. The court could sell the property, award it to an offer that was received below the determination of value, or allow sale by sealed bid or by auction. So the court gets a lot of freedom if the property is not sold. Now, in your materials, you'll find flow charts, a motion for determination of heirs property, an order determining heirs property, and a draft complaint. Please understand these drafts are over the top with citation references and with recommendations, many of which are not required. They're there to aid your overall understanding in how the Act works. Additional considerations as we close, and you'll see these in a lot of the draft documents. First, the use of verified pleadings can be very beneficial in determining ownership, which can be difficult and time-consuming. Further, verified pleadings will support a quick determination of heirs property. Secondly, as Patrick previously mentioned, appraise the property, particularly if the cost is reasonable, particularly if your client desires to consolidate ownership. Further, the appraisal may support agreement and avoid additional expenses at time early on in the determination of value time period, and the competent appraisal will likely be considered by the court, commissioners, and brokers as we go through the Act. Third, as we mentioned briefly before, go ahead and look at your adjustments to the value that support an accounting, particularly if your client is the one that has paid property taxes or paid for a new roof on the property. You want to, if you're in that situation, you want to make sure you begin that preparation early and include it in your complaint or your response. Finally, if your plan is for a partition in kind, prepare the plan. You should consider whether you want to get surveys, legal descriptions, and come up with a recommended partition. You should identify mandatory factors within those factors that we discussed previously that support your client's position, and a volunteer owlty if you can. One final word of caution is the buyout process might change the ownership. So keep all those things in mind. Hopefully we provided you with a good package to aid your implementation of the new act, and feel free to contact me if you have follow-up questions. Again, Patrick and I thank you. Have a good afternoon.
Our next presenter is Tay Bronner. Tay has received numerous awards from the section, including being the first recipient of the Rising Star Award in 2008. Tay has also been awarded the John Arthur Jones Annual Service Award in 2009 and the Robert C. Scott Memorial Award in 2018. Tay's presentation is Small Bank Account, No Problem. New Techniques for Distribution Without Administration.
My speech today is regarding small bank accounts. It's House Bill 1439 creates two new procedures to deal with summary, summary or small administration for very small accounts. The bill also amends Section 655.059 of Florida statutes, which we'll talk about last, that provides financial institutions with additional authority to disclose information about the decedent's accounts to family members without prior court approval and in limited circumstances to give them broader authority to assist us in providing us with the information as practitioners that we need to do these small administrations. Okay, the first portion of this statute is Section 735.303, which is entitled Payment to Successor Without Court Proceedings. And this is what we're going to refer to as the banker's statute. Basically, what happened is that the bankers came to the section with the problem that they felt that there were so many small bank accounts out there that did not have any information, that didn't have an effective way of transferring those accounts to the beneficiaries after someone passed away. Basically, the current alternatives were summary administration, disposition without administration, or unclaimed property. And so they wanted a simpler way to be able to do this. The real property section was very concerned that if they wanted to do an administration without any court involvement, and the real property section was afraid that that would be ripe for fraud. So we worked together and we came up with an alternative, actually two alternatives, one for extremely small accounts and one for larger accounts, that balances the need for the transfer of those accounts without the involvement of an attorney, and in some instances without the involvement of a court, against the potential fraud that could occur. Okay, so the essence or the main parts of this first new section 735.303, which involves no court involvement, is contained in subsection 2 of that section. And in subsection 2, it states that a financial institution in this estate may pay to a family member, which is a defined term, of a decedent without any court proceeding, order, or judgment, the funds on deposit in all qualified accounts, again, a defined term, all the defined terms are in red, of the decedent at the financial institution if the total amount of the combined funds in the qualified accounts do not exceed an aggregate value of $1,000 and more than 6 months has passed since the decedent's date of death. Okay, that's a lot to kind of digest in there, and there's a lot of information in there. But essentially how this statute works is that if you have a qualified account of less than $1,000, and again, a qualified account is going to be an account that it means is a depository account or a certificate of deposit held by a financial institution. It's not going to include a stock account, a brokerage account, intangible personal property outside of just the straight bank accounts, or any interest in a corporation. So we're really limited down to what we're doing here. It also provides that the family member is going to come and file the claim to receive these funds, but the family member is not necessarily the person entitled to the funds. Under the statute, as I said, family member is a defined term, and that family member means first the surviving spouse of the decedent, if there is one. If there is no surviving spouse, family member is going to be the adult child of a decedent. If there's no spouse or adult child, then the family member will be the adult descendant of the decedent. And if there's no adult surviving spouse, adult child, adult descendant, then that the parent of the decedent is the family member who has the right to go to the bank to claim these funds. But as I said, just because the family member can claim the funds, that doesn't mean the family member is the person entitled to the funds. In fact, the family member who withdraws the funds under this section becomes personally liable to the creditors of the decedent and to any other person rightfully entitled to the funds under the probate code to the extent of the amount paid exceeds the amount properly attributable to the family member's share. So for instance, if there's a prenuptial agreement or something along those lines that the surviving spouse claims it and the money actually belongs to the children of the decedent, because we're only talking about intestate estates and using the statute, then that surviving spouse would be entitled to give it to it. Or for instance, if one family member, one adult child claimed the funds and kept the funds, they would then be liable to the other adult children who would also be entitled under the intestate succession. One of the problems with this statute is it puts the burden on determining who's entitled to the funds on the family member who is claiming the funds, and the bank is released from all liability. So it is a little bit, I think, of a dangerous situation if you have a family member going to the bank who's defined under the statute who doesn't understand they can't keep all the money. And then the family members have to fight among themselves. The bank is taken out of any liability, and any action to enforce it, it has to be filed against the family member. The family member claims these funds by completing an affidavit, and presumably this affidavit is going to be something that will be provided to them by the bank. There's a form in the statute for the affidavit. In the affidavit, the family member must state the date of death and the last residence of the decedent. They have to make a statement that all qualified accounts known to the affiant in all financial institutions does not exceed the total of $1,000. Now you'll notice that, and I made a footnote in my outline, that differs slightly from the subsection 2 of the statute that says it's all qualified accounts, it's limited to all qualified accounts less than $1,000 at that financial institution. The affidavit says all financial institutions. And I think the intent behind the statute was to limit the use of the statute to $1,000 total. They also have to state that there's no PR or probate or summary, because as I said, this only applies to intestate estates, that they have no knowledge of a will or an agreement to distribute the decedent's estate, that they acknowledge that the payment of these funds constitutes a full release and discharge of the financial institution's obligations, and that they understand that they're going to become personally liable to the creditors and to the other people entitled to the funds when they withdraw this money. And then they also have to make a statement acknowledging that the affiant understands that making false statements in the affidavit may be punishable by a criminal offense. So it's a pretty harsh punishment if you do something wrong. There is no court involvement in this. It's all handled by the financial institution. There's no verification of the information. The financial institution has no duty to verify that information. Yet there is this harsh charge, this harsh punishment that if you make a false statement in an affidavit, they can be charged with that. So that's just something to be very concerned about if your clients are going to use this type of procedure, that there are some pretty harsh punishments if you make a false statement and you take the money. And it's not going to be the bank that's going to be responsible. It's going to be that person who took those funds. Okay. Now, the second procedure, which I'm going to refer to as the reptile proposal, is meant for slightly larger accounts. So in this situation, we're going to go up to $10,000 of exempt property, non-exempt property that we're going to allow. And so this becomes essentially a bridge a statute to bridge the gap between the current disposition without administration and the current summer administration. It's really a hybrid of both procedures, and so it has those built-in protections of the summer administration, but it allows someone to go and do a disposition without administration without the help of an attorney. It's done with the clerk at the clerk's office, and there's no attorney required. So it removes that impediment of having to pay the attorney's fees to get access to these smaller accounts under $10,000, but it also builds in the protections that we're doing this through a court. Okay, so the essence of this statute is that it's worded very similar to the disposition without administration statute, is that no administration shall be required of formal proceedings when the stated decedent who has died intestate, again, we're only dealing with intestate estates, leaving only personal property exempt under the provisions of 732-402, personal property exempt from claims under the Constitution, non-exempt personal property to the value which does not exceed $10,000. And then in determining those amounts, you're not going to count in the preferred funeral expenses and reasonable and necessary medical and hospital expenses of the last 60 days. So that's really the class 2 and class 4 claims. And then it gives you the requirement that to use the statute, the decedent has to be deceased for more than 1 year. We don't want someone running down to the courthouse the week after someone passes away to use this disposition without administration, because we want time for someone to locate a will. We don't want to take away the right of people to devise their property, their constitutional right in the state of Florida for you to devise your property as you wish. We want to make sure that everyone has enough time to locate that will if it can't be located. Now, I want to point out that you can pass quite a bit of property under this statute. For the personal property exempt under 732-402, you have personal property furnishings within the decedent's usual place of abode up to $20,000. You also have 2 vehicles that are regularly used by the decedent or members of his family. You have $1,000 under the Florida Constitution for exempt personal property, and then you have that $10,000 of non-exempt property in addition to the amount of the preferred funeral expenses and the medical and hospital expenses of the last 60 days. So you really could be passing quite a bit of information, quite a bit of assets here without ever having to open an administration or retain an attorney. As I said, there's no attorney required. And in this situation, the clerk can help and complete the petition or affidavit. And this is going to be done through a sworn affidavit or a sworn petition. Because we can pass so much property this way, we did want to build in the protections that are built into the summary administration. So similar to summary administration, recipients of the non-exempt property, so that $10,000 of non-exempt property, are going to remain liable for a pro rata share of all the lawful claims that are not otherwise barred under 733-710 of the 2-year statute of repose against the estate of the decedent, but only to the extent of the value on the date of the distribution of the personal property actually received by each recipient. Additionally, any heir or devotee of the decedent who was lawfully entitled to a share in the estate was not properly included in the distribution may enforce all rights against the affiant, the person who filed this affidavit or sworn petition, and those who received distribution of property. And if they're successful, they're entitled to attorney's fees. Again, this mirrors the provisions in the summary administration. Again, we're going to also impose in this type of disposition without administration the service and the joinder requirements that we find in the petition for summary administration. So under this statute, the affidavit, which can be an affidavit or a sworn petition, is going to have to be signed and verified by the surviving spouse and by any heirs at law, unless those heirs at law are going to receive their full intestate share under the proposed distribution. Before filing the affidavit, the affiant has to make a diligent search and reasonable inquiry for any known and reasonably ascertainable creditors. Because we're giving $10,000 of non-exempt asset, we want to make sure that we're not taking away the right of creditors, that they would be entitled to those funds before the beneficiaries. And the proposed distribution must make provision for payment of those creditors to the extent that the assets are available. So you can have an estate that has creditors and still use this type of administration as long as you're making payment to those creditors for that administration, to the extent the assets available. Again, it's the same danger you have when you use a summary administration for that type of administration, as maybe there's a creditor who comes back later that had a higher priority and is going to go after those assets. If you don't make provision for payment of the creditors have to consent to the proposed distribution. So they can say we waive our right to be paid, but they have to consent to that. We also have the service requirements that the affidavit has to be served in the manner or formal notice, so by certified mail or Federal Express signed signature required, upon all heirs at law who haven't joined in the affidavit. So if they're receiving their full intestate share, but they haven't joined in the affidavit, you have the ability to serve them instead of having them join. All known and reasonably ascertainable creditors of the decedent, and if the decedent's over the age of 55, you're going to have to also serve in the manner of formal notice on the Agency for Healthcare Administration. I want to note here that the surviving spouse cannot just be served, she has to join. He or she is the only person that must join in the petition. You can't provide full distribution to her or him and then simply serve them in the manner of formal notice. That's not going to cut it. They have to join. Some of the protections that are built in, again, are the recipients of the non-exempt property are going to remain liable for their pro rata share of the lawful claims and to the other beneficiaries who should have received the property. Any heir or devotee of the decedent who was lawfully entitled to a share and didn't get it can enforce their rights against the person who initiated the procedure and against those who received the property. And the clerk, this is, I think, the most important point, the clerk is here to verify the information in the affidavit or the sworn petition. They're going to request copies of the relevant funeral expenses, the medical and hospital bills, and all evidence relating to the relationship of the decedent. So they're going to verify that the information's there. They're also there to explain the intestate succession statute. So you have somebody who has some legal knowledge that's assisting in the preparation of this pleading. So that's why we felt comfortable going to the higher amount of the non-exempt property. The final aspect to this statute, I only have 10 minutes, so we're kind of flying through all this, but the final aspect to this new House bill is the changes to section 655.059. And that's the disclosure of information by financial institutions. One of the biggest problems with the summary administrations or disposition without administration or small administrations is that you don't have access to the information you need to complete the petitions. A petition for summary administration or any of these ones we've discussed today, you're going to need to know how much is in that account to determine whether you fall within the parameters of those statutes. The difficult part is a lot of the bank account information is delivered virtually now by email, or a wrongdoer has come in and taken all that information or diverted the mail, and you just don't have access to the information. So you don't know if you fall within the right parameters. Right now, the financial institutions are not permitted to give you any information about the accounts except upon express authorization by the account holder as to his or her accounts. And so, for instance, in a summary administration, they can't release the information to tell you how much is in the account, but the court's going to require you to include on the petition for summary administration the amount, or at least a very close approximate of what's in the account. So a lot of times you're stuck issuing a subpoena to the bank to have that information released, or you have to just go with a formal administration and incur additional fees on behalf of your clients. So this new statute creates these new exceptions, and there's two new exceptions. The first exception deals with the affidavit and the account smaller than $1,000 under that banker statute 735.304. And in that, this exception allows a financial institution to disclose the existence and the amount on deposit in any qualified account of a decedent pursuant to this new statute. Again, qualified account is a defined term we went over. And they can also provide a copy of the affidavit delivered to that financial institution, which they're required to retain, by the way, to a person authorized to receive such information under the statute, so to any family member or qualified beneficiary. In subsection 4, there's a new exception for the financial institution to disclose the existence of and the amounts on deposit in an individual account of a decedent to a petitioner that filed with the court a petition pursuant to the small ancillary administration or summary administration, or to an affiant that filed with the court an affidavit for disposition without administration under the two forms of disposition without administration, the traditional form and the new form that we discussed. So they're going to be able to assist in providing that information to you in preparing those petitions. And I think that's going to be extremely helpful. Now, again, I want to warn you that this is only that the bank may provide that information. It doesn't require the bank to provide that information. So it remains to be seen whether financial institutions across the board will cooperate. It also requires that you have filed a petition for administration or an affidavit under the disposition without administration. So you may have to file a petition and make an estimated amount and then go back and amend that petition, but at least it doesn't require you to go that extra step of having the subpoena issued. And that is the summary of my House Bill 1439, and that's the end of my presentation. Thank you.
Our next presenter is Manuel Farash, also known as Manny. Manny is triple board certified in real estate, business litigation, and appellate law. He was named Board Certified Lawyer of the Year in 2019. He's the co-vice chair of Real Property Litigation, co-vice chair of the Legislation Committee, and currently chairs the Real Property Certification Review Course Committee. Manny's presentation is on Senate Bill 838, the Corporations Glitch Bill, and much, much more.
Hello, this is Manny Faraj. We're going to talk about SB 838, which is the corporation's glitch bill. And we're going to talk about much, much more than just the corporation's glitch bill. You know, a lot of folks have had problems with this particular bill in the sense of trying to get their arms around it. It's really not that complicated, but what most folks don't have is sort of appreciation for what came before SB 838 and the reason for the predecessor corporate bill and why SB 838 was necessary. And once you understand that, and once you understand the Florida adaptations, it really is pretty straightforward, pretty easy to understand. So let's get into it. We're talking SB 838. Now, where does it come from? Well, actually, if you go way back, just a couple of years, it comes from the Model Business Corporation Act. The MBCA, Model Business Corporation Act, is a project of the ABA. ABA started doing this about 1950, and it's been worked on ever since then. The idea behind the MBCA, as you might imagine, was a good deal of uniformity amongst the different states, a nationwide uniformity to some degree, so that corporate practice could travel interstate. As you might imagine, starting in 1950 and coming to this present day, the corporate practice in the United States often is not just limited to one state. Corporation may have interstate commerce in other states. And so having different corporate acts between different states was a bit problematic. Now, the MBCA was last revised in 2016. And when it was revised in 2016, the folks who practice here in Florida said, you know what? Maybe we should start thinking about updating the Florida Corporations Act. The MBCA is highly adopted. It's been adopted in all 50 states and the District of Columbia. And of course, there are state-specific adaptations, and many of those states make the MBCA, even though there's a goal of uniformity, a little bit easier to understand for a particular state and to make it work with that state's organic law. Consider the MBCA a comprehensive corporate bill, and understand what it really needs is uniformity in order for it to work. And then you'll start to appreciate SB 838. All right, let's talk about Florida here for a second. Here are the Florida needs for corporate law. We need some uniformity with national laws. And when I say some, I mean some but not complete. Why? Because Florida has different needs than perhaps, say, an Ohio or a California. Our organic law is different than those particular states, and Florida corporations and businesses are different than those particular states. So we're always doing a little bit of a balancing act when it comes to the MBCA, when we're adapting it to Florida, because we want that uniformity, but you also want Florida-specific items there. And we also want Florida control. Consider this. The preeminent, you might want to call it that, a law, corporate law, business law in this country is Delaware, which is all fine and good, right? Many of us have dealt with Delaware corporations and businesses because our clients end up organizing their businesses through Delaware entities. That's fine. But there are problems with that. One is that Delaware, the state legislature of Delaware, and the Delaware courts, as well-intentioned as they might be, well, they don't care about Florida as much as they do about Delaware. And certainly they have a national perspective, but Florida's a completely different perspective. Keep in mind that Florida is the third largest state in the union, and if Florida's economy were going to be considered an independent country's economy, its GDP would rank in the dozens of worldwide GDPs. So it's a large, large economy. And so we got these two issues, the Florida control and the Florida input. And look, it doesn't help that Florida practitioners were always concerned about the fact that, hey, if my client formed its business in Delaware, apart from the input, apart from the control issue, is the fact that we, Florida practitioners, would have to learn a completely different set of laws in order to properly advise our clients. I understand we're not Delaware lawyers, but look, clients call us all the time and ask us for a quick question, and then we'd have to run off to the Delaware statutes to try to figure it out. So there's some reasons for the MBCA to be enacted, and some good reasons. Now, even though we've got the MBCA, we still have to harmonize it with Florida needs and Florida laws. And there's some ways we do that. One of the things that the MBCA does in order to create its uniformity is it creates default provisions throughout the Act. What those default provisions do is they say, this is what the law is going to be unless you affirmatively opt out. Now, these default provisions are important because what we want to do is create that uniformity that's going to help Florida practitioners and is going to help Florida businesses. Why is uniformity so important? If we care about Florida law, Florida input, Florida control, why is uniformity so important? Well, think about this. If you are representing a Florida business and the vendors or the other corporate entities or the lenders or the title insurance companies, whatever, they're not as familiar with Florida, what they're going to be looking for is something that gives them a certain level of comfort. And if you are sticking pretty closely to the MBCA, then you've got that. You can tell that lender from Ohio or New York or Illinois or wherever it might be. You can say, hey, listen, we follow the MBCA for the most part with some minor state-specific adaptations. And here it is, right there in Florida Statutes, Chapter 607. You can take a look at it, and you can see how that works. So that's why we need this uniformity in order to make Florida practices, Florida businesses, Florida attorneys able to help their clients work on a nationwide basis. Now, the other thing that the MBCA has, which Florida also adopts, is the control of the corporations by the boards of directors. This is important not just for theoretical or abstract corporate governance issues. Florida has a strong public policy on corporate democracy, for lack of a better phrase, meaning corporations should be run in a fashion where the shareholders, the citizens of the corporation or the business, have a right to vote their shares in a fashion they think is appropriate. So the MBCA sticks to this and creates this corporate democracy concept. Now, what is the key to this corporate democracy concept? And I want you to keep this in the back of your mind as we go through SB 838 and its Florida adaptations. The key is that the shareholders vote, and they direct their votes to the representatives. And we're talking a Republican representative form of government, obviously little r Republican, meaning that the shareholders don't vote on everything. There are some things that they do vote on, but what they do is they elect representatives, the folks on the board of directors, to run the company for them. But the ultimate control remains with the shareholders. That's the corporate democracy concept. Now, the third thing that the MBCA focuses on is director competence. Why do we want that? We want qualifications for directors, a certain level of qualifications, so that we have corporate competence. Just like you can't run for office if you're 15 years old and be elected to the United States House of Representatives, there's a minimum level of requirements for that. There are minimum levels of competence for directors. So those are what the MBCA brings to Florida, and that's what we need in Florida to sort of harmonize. Now, the final thing that we need to keep in mind as we think about 838 and how it adapts to Florida needs and desires is that 617, the nonprofit corporate statute, defaults to 607 for a lot of these things. So that's sort of the background of where we are. Let's start talking about what SB 838 did. It, in order to accomplish these needs, is create this new level of committees. And before we get there, let's talk about take one step back and talk about the glitch bill itself and why a glitch bill was necessary. The business law section of the Florida Bar has been very active with regard to corporate statutes over the last few years. Many of you know that. And it put together a task force to study and update the Florida Corporate Act, which hadn't been updated since the 1980s. And the business practitioners in the state of Florida thought, hey, listen, we're losing a lot of business. We're not being competitive. Our businesses, we, the attorneys, are losing business, and our business clients are not being competitive because of this outdated, outmoded Florida Corporations Act. So the Business Law Section Task Force adopted the MBCA and started adapting it to Florida needs. And it passed in 2019. In fact, it passed both houses and was signed by the governor into law, became effective this January. There were a few problems, though, you might expect, being a complete corporate change, a complete change to the Corporations Act, not just piecemeal changes, a complete new adoption. That bill was over 500 pages long. As you might expect, with any bill that's 500 pages or more long, there's going to be some technical glitches. There's going to be some issues that arise with regard to this language or that particular provision. And that was the impetus for SB 838. As the business law section was studying the need for a corporate glitch, it also came to light that unintentionally there were some issues with not-for-profit corporations and the way not-for-profit corporations were run in the state of Florida. Specifically, some adaptations of the MBCA would make it very difficult, if not impossible, to run some particular corporations, not-for-profit corporations in the state of Florida. So the business law section decided to correct those technical mistakes and also to create a method by which not-for-profit corporations actually were able to operate more effectively and efficiently here in the state of Florida. And that's what we're going to focus on during this presentation, because that's what's of interest to real estate practitioners. Why? Because many community associations use the not-for-profit statute and form in order to run their particular community associations. Now, the way the business law section drafted SB 838 in order to achieve this was to create a two-tiered system of committees. Remember, one of the things that we want with the MBCA is that uniformity. We need that uniformity in order to allow Florida lawyers and Florida businesses and Florida not-for-profits to work beyond state lines. Why? Because if we can tell folks, hey, this is pretty much the MBCA. I know you're in Illinois, Mr. Lender, but this is pretty much the MBCA, which is pretty similar to what you have there in Illinois. That lender or that title company is going to be more comfortable working with that not-for-profit association. So the idea was, in addition to fixing those technical glitches, was to synchronize the goals of the MBCA. And the way it synchronized the goals of the MBCA with Florida needs. And the way it did that was to differentiate board committees from advisory committees. Remember, we've got this corporate democracy thing, this corporate governance issue out there. And so we've got to be not only harmonizing with the MBCA, but we also have to stay true to Florida corporate doctrine. All right, let's talk about those. This will become more apparent as we go through these. One of the biggest things you need to know when studying and understanding SB 838 is to understand that notwithstanding all the desires and needs and goals and everything else of the MBCA, the Florida adaptations and everything else, SB 838 made it clear that when we're talking about these particular committees, there are exceptions to that. And there's one really big exception. That big exception, the one that you really need to know about, is with regard to owner responsibility. Specifically, and I'll quote here because it's important, SB 838 says this doesn't apply to a committee established under Chapter 718, Chapter 719, or Chapter 720 to perform the functions set forth in 718303, 719303, 720.303, or 720.3035. In other words, owner responsibilities, owner obligations cannot be dealt with these particular committees. Now, something else to know, there's going to be a glitch bill because we're still cleaning up some of the issues that came up during the glitch bill. And one of them is the fact that there is actually a typo in what I just read you. The reference to 720.303 parens 2 should actually read 720.305 parens 2. So, irrespective of that minor typographical error, the exception still applies that this change in SB 838 does not apply to owner responsibilities. All right, let's get into it. Board committees. What can board committees do? Well, they can do just about anything, and they can include non-board members so long as the majority of the committee is comprised of board members. But there's an important exception to this rule. We're talking law, so there's always a rule and an exception, and sometimes an exception to the exception. Board committees can include a majority or be comprised entirely of non-board members if the board committee is involved in the, quote, election, nomination, qualification, or credentials of directors, close quote. Or otherwise, quote, involved in the process of electing directors. So you see what we've got here, which is, I think, a nice adaptation by SB 838. It allows board committees to really deal with the director issues and allows those board committees to be set up of non-directors, set up with non-directors. Makes it easier. And members of these board committees have all the responsibilities of regular boards of directors members, even if they aren't a member of the board of directors. What responsibilities are we talking about? Well, the typical responsibilities set forth in Chapter 607 in Florida Organic Law. Fiduciary and other duties of members of a board of directors. Okay, well, gee, Manny, that doesn't sound like a great deal for a non-board of directors member to be on a board committee because they can get sued, right? Well, yes, they can, but SB 838 also protects those particular non-director board members by saying that they're entitled to the same defenses as board of directors members. What does that mean? Applying Florida Organic Law, you've got the business judgment rule to Chapter 6 that applies to Chapter 607 corporations. And the business judgment rule is pretty broad. Case after case after case has said, hey, we as courts are not going to second guess the decisions of boards of directors so long as it apparently was taken for a business purpose. And when you take the 607, the business judgment rule, and morph it into 617, the not-for-profit, that broad discretion given to boards of directors is expanded even further. So not-for-profit corporations have an expanded business judgment rule, or like some folks call it, a business judgment rule on steroids. So those non-board director members, committee members, they've got all those protections. So they're taken care of. They're in good shape. Now, let's contrast that with advisory committees. Advisory committees have no limit on the number of non-board members. Remember, the majority have to be boards for board committees, but advisory committees, no limit whatsoever. But SB 838 gives with one hand, takes away with the other. There are some limits for advisory committees. They are not, quote, board committees, which means that they cannot be delegated board authority, and they can only make recommendations. Why do we have these two provisions? The provisions they were put into SB 838 was because There are some not-for-profits and some community associations that are having trouble attracting people, members, to board committees and to advisory committees. By virtue of these particular changes, those particular not-for-profit corporations should have an easier time attracting folks, citizens, residents, unit owners, whatever you want to call them, to those board committees and allow those not-for-profits to operate a bit more effectively. So that is pretty much the summary of what you need to know with regard to SB 838. A couple of technical changes that we'll run through very quickly, and then we'll conclude, and we'll leave it at that. First of all, there's a change to 607.0707, and that cleared up some numbering issues that resulted as a result of the MBCA being sort of adapted into the Florida Corporations Act. Remember, we're trying to adapt the entire thing, but also harmonize it with Florida organic law and Florida corporate practice. There are also changes to 607, 1106, 11920, 11923, 11924, and 11935. This shouldn't affect most real estate practitioners because the purpose behind these particular changes was to clean up some language regarding organic transactions for corporations like mergers, stock swaps, derivatives, those types of things. But it is out there and you should know about it. And finally, there were changes to 607.1703. This gave the Florida Department of State, acting under Chapter 607, the ability to direct interrogatories to corporations and other persons with regard to corporate activities. I'm pointing this last one out because a lot of people don't know that it still exists. So, there's one more, 607.1907 cleared up the effective date as to what happened to actions that were pending at a particular time. So where does this leave us with regard to the SB 838? It really is a pretty straightforward change. It's nothing that should intimidate or scare real estate practitioners, even if you're not heavy into corporate practice. Approach it from the perspective of board committees and advisory committees. They can do certain things and double check the statute to see which board committees can do which things and which advisory committees can do which things. But also keep in mind that the goal was harmonization with the Model Business Corporation Act and allowing folks to go out of state. Keep in mind that nowhere, whether it's a board committee or an advisory committee, are certain owner responsibilities. Those can't be delegated or shunted off to these particular committees. With that, I think we're concluded. If you have any questions, you know where to find me. I'll be more than happy to try to help you. Thank you again. Have yourself a great day.
Our next speaker is Brandon Ballou. Brandon practices in Clearwater, and he currently serves as Vice Chair of the Guardianship, Power of Attorney, and Advanced Directives Committee. Brandon's presentation will be Live or Let Die, DNRs, guardian conflicts, filing fees, and other guardianship law updates.
Good afternoon. I'm Brandon Ballou, and I'm here to speak to you today as part of the legislative and case law update. Unfortunately, we can't all be together live at the breakers to talk about these exciting topics, but we will do the best that we can. Today, we're going to talk about the recent changes to the guardianship code that were put into place on July 1st. Title of the presentation today is Live or Let Die, DNRs, guardianship conflicts, filing fees, and other guardianship law updates. The updates and the changes to the guardianship code came from two bills that were passed. The first was Senate Bill 994, and this bill now includes changes to 7 different statutes. So it affects 7 different statutes. We'll talk about each of those statutes individually, but the main point of this bill as a whole was it now requires a court, when appointing a guardian, to inquire into and consider potential disqualifications and conflicts of interest. There's a major concern about guardians, especially professional guardians, serving as guardians for wards where there are conflicts of interest or other factors that could play into whether they're appointed at all or how they how they serve, what they do as they serve as guardian, requirements and restrictions put into place on those guardians. Also, this bill includes changes to statutes that now require guardians to obtain court approval in order to sign a DNR for a ward, and provides a procedure for doing so, for obtaining a DNR for a ward. The first statute that is affected is Florida Statute 744-312. This deals with considerations in appointment of a guardian, and it expands the requirements as to what a court must look at as far as whether a guardian is qualified or disqualified from serving as a guardian. The statute is now changed, and the materials that I have provided will list out, or do list out, each statute that is changed or affected by this bill. It describes the effect of the change, and it lists the specific revisions. The PowerPoint presentation will only show you the statute and will show you only the parts of the statute that are affected by the change. 744-312's changes that are put into place by this bill now require a court to look into and consider a prospective guardian's potential disqualifications under 744-309 and potential conflicts of interest under 744-446 when the court is considering whether to appoint that guardian for an incapacitated person. The next statute affected is 744.334. This deals with petitions for appointments of guardian or professional guardian, and it specifically deals with the contents of those petitions. The requirements for a petition for appointment of a guardian is now revised, and it defines certain terms. It defines the terms, or the term alternatives to guardianship and the term relative. And it prohibits a professional guardian from petitioning for his or her own appointment as guardian. Someone else must now petition for that guardian, for that professional guardian to be appointed as guardian for an alleged incapacitated person, unless that professional guardian is a relative of the alleged incapacitated person. Of course, the term relative is now defined, as you can see. It is now required for a petition for appointment of guardian to list specifically the reasons why that the proposed guardian should be appointed guardian, and specifically list whether the proposed guardian is a professional guardian. The petition for appointment must list any other type of guardianship and or alternative to guardianship that the alleged incapacitated person or minor has designated or is in currently or has been in previously. The reasons why a guardian, and it must also list the reasons why a guardian advocate or other alternatives to guardianship are insufficient to meet the needs of the alleged incapacitated person or minor. The petition must state whether any willing and qualified guardian cannot be located. And as I stated, alternatives to guardianship is now defined, and the term relative is now defined. And if there are any alternatives to a guardianship, as defined in the revisions to the statute, the petition must state why those alternatives are insufficient to meet the needs of the incapacitated person. Subpart 2, or Section 2 of the statute, is completely changed and requires a professional guardian, or prohibits rather, a professional guardian from petitioning for his or her own appointment, as I said, unless the professional guardian is a relative, as defined in the statute. However, this does not apply to a public guardian who seeks appointment as a guardian of a person of limited financial needs. Basically, it doesn't apply to anyone who will not be paid from the ward's assets. Again, it's aimed at avoiding any conflicts of interest that may arise. The next statute affected is 744-363. This deals with the initial guardianship plan. It adds a requirement as to what the initial guardianship plan must contain. The initial guardianship plan must now contain, as shown in the addition of subpart F to section 1, a list of any pre-existing orders not to resuscitate or any pre-existing advance directives. The date of an order or directive was signed, whether such order has been suspended by the court, and a description that of the steps taken to identify and locate the pre-existing order not to resuscitate or advance directive that the guardian has taken to identify those and locate those. The next statute deals with the duty to file an annual guardianship report and what must be included in the annual guardianship report. This must now include all remuneration that the guardian has received. So report has to include everything, all compensation, all benefits that the guardian has received as a result of being the guardian from or otherwise from the ward. It includes you have to declare that from any sources for services rendered to or on behalf of the ward, and it defines remuneration to mean any payment or other benefit made directly or indirectly, overtly or covertly, or in cash or in kind to the guardian. Basically, any benefit that the guardian receives from the ward. The annual guardianship report must be served on the ward. 744-3675, dealing with the annual guardianship plan, has also been amended, similar to the initial guardianship plan. It must now include the list of the pre-existing orders not to resuscitate or any pre-existing advance directives. It must also describe those and describe any steps taken by the guardian to identify and locate those documents. Now, under Chapter 7 or under 744.441, that deals with the powers of guardian upon court approval. This deals with the guardian's ability to execute a do not resuscitate order on behalf of the ward. Section 2 is added. It creates a new subsection 1, and then it renumbers the subsections 1 through 22 as subsections 1A through 1V, and it creates a new subsection 2. And it now specifies that a plenary or limited guardian may sign a DNR as provided in the statute if a court order is first obtained. So only if a court order is obtained. However, in cases where a guardian seeks the court order on an emergency basis, the guardian must first follow the procedures under Florida Probate Rule 5.900, and the court must hold a preliminary hearing within 72 hours after the petition is filed. So this deals with the guardian's ability to sign a DNR, and it spells out the process by which a guardian can obtain this ability to sign the DNR. (744.446), which deals with conflicts of interest, prohibited activities, court approval, and breaches of fiduciary duty, is amended, and it now prohibits guardians from taking certain actions on behalf of a ward or on behalf of an alleged incapacitated person or minor, and it revises the provisions relating to conflicts of interest. This is effectuated by renumbering sections 2, 3, and 4, and it adds a new subsection 2. This new subsection 2, as you can see, it more specifically prohibits guardians from entering into financial transactions on behalf of a ward or an alleged incapacitated person or minor. And additionally, the bill specifies that unless prior court approval is granted by a court order or the relationship existed before the guardianship, the guardian and was disclosed to the court. So it existed before the guardianship and it was disclosed. In the petition for appointment, a guardian may not have any interest, financial or otherwise, in a business transaction or activity with certain individuals that may create conflicts of interest with their position as a guardian for the ward. And this is spelled out in detail in the change to in the addition to the statute in Section 2. It says exactly what a guardian may not do as far as business relationships and obtaining benefits for being the guardian. Here is the changes to subsection 3, and this is the section that talks about how, unless court approval is obtained by court order, or the relationship existed before the guardianship and it was disclosed, the guardian cannot do certain things, or the guardian cannot do certain things. Not only with the ward, but with the judge presiding over the case. This would take care of any situation where a guardian has a relationship with the judge, which we've all unfortunately heard about in certain situations. The guardian cannot have the relationship with any member of the examining committee who was appointed in that particular case, any court employee involved in the guardianship process, or the attorney for the ward. So not only affects the relationship between the guardian and the ward, but also with anyone associated with the ward or the guardianship case and the guardian. So it expands the potential conflicts of interest and tries to prevent those. The second bill that went into effect on July 1st was Senate Bill 344, and this clarifies certain ambiguities in current law that deals with public guardians, and clarifies that they are exempt from paying certain court-related charges and fees for accessing public records, and it now specifically requires courts to waive court costs and filing fees in proceedings involving the appointment of a public guardian or for the estate of a public guardian's ward after the death of the ward. And finally, it allows a physician assistant or advanced practice registered nurse to complete a ward's annual medical evaluation, which is required as part of the annual guardianship plan in certain situations. So this is put into play and affects, I believe, 3 statutes. First statute is 28.345, and it now clarifies as to what is exempt, or as to what the public guardian is exempt from as far as fees and charges go. The next one is 744-2008 that deals with the cost of public guardian. It eliminates the words including filing fees to clarify that potential ambiguity, and it changes the waiving of court cost or filing fees for public guardians to an optional situation, from an optional situation to a mandatory situation. So now the court shall waive any court cost or filing fees for the public guardian. Finally, in the relating to the annual guardianship plan as specified in 744.3675, the report of the physician that has to be included in the annual guardianship plan may now be signed by someone other than the physician. So if the guardian has requested a physician to complete the examination, the annual examination that is part of the annual guardianship plan, the physician can delegate that responsibility. The examination may now be performed, and the report may be prepared and signed by a physician assistant or by an advanced practice registered nurse. And the point of that is to make things easier for guardians to file the annual guardianship plans and to be able to prepare these. And that concludes our presentation today for the changes and the updates to the guardianship code. Thank you for your time, and again, I apologize, or I am sorry that we cannot be together. Hopefully we can all be together next year at the legislative and case law update. Thank you.
Hello again. It is my pleasure to introduce our next speaker, my friend David Eastman from Tallahassee. He is a longtime practitioner in the area of mobile home and RV park law, where he currently serves as general counsel to the Florida Manufactured Housing Association. And in this time, in the middle of hurricane season, it is very apropos that he is here to talk to us about Hurricane Irma changed everything, rebuilding mobile homes and RV parks.
I'm the general counsel to the Florida Manufactured Housing Association, as well as the Florida and Alabama RV Park Association. I'm here today to discuss the legislation for both mobile home parks and RV parks that passed during this last 2020 legislative session. There are two separate bills. 2020-27 Laws of Florida is the mobile home legislation, and it's a part of the affordable housing legislation that passed this year. The second bill is an RV industries bill, and that is 2020-126 Laws of Florida. My presentation is set up in this manner. I've identified for each bill the section number and the legislation statute that was amended. And so you can go through my outline and through the PowerPoint and see that, identify it, take a look at the actual legislation, and read it for yourself. But I think it's important today to go through briefly the very most important parts of this legislation, as well as some of the housekeeping and other legal issues that may come up that we were trying to address in this legislation. So if I may, it's entitled Hurricane Irma Changed Everything, and there is a good reason for that. A lot of this legislation arose out of the impact of Hurricane Irma on the Florida Keys. As many of you know, it came ashore as a Category 4 hurricane, affected the Keys from Marathon to Isla Mirada very hard, and there was like a 10-foot storm surge, as well as 12 inches of rain over a 24-hour period. It impacted the Keys very much. For mobile home parks and RV parks that are in the Keys, the storm surge had the effect of either really flooding those homes or floating them off their foundations. And so the floating homes, of course, would collide with other homes and also pull sewer lines and water lines out of the ground and impacting the whole utility system in a park. So the impact of the hurricane was tremendous. Mobile home parks and RV parks were substantially damaged, as were the individual homes. The problems that arose out of that resulted in a rethinking by the industry of how we deal with manufactured home parks, particularly, as well as RV parks, in rebuilding and maintaining the investment of the families who owned those properties or the investors who had bought in Florida and had a substantial investment in the real estate. So I'm going to go over basically two types of matters within the legislation. One is the bigger issues, the important stuff that you really need to know if you're practicing in real estate law or if you're involved in redevelopment or development law. The second thing I'm going to cover are the operational matters in a community, which involve not only the operations such as ejectment or requiring a homeowner to clean up after they remove their home from the lot, but also things like how you enter into the landlord-tenant relationship, ejectment, and then a matter of eviction. We removed the waiver of eviction for acceptance of rent. So I want to briefly touch on that. Let me begin by talking about the effects of Hurricane Irma. So initially, local governments in Hurricane Irma started stopping work of people that were working on their homes. They started changing the way that permitting was required, essentially going in and requiring a complete redevelopment consistent with their land development regulations. Many of those regulations had been revised since the parks had initially been placed in the Keys. So change the state agency that's in control of permitting is the Department of Health. And we provided exclusive regulation to the Department of Health on permitting and operational matters under Chapter 513. And that's in 513.02, 513.012, and 513.051. Essentially, it's exclusive regulation by the Department of Health, and the standards of the Department of Health are uniform throughout the state of Florida. The second big blockbuster thing that was done was statutorily allow for the rebuilding of mobile home parks and RV parks to the same density, that they had been built to originally. Subsequent to the development of a mobile home park or an RV park in the Keys, there had been a lot of regulations that had passed, some of those dealing with density, some of those dealing with separation and setback distances, lot sizes, and the like. Those are all under the zoning code. The Department of Health had its own lot size regulations, which were imposed as well. And so the densities of parks ranged anywhere from, let's just say, 100 spaces on up to 450 spaces. Those densities may not be possible today. However, the investment in the property by outside investors and also the families who own those properties was very much geared towards rebuilding back to the original park. And so we provided both for mobile home parks and for RV parks that they could be rebuilt to the same density, the same separation and setback distances, and the same lot sizes as were approved at the original development, the initial development. And as I said, those initial developments were approved by the Department of Health along with the local governments. The second thing that really became an issue was the rebuilding of manufactured homes. They're built to the Manufactured Housing Code, which is really a federal code implemented by the Department of Housing and Urban Development. Local governments build to the Florida Building Code. As we started redeveloping in the Keys and homeowners came in to rebuild their homes, they were faced with new building permit requirements, as well as stop work orders for not having pulled the appropriate permits. And in many instances, local governments were wrong. The type of regulation that is imposed on mobile home parks is through the Department of Highway Safety and Motor Vehicles. So we revisited that legislation. That's called the Florida Manufactured and Mobile Home Repair and Remodeling Code. That code was made uniform throughout the state of Florida, and it's exclusively regulated by the Department of Highway Safety and Motor Vehicles. There is permitting by local governments. There's also, of course, zoning and land development regulations that are outside of that code. But that code controls all rebuilding of mobile homes in the state of Florida after July 1st of this year. The statute also included a number of other issues, and I'm going to break those down into both RV park and then mobile home park. So under the RV park issue, there was a new master qualified propane installer for RVs, and that is through the Department of Agriculture and Consumer Services. The Department of Agriculture is required to develop criteria for testing and for qualifications for those individuals. And that's really a large issue for the manufacturing side, and also to some extent repair and so forth of RVs by individual vendors. There are, in the RV statute, a number of operational matters which are important to know about. There was an unclaimed property statute which did not work very well. That has been substantially revised to place the RV parks under or utilizing the abandoned property statute in 715 and 705. On the operation of RV parks, there is a question about conduct on premises and whether there was a right to proceed under something other than eviction for someone whose conduct on the premises was unruly, using banned substances, and so forth. So that was cleared up as well by adopting an ejectment statute, which placed the requirement on the community owner to call in law enforcement and have the person ejected and then have their property, the RV or their car or their personal belongings, removed as well. That's under section 513.118 and section 521.01 for the licensure of qualified propane installers. The manufactured housing side also included some development issues, and this is allowing manufactured housing in subdivisions. That's become a very large interest area for manufacturers as well as for developers. And manufactured housing, as you know, has gone through quite a transformation from the old tin can trailers to what is now a very viable housing product. The dealership requirements under Chapter 320 required that a mobile home dealer, manufactured housing dealer, had to have sufficient display space for their inventory, which meant had to have a very large lot and you had to include those homes that were for sale. The law was changed to allow for a one display home for a subdivision developer for a mobile home park developer in order to showcase the type of home they were selling. It was a minimum of one. There certainly could be a larger sales lot, but essentially that was changed to allow manufactured housing in as a viable product in subdivision development. In addition to that, there is sales of park trailers, which are a larger type of RV. There was a garage liability policy required for mobile home dealers in order to sell park trailers. That garage liability requirement was eliminated. Garage liability is for such things as motorized homes that are going to be taken out off the lot and driven on the street, or for fifth wheel type of RVs, which are again demonstrated on the street. That is not necessary for park trailers. In addition to that, under the mobile home statute, these are operational matters. The mobile home owners may be required to install permanent improvements, and they also are required to receive approval from the park owner prior to doing any construction on their homes. This solves two issues involving code enforcement, which are really necessary to resolve in order to avoid conflicts between homeowners and the community owner on matters where illegal construction had gone on. The ad valorem property tax is charged as a pass-through charge under the park prospectus, and that was changed to make it clear that ad valorem property taxes could be charged, but they had to be charged at the same rate as charged by the local government. In a much bigger issue for development lawyers and for real estate transactional lawyers is the authority to allow park owners, mobile home park owners, to acquire adjacent underutilized property and convert it into part of the mobile home park. Previously, that had been basically prohibited by Chapter 723. Now it is authorized. The requirement is, however, that upon acquiring that property and bringing it into the mobile home park, there is a requirement that facilities and services consistent with the new population of homeowners that will be moving into the park are satisfied. And that may be expansion of existing facilities, it may be additional facilities. There is one big change in evictions that need to be addressed, and that is that evictions for rules violations, where someone has violated the rules and regulations of the park in some manner. If a park owner had accepted rent from that individual, then the termination of tenancy for a rules violation was waived. It was, and the case would be dismissed. So the new change allows for a community owner to give a notice of a termination of tenancy and accept rent. The accounting for the rent must be done at the final hearing on the eviction, but the acceptance of rent does not waive the eviction termination of tenancy, nor does it allow for dismissal of that termination of tenancy. So that's a fairly large issue and one that I think should be recognized by evictions attorneys throughout the state. And it's also very important for park owners because all of the fees and charges that a park owner charges are included in the lot rental amount. And by accepting payments, for example, for water and sewer usage or for electricity usage, there should be no penalty on the community owner for that. Thank you. That's basically the outline that I have for today. There are many more details in this bill if you are involved in this issue area, and I'd recommend you contact the respective trade associations to get further information if you are. Thank you very much.
And my last introduction today is Steve Hearn and Ricky Hearn, who are coming to us today from Tampa. Steve is a fellow Duke Law grad. Go Devils, always glad to have that in the house. And more importantly, he is a past chair of the Real Property Probate and Trust Law section, where he has spent countless hours over many years contributing to the great good that this organization puts forth. And I'm excited to have him come back and reprise his efforts as the always popular estate, trust, and guardianship law update. Thank you so much.
Good afternoon, folks. Welcome to the portion of this seminar that's dealing with estate, trust, and guardianship case law update. I'm going to be running through a bunch of cases, as always. The cases that have been decided over the last year. Materials have been provided to you. I'm going to be going right in the order of the cases in the material. I've also got a few bonus cases since this is being recorded a few weeks after the date that the cases were were prepared as part of the materials. I'm going to try to get through them quickly and hopefully keep you guys awake. Grab your beer and hang on to your hats. First, I'm going to mention that in the last year, it's been a pretty crazy year for the appeals. The district courts of appeals have had a really variation in the amounts of appeals they've been handling in estates, trusts, and guardianships. As is typical, you folks down in the 3rd DCA have been the most litigious, most appellate work down there. And between the cases in the material and the bonus cases, there were 14 appeals to report on. The 4th DCA wasn't too far behind. You had 11. Moving on down the road, we had 8 in the 2nd DCA and 7 in the 5th. And you folks in the 1st must be a little bit more peaceful and kind because you only had 2 appeals in estate, trust, and guardianship cases. So that's the statistical update. Let's just dive right into the materials. I'm going to start right with case number 1, which was the Cruz case. It had to do with standing to challenge accounting information in a trust proceeding. And here was a situation in which parties were challenging the validity of a pour-over will and a trust, claiming that the testator / grantor didn't have the capacity to do those documents. While that proceeding was going, the trustee, a corporate trustee, prepared and served accountings that had the standard 6-month limitation notice in it. After receiving those accountings, the contestants sued, claiming maladministration of the trust. The trustee, notwithstanding that notice, filed a motion to dismiss, saying, wait a minute, you don't have standing because under the current trust, you're not a beneficiary. You don't have any right to do that. And on top of that, to the extent you are a beneficiary, you did the conditional renunciation as part of your trust contest. And until that's decided, you don't have standing. The trial court agreed and granted a motion to dismiss, kicking out the contestants. On appeal, the DCA, the 5th DCA, said, no, you are an interested person, even though you haven't fully established your status. It says you are a party pursuant to the interested person definition who may be impacted by the proceeding. And it also noticed that under 736.08165, that the trustee was allowed to continue the administration, but couldn't do anything that might impact the parties to the case. And based upon all of those things, the court said you do have standing as an interested person at that stage to challenge the accountings and allowed the case to proceed. There were a bunch of guardianship cases this year. I don't usually report on guardianship cases, but there were several that really apply across to other areas and I think are important to know about, some that necessarily weren't. The first case, the Wallace case, this was a case involving a family that's been in litigation for several years, and there are multiple appeals in prior years. This involved a case in which one of the grantor's sons was challenging an irrevocable trust and challenging transfers from the irrevocable trust on the grounds that his father didn't have the capacity to make those transfers, as well as didn't have the capacity to actually establish the irrevocable trust. As part of the trust proceeding, the son subpoenaed medical records of the father, and the father opposed that. The trial court said, no, I'm going to allow you to get those medical records. You put your father's mental condition into issue by virtue of your claims. Therefore, I'm going to let you get those, but I am not going to let you provide those records to any persons other than your own counsel and your own medical experts. After getting the records and after having medical reports from the medical experts, the son told the court, wait a minute, I need to petition for a guardianship from my father based upon these reports, and I want to attach these medical records and these reports to my initial pleadings in the guardianship petition that I'm going to file. He hadn't filed it yet. Father opposed it, and the trial court said, no, you cannot do that. I'm not going to let you use those records in any future guardianship proceeding. And on top of that, if you start a guardianship proceeding, I'm not going to let any parties have any communications with the examining committee that's not yet been appointed. That was appealed by the son, and the appellate court effectively basically affirmed that decision, saying that if you file a guardianship proceeding, The guardianship code has specific provisions for information that's to be provided. That does not include attaching medical records to the petition. And because of the court's concerns about improper influence of an examining committee, we're going to affirm the order preventing you from talking to an examining committee. There was a pretty lengthy dissent in the case that I think correctly pointed out the fact that there was no guardianship proceeding. Let the guardianship court work on all of these things. If improper paper was filed, the respondent could move to strike. If the guardianship court was concerned about communications, the guardianship court could limit those communications. How can a trial court in a separate proceeding limit and issue orders limiting communications in a case that hasn't even started yet? Nonetheless, 2 out of the 3 judges said they could and did so. One of the bonus cases is out of the same proceeding, the same family. It's the Wallace versus Comprehensive Personal Care case. This was I've got a Florida Law Weekly case site for you, 45 Florida Law Weekly D1318. This is the 3rd DCA, and the most recent decision was June 3rd of 2020. Apparently this son decided, well, rather than doing a guardianship proceeding, I'm going to move to have my father removed as trustee on the grounds that he's incapacitated. Father opposed that, saying, well, wait a minute, the trust has specific provisions on how to remove a trustee, and those provisions effectively require a guardianship court determination that I'm incapacitated. And if you allow him to do that without obtaining that, you're effectively usurping the guardianship court. The trial court agreed and dismissed the count, claiming failure to plead a claim for which relief could be granted. On appeal, the DCA reversed and said, even though the trust has provisions on how to remove a trustee, that doesn't supplant the Florida statutory provisions under the trust code. This complaint relied upon those provisions, not the provisions in the trust, and that the standards for removal of a trustee based upon lack of capacity or incapacity are not as high as those required for a determination of incapacity for guardianship proceedings, and allowed the case to proceed. Next case is the Covey case. It's a 2nd DCA case involving appointment of emergency temporary guardian. There, the court focused upon a glitch in our guardianship code, 744-3031, regarding emergency temporary guardians, requires that a notice be served, but doesn't actually require a hearing. In this case, a ward's life partner of 36 years was warring with an out-of-state niece. The niece was able to get an ex parte order appointing an emergency temporary guardian. That was appealed by the life partner. During the pendency of the appeal, a full-time guardian was appointed, and therefore the case really became moot. But the appellate court said, we're going to consider this because this is likely to happen again, and we want to make sure there's appellate guidance on how to proceed. The appellate court reviewed the statute and reviewed the guardianship code and concluded that even though the statute only requires notice of a hearing, you got to have a hearing, and that therefore appointment of an emergency temporary guardian without a hearing is not valid, and the order should have been set aside. The Lovis case was a case involving whether a guardian can retain assets and continue the guardianship administration after death. There have been several cases out there in the past years in which the courts clearly allowed ongoing jurisdiction post-death for purposes of resolving attorney's fees and guardian fees in the guardianship court, but distinguished between that and debts of the decedent, which it would kick over into an estate administration. This case, I think, applies it and expands that not only to attorneys and guardianship fees, but to outstanding debts of the ward in the guardianship court. This is one in which a guardianship went for 7 years after death. It was interesting. It involved an artist in the Overtown area down in South Florida. Apparently a previously very successful artist whose pieces were owned by Jane Fonda, John Belushi, Dan Aykroyd, and others. Unfortunately, that success must have failed because at death, all this person had was art. The guardian had gotten an award saying you can use art in kind to satisfy debts, but each creditor has to get art having a value of 200% of the value of their claim. That didn't even work. After 7 years, the guardian finally filed 7 years of reports and asked for authority to get the case closed at much lesser terms. The eventual heir of the estate objected and said, no, I disagree with this. I object to these reports. This guardian should have been held in contempt for failure to file reports. Nonetheless, the trial court said, wait a minute, you're not an interested person in the guardianship. I'm going to kick you out. You don't have standing to pursue this. The appellate court affirmed and basically said, as an estate heir, if you want to be determined to be an interested person in an ongoing guardianship, you have to file a request for notice pursuant to the guardianship rules. And that is what allows the court to tee up the issue of whether you truly are interested. If you don't file that notice and you don't bring that issue before the guardianship court, you are not automatically an interested person. The appellate court went on to say that the guardian couldn't be held in contempt of court because the guardian was never ordered pursuant to the rules to file annual accountings or to get caught up with those annual accountings. Therefore, there was no violation, and the court permitted the final discharge of the guardian. The Jones case, case number 5, another guardianship case. Here, a guardian in the 5th DCA out of Orlando who was the daughter of the ward, petitioned for guardian fees. The guardianship court said, wait a minute, you're a daughter, you're doing things that you should do out of your obligations as the child of the ward. Therefore, I'm not going to award you any fees whatsoever. Appellate court reversed and said, well, you're not entitled to fees for what you would be doing to satisfy your familiar obligations. If you are doing things that are required for a guardian and to discharge your duties as a guardian, you are entitled to fees, and the court remanded for further proceedings. The Carter case involved a sad situation with an adult ward who was an autistic child. The ward's mother previously had been appointed guardian, but earlier on in 1997, there had been a determination of abuse by the mother. She later had her guardian powers removed. Fast forward to 2019, she petitioned to have those powers reinstated, and a professional guardian also petitioned for appointment as a guardian. Mom shows up at the hearing, and professional guardian objects and says, you've been previously determined to be not eligible because of this prior abuse determination, therefore you have no standing. The trial court allowed the mother to attend, but did not allow her to participate, testify, or say anything with respect to the professional guardian's request to be appointed. A professional guardian was appointed. Mom appealed. Appellate court said even though mom's not obligated or not qualified to be the guardian, she still has the right as next of kin. She still is an interested person as defined by the guardianship code, and therefore she should have been able to participate, present evidence, and state her position at the lower court. The Walden case is a case involving analysis of what truly constitutes a conflict of interest that would prevent a guardian from being appointed. Here, the ward's daughter in Florida petitioned to be appointed guardian. The ward previously had gone to Georgia with some other daughters and was staying with them up in Georgia. While in Georgia, he actually obtained a restraining order against the Florida daughter, claiming that he was fearful that she was abusing him, exploiting him, and using his assets. During the course of the Florida guardianship proceedings, the Georgia case was dismissed. Nonetheless, father still opposed appointment of daughter in Georgia, who, by the way, also had sued on a mortgage foreclosure case and was seeking to extinguish a junior interest held by her father in the real estate. The appellate court ruled that neither of those items constituted a per se conflict that would prevent the daughter from being appointed. The restraining order, because it had been dismissed and basically extinguished prior to the proceedings on the Florida guardianship, did not constitute a conflict. The court also analyzed the nature of the junior interest in the mortgage foreclosure case and determined that that did not rise to the level of a conflict that would prevent her appointment. The Erlinson case, case number 8. This is an interesting one that involves an attorney's duties when they're representing a disabled or incapacitated client. Here, an attorney was appointed to represent a proposed ward in a guardianship proceeding. That person was adamant that she didn't want a guardian, she didn't need a guardian, and instructed her lawyer to put on evidence to defend her in the guardianship proceeding. The attorney testified, I think that my client does need a guardianship. She's not taking care of herself. She's not medically following up on her medicines. She's not doing what needs to be done. I think she's going to be harmed if she doesn't have a guardian. Therefore, I'm not going to put evidence on. I'm not going to oppose this. And I disagree with my own client. I think she needs a guardianship. A guardian was appointed. The decision was appealed. The appellate court ruled that this lawyer, the court-appointed lawyer for the ward, had a conflict of interest, that she cannot take a position contrary to the expressed desires of the proposed ward, that the guardianship code requires that she defend the ward based upon the ward's expressed desires. The court did note the rules of professional conduct on the Florida bar that deal with what you have to do when you represent an incapacitated client, and specifically pointed out the provision that says if an attorney has a reasonable basis, they have the duty to seek appointment of a guardian for their client. The appellate court said that that provision effectively is overridden by the guardianship code, and that if you are an attorney appointed in a guardianship proceeding, you effectively do not have the right or the ability to seek a guardianship for your client, that you are statutorily bound to oppose the guardianship proceedings, notwithstanding your personal opinions. And if you're unable to do so, that's a conflict that requires the appointment of another lawyer. The court reversed the appointment of the guardianship and remanded for proceedings, including appointment of a different lawyer to represent the ward. Moving on into fee cases, the first one is a guardianship fee case, the Reed decision. The Reed case stands for the proposition that size does matter. Here, there was a $17,000 attorney's fee provision award that was appealed. The basis for the appeal was that the trial court specifically stated it did not consider the nature and extent of the guardianship assets. It did not consider the size of the guardianship, although the guardian had requested judicial notice of the guardianship inventory, and it claimed that the guardianship was bankrupt. The appellate court reversed the fee award and said that the trial court must consider the size, must consider the nature and extent of the guardianship assets, and that's a very relevant consideration in awarding a guardianship fee. The Foreman case is another guardianship case. It's a fee case in which a court heard testimony by an attorney about their time, their hourly rates, the attorney's time, the paralegal time, and entered an award saying, I'm going to award a lump sum figure of X dollars of attorney's fees and costs. I have taken into account duplication of effort by the attorney and the paralegal, and this fee amount, this lump sum amount, includes attorney's fees as well as paralegal fees. The DCA reversed, and in the fourth DCA says you can't do a lump sum award. The court must provide detail regarding attorney's fees that are awarded, fees that are awarded for the paralegal. If there are reductions in fees due to duplication, it must state specifically the amounts reduced and where, and provide more detail, and the court reversed and remanded for further proceedings. The Hicks case is one involving a guardian who blatantly refused to comply with multiple orders from the court to provide accountings and provide financial information in a guardianship proceeding. The trial court finally got fed up and said, okay, I'm going to appoint a forensic CPA, and guardian, you're paying for it out of your personal pocket. And additionally, I'm awarding fees against you for your bad faith failure to comply with this court's orders. I'm holding you in contempt, and I'm awarding those fees against you individually. The guardian the guardian appealed, and on appeal, the guardian won with respect to the attorney's fees. The court said, no matter how bad or blatant this was, that the trial court failed to provide specific findings regarding bad faith and the factual basis for a finding of bad faith, and that to the extent you award fees related to bad faith, there must be evidence directly relating the attorney's fees amounts to the bad faith conduct, that because of those failures, that decision was reversed. The court did affirm the forensic CPA findings. The Lopez case, finally, we're getting to an estate case. This is a case that was pretty interesting. Apparently, it involved an estate that had been in litigation for 15 years. This was the 10th appeal from this estate. And you wonder why. Well, all you have to do is look at the court's description of the two appellants and the two beneficiaries of the estates. They described them as, quote, brothers, attorneys, and co-beneficiaries, close quote. So here you got two attorneys who were two beneficiaries in an estate who are fighting forever. This appeal actually involves one where they were both appealing on the same side. The attorney for one of the lawyers, these lawyers were Reuben and Raul. The attorney for Reuben had petitioned for payment of fees. After proceedings, the trial court awarded fees in favor of that lawyer, divided them one half to the estate, one half against Reuben individually, and also gave the lawyer a retaining lien on the assets of the trust of the estate. By that time, by the way, what started off as a $186,000 estate had dwindled down to no liquid assets and a piece of real estate that had fallen in value to about $40,000. Both of the sons appealed, and the court reversed the decision. First, it determined that under 733.106, you can't allow individual liability for attorney's fees. It just doesn't provide it. So that the entire award would have to be against the estate as a whole, not half against Reuben as an individual party. The court also said that there's no ability in this instance to assert a retaining lien against the estate assets because the lawyer didn't present any evidence that the assets in the estate were brought into the estate as the result of the work of the lawyer. Therefore, if you as a lawyer for an estate don't independently obtain assets that are brought into the estate, you're not going to have a right to a retaining lien against those assets. The Heritage Foundation case out of the second DCA is one in which the decedent's sister and her child challenged a will. They brought an action to reform a will, claiming that my brother made a mistake. There's no way they would have ever put that provision in this document, giving virtually all of my estate to charities. Therefore, I want it reformed. They went through discovery and determined that, in fact, they had no basis for the reformation, and they voluntarily dismissed their claim. The charities then pursued recovery of attorney's fees, and the trial court said, sure, I'll give you your fees, but only out of the estate. I'm not going to award anything against the parties who petitioned for reformation. The charities appealed and said, wait a minute, you're awarding it from the estate, but that's our money anyhow. We want an award against the sister and her son, and therefore we want this case reversed and sent back down. And the reason for it is that the statute dealing with reformation is different from the other statutes in that it doesn't have language that specifically says you can order payment from the estate. In fact, we're arguing that if there are no interests held by the parties who seek reformation, the court can't award fees from the estate. It has to order fees paid out of the pockets of the parties bringing the reformation action. The appellate court rejected that argument, said no, notwithstanding that missing language. It went through an analysis that basically says the probate court has the discretion to award fees from the estate. It also has discretion to award fees from the individuals, and that there was no abuse of discretion for failure to do that here. The Yontef case, number 14, deals with estate and trust attorney's fees. Here, an attorney filed a petition for fees and submitted an affidavit signed by their client as to the attorney's fees and costs. The trial court awarded those fees. That was appealed. On appeal, the DCA, the fourth this time, said you can't have a fee award that's based solely upon an affidavit signed by the client. You must have evidence submitted by the attorneys, and therefore this fee award was not valid. The Wilson case deals with some elective share issues. Here, a husband and wife got married in 2011. They signed a prenup in which they each waived any claims for elective share against the other's estate. And he amends his trust to say, I give my wife that amount to which she would be entitled as her elective share under the Florida statutes, as long as she files the proper notices and proper elections to obtain that elective share amount. 3 years later, hubby dies. Wife files a petition for elective share and says, hey, this trust gives me a benefit equal to that amount. Hubby's son, who apparently didn't like stepmom as much as dad did, objects and says, no, wait a minute, you waived elective share under the prenup, you're entitled to nothing. The DCA agreed and affirmed the trial court's ruling that as of date of death, because of the prenup, you had no right under the Florida statutes to an elective share. Therefore, the amount of that trust is zero. The court also noted that the trust itself did not constitute an amendment of the prenup because there was not a written agreement signed by both parties. And therefore, wife was not entitled to elective share, and wife was not entitled to a trust based upon the elective share amount. The Mullins case, here a will devised the decedent's homestead to the three sons. And the her three sons, it was two sons and a daughter, but she gave a life estate to two of those three persons to live on the homestead as long as they wanted. The third individual, after obtaining a homestead order that basically said it's a homestead that's devised to the three of them, referenced the homestead order and attempted to partition the property, claiming that the homestead order extinguished the life estate. The appellate court said, no, that's not true. A homestead order cannot act to extinguish a life estate. Title passes pursuant to law, not pursuant to the homestead order, and also that a homestead order is not a title transaction as defined in Florida Statutes Chapter 712. I think that last finding by this appellate court may be helpful for those of us who have to deal with title companies in the states who oftentimes demand a homestead order, notwithstanding the fact that it's a clean transaction with respect to homestead, because you now have an appellate case that says a homestead order is not a title transaction. So keep that one in mind. Next case is the Walters case. It involves an ongoing conflict between the second and third DCAs. This is a third DCA case about whether an interest held in a co-op form would qualify as exempt property for homestead purposes. The second DCA, years ago, said, yes, it does, and that a co-op interest is protected homestead. The third DCA in 2007 in their Hirshon decision ruled the opposite, said, no, it doesn't. It's not consistent with the Constitution of Florida or the Florida statutes. Therefore, a co-op interest is not protected homestead. In 2007, the third DCA certified it to the Supreme Court, saying, we got a conflict here, resolve this. For some reason, the Florida Supreme Court said, no, we're not going to do it. We're not going to accept jurisdiction, and refused it. Fast forward to 2019, this was a case from December of last year. Third DCA has it back in front of them again. They say, once again, we feel bound by prior case law. No statutory changes have made a difference. Therefore, we find that a co-op interest is not protected homestead. But Florida Supreme Court, we asked you to look at this before. You said no. Well, hey, we're sending it back to you again. Please take a look at this. It's a conflict. And they certified it to the Florida Supreme Court. Bonus case, this time around, the Florida Supreme Court apparently has accepted jurisdiction. They just did so, I believe it was June 29th of this year. So stay tuned. We may finally get a determination and a resolution of the conflict between the second DCA and the third DCA. Another homestead case, the Anderson case, it's number 18 in your playbook. It's from May of this year. It involved a situation in which the decedent rented out 3 of the 4 bedrooms in his house. There was a $38,000 claim brought by apparently either his grooming company or his pet boarding house, Precious Pets, against the estate. The estate said, no, this is protected homestead, go away. Precious Pets said, no, wait a minute, you were running a commercial operation. This wasn't your principal place of residence. 3 out of the 4 rooms you were getting rent for, it's not homestead. The probate court tried to split the baby. They gave a homestead exemption on 25% of the property, claiming that 75% wasn't protected. The second DCA on appeal said no, the entire property is homestead. And they based their analysis on a determination of 2 factors. Is the residence a fraction of the entire property? And second, is the property severable? They use the example of a duplex structure in which half of the property is rented and half of the property is not. It's severable. You can draw an imaginary line and separate these properties completely. In those instances, it's not 100% protected. In this case, because of the fact that these 4 bedrooms all access the common kitchen, common living areas, and it was not physically severable, the court applied the entire homestead protection to the entire property, notwithstanding the fact that the decedent was obtaining rent from 3 of the 4 bedrooms. The Ebling case, another second DCA case, it's a really complicated, convoluted interpretation of trust provisions regarding whether certain trust property passes to contingent beneficiaries or back to the estate of one beneficiary. The details and the convoluted nature of this case are way beyond the limited amount of time I have to talk to you today. So I just cite it to you as an example of a trust construction case and an example of how not to draft contingent beneficiary language. The Reno case, number 20, is February of this year, is dealing with Janet Reno's estate. And this was an interesting case in which the appellate court and the trial court were required to apply the Cypre Cypre principles regarding charitable benefits. Here, the Janet Reno homestead, which everybody admitted was a historically significant piece of property, had been held in trust during her lifetime. The trust had certain provisions that were somewhat subject to interpretation in 2 different fashions. But basically what happened is it provided that after Janet Reno's death, the trust was to go to the University of Miami under conditions and terms where they would maintain the property as a historically important property in perpetuity. The University of Miami, and this doesn't surprise me being a Seminole fan, fell through, didn't come through. You just can't trust them. And they said, no, we don't want this. That means we have responsibility and we'd have to do things. So we're not going to accept this devise. And you guys go away, leave us alone. The trustees then went and found another place. Miami-Dade College said, yeah, we'll do it. We're not like the University of Miami. We're trustworthy, but we'll take over this. And they sought a court order in which they asked that the trial court apply the Cypre doctrine and modify the trust to accomplish the charitable interests expressed in the trust. A group of beneficiaries named in the trust opposed that and said, well, wait a minute. This trust has provisions. It says if the property is not held pursuant to these terms, it has to be sold, and we want our money. The trial court said no, they modified the trust, and the appellate court agreed. And they said, no, we can apply this doctrine to preserve the historic significance of this homestead property. And therefore, University of Miami's failure is not going to allow this property to be sold. The Barrett case deals with the timing of vesting of an interest after death. The basic principle always has been that a person's interest in a devise vests as of the date of death, even though they don't receive it later, unless it's provided otherwise in the document. This case involved a situation where the document, rather than giving property to two heirs, directed that the property be sold to one of those heirs and giving that heir a right of first refusal to purchase the property. That heir eventually exercised that right, but by the time the property was closed, one of the two beneficiaries had died. That deceased beneficiary's estate came in and said, wait a minute, we get the proceeds from the sale. It vested as of date of death. Give us our money. Trial court and appellate court said, no, the document doesn't say you get it as of date of death. If they'd wanted to give you the property itself, they could have. They didn't. And the document says any beneficiary who dies prior to receipt of their shares, it passes to other persons in the estate. Therefore, the estate does not get it, and the terms of the document itself prevail. 31, that was 31, the Cantero case. This is a reasonably ascertainable creditor case. October of last year, out of the 3rd DCA. This case involves the sad, sad tale of a deceased lady and her boyfriend, who had broken up with her 20 years before her death, called the lawyer and said, wait a minute, we used to live in that condo together. I think I left some tools in the garage. You mind if I go pick them up? There were communications back and forth between the lawyer and the fiduciary and his boyfriend about these tools, but nothing else. 4 months after the expiration of the creditor claims period, bereft ex-boyfriend files a claim in the estate and says, wait a minute, you're selling that condo. I have an interest in that condo. I maintained it. I paid expenses. I paid mortgage while we were together. I get a piece of that sale. The trial court rejected that, as did the appellate court, and said the mere fact that you called and asked for tools out of the garage with nothing more does not make you a reasonably ascertainable creditor. You are not entitled to direct notice. Therefore, you lose. The Zeidman decision out of the 3rd DCA involved a holographic will in Belgium. Apparently, the decedent had moved to Europe, and while in Belgium, had handwritten a will that was witnessed by one person, at least according to the notary on that will, and deposited that will with a rabbi in Antwerp, saying, don't tell my family about this will, but when I die, I want my property to pass pursuant to this will, not pursuant to my old will that's still in the United States. Decedent dies. Rabbi coughs up the will. Family comes to Florida and says, we get everything based upon this holographic will that's valid under the laws of Belgium. Appellate court says, no, that's not true, that our Florida statutes specifically state that if you have a will, even if it's valid under the laws of a different state or country, it is a holographic will, it must comply with the witnessing requirements in the state of Florida. This one doesn't. Therefore, notwithstanding its validity elsewhere, it's not valid as to Florida property. The heirs also asked that the court have an evidentiary hearing regarding whether there actually were two witnesses. The trial court and the appellate court both said, no, that would be useless. There's a per se evidence already based upon the notary attestation that there was only one witness to the will. Therefore, it would be a waste of time to have a hearing, and we're not going to reopen this case based solely upon your suspicions that there may have been another witness. The Schlossberg case is a case involving a lot of convoluted conveyances of property, basically a decedent and her daughter owned a piece of property jointly. During the decedent's lifetime, she conveyed her 50% of the property into a trust that she had established for herself. That severed any joint rights by survivorship and caused the daughter and the trust to each own a 50% interest in the property. Later, the mother, as trustee and individually, signed a deed joined by daughter individually, conveying the property to daughter subject to a life estate in mother. After mom died, mom's estate showed up and said, wait a minute, that was not a valid conveyance out of the trust because the trust provided only for distributions for the benefit of the mother, and that a distribution of that interest for the lifetime of the mother with the remainder to the daughter is not exclusively for the mother, therefore it's an invalid conveyance. The appellate court said, no, you're basically putting form over substance because the deed was signed in individual capacity as well as trustee. It effectively was a conveyance of the property to mom, and then she had the right to do whatever she wanted to with that property, including conveyance of a remainder interest to her daughter. It did not require a two-deed transaction. Additionally, the court here ruled that the conveyance from the trust, which was a revocable trust, effectively was a termination of the trust as to that piece of property, and that therefore the transaction was valid for that reason too. The Herman decision is one in which a claimant filed a claim 3 months and 1 day after the date of publication of notice to creditors. That claim was stricken, and on appeal they said, no, wait a minute, rules of judicial administration say that if you're calculating the time to respond, you start calculating on the next day. You don't calculate on the day of the notice. The appellate court said, no, the statute says 3 months from the date of publication. 3 months means 3 months, and notwithstanding what the rules of judicial administration might say for procedural calculation of time, that you start on the date of publication. You don't get that extra day. The Kirby case was a case involving initially a divorce. During the divorce, the husband was able to get a sanctions award and an attorney's fee award against the wife. There was a hearing held. The court took the decision under advisement. Between the date of the hearing and the date of the order, wife dies. Notwithstanding that death, and after the filing of a suggestion of death, divorce court judge enters an order awarding fees to the husband against the wife, even though the wife's estate had not been substituted in. Later, the wife's estate moved to set aside that order and said, hey, you didn't substitute a party within 90 days after a suggestion of death under the civil rules. Therefore, this entire item goes away. Trial court agreed. Appellate court said, well, no, that's not exactly right. The appellate court did agree that you have to have a party in place before you can enter an order against that party, and that therefore the case needed to be remanded to have the estate substituted in. Appellate court also pointed out, though, that unlike civil actions, the family law rules do not have a 90-day requirement. They simply have a requirement for substitution of an estate. Therefore, they were going to be allowed to go back and substitute the estate in, even though the 90 days had passed. The Ortiz case. This was a case involving another attorney party, the daughter of a decedent, who decided 21 years after her father died to bring a civil quiet title action claiming a 25% interest in a family corporation that had passed through the father's estate, and using that as a basis to claim 25% interest in real estate owned by the company. The trial court and the appellate court both said no. Just because you're doing this as a quiet title action doesn't get you out from the fact that you should have asserted this ownership interest in your father's estate in 1995. You failed to do so. The 2-year statute bars you, and you can't now bring it again this many years later and attempt to get around that simply by asserting that this is a quiet title action and not dealing with ownership of assets out of your father's estate. I've got provisions in here and citations to amendments to the probate rules and rules of judicial administration for any probate and guardianship related matters. Moving ahead to number 30, the Nedgedly case. Here, a party negotiated with a third-party medical provider to settle a claim against the estate and basically agreed to a reduced payment of $15,000 to this medical provider, who then assigned the claim to the party. The party then turned around and filed a claim against the estate for the full amount of the medical expenses and attached the medical billing history to that claim. The court awarded the amount and referenced the orders, the rehab clinic's medical history and billing history as the basis for the order. The appellate court reversed and said those records were not properly admitted into evidence. There was no basis for the award. Therefore, any award was limited to the $15,000 amount, but it did remand for further proceedings. Again, there were more rules amendments, excuse me, rules of appellate procedure, judicial administration, and important rules regarding electronic wills. That's item number 33 that you may want to look at. 34, the Het decision. Here, a decedent's heir sued an individual friend of the decedent, claiming that that person exploited and improperly took $200,000 from the decedent over a long period of time. Part of the claim dealt with the fact that this party had set up a trust that ostensibly was for the benefit of the decedent during the decedent's life. In the proceedings, there was discovery requests sent to the defendant seeking personal financial information from the trust, as well as financial information and other records regarding the law firm records. And they moved for protective order. The appellate court said the personal information was fine, but with respect to the trustee financial records and the law firm records, that the court was required to hold an in-camera review to determine relevancy and address any privilege issues. And with respect to the trust records, that was specifically ordered because the trust was not a defendant in the lawsuit and therefore could not be compelled to produce those records without further in-camera review. The Robinson case is a case, these pop up about once a year, involving an attempt to determine paternity for purposes of intestate succession. Years ago, there was legislation that amended the paternity statute and effectively extended the limitations on determination of paternity for purposes of inheritance. Those cases have always stated, as does this one, that to the extent that your claim for paternity already was expired as of the time of that legislation in 2002, that legislation did not revive your right to seek paternity. This is one of those cases in which they attempted to revive, and again, that claim was rejected. The Klein decision was enforcement of a mediation agreement in which three parties agreed to allocation of a malpractice case brought on behalf of an estate. The three parties basically pled conflicting claims to recovery from those proceeds, but entered a settlement agreement that said, we're going to let the probate court make that determination in a non-evidentiary setting if we can't agree. They didn't agree, and one of the three groups, who was awarded zero by the probate court, didn't like it. And as part of their proceeding, they had claimed that under 1.540, mistake in judgment, etc., that zero would not be sufficient consideration. Therefore, if the court awarded zero, the mediation needed to be set aside. The appellate court said, no, you agreed to an allocation. You can't change the rules in the middle of the game, and you're going to be bound by what the probate court said. It doesn't matter what you think in terms of improper error because you didn't preserve it for appeal. You agreed to it in the mediation agreement, and that's going to be enforceable, and that gives the probate court jurisdiction to make that determination. Manor Oaks case is one involving a healthcare surrogate under a healthcare surrogate designation who signs the admission paperwork into a nursing home A dispute later arises. Nursing home says, hey, wait a minute, we have these terribly favorable arbitration provisions in our documentation. The estate's bound to that. Appellate court said no, a healthcare surrogate does not have the power to bind the designor to an arbitration agreement in a nursing home provision. The Solidatich case involved a messed up order. The judge orally ruled and then entered a written order that was different from his oral ruling. The judge refused to change it. The appellate court said change it. The Maddox case, number 40, is one in which a Medicaid hearing officer set aside an irrevocable trust, but didn't cite to any evidence to support that determination. Appellate court said you can't do that. You've got to have a basis for your ruling, and remanded for further proceedings. The Demiracan case is, again, a very convoluted factual situation involving an attempt by a grantor and all beneficiaries to modify an irrevocable trust. The appellate court ruled that, number one, this was a common law modification that was not affected by our statutory reformation or modification statutes. And more importantly, number two, ruled that an individual third party to whom the trust gave specific ability to remove and replace trustees did not have standing and was not an indispensable party in the proceeding. Although the analysis is detailed in the opinion, it basically boils down to a conclusion that a trustee of a trust that is subject to modification does not per se have standing and is not per se a necessary party if the grantor and all beneficiaries are agreeing to the modification. Therefore, because the trustee himself doesn't have that status, a party with the power to remove and replace that trustee can't be granted status in excess of whatever powers the trustee has. Finally, and I know I'm running out of time here, there were several additional cases that have come out since the materials were presented. I'm just going to run through them quickly. The Bloom case, 45 Florida Law Weekly, 1326. 45 Florida Law Weekly, 1326. Second DCA case that basically holds that a party who's serving as a successor trustee who hasn't obtained a required court order to be appointed has the burden to prove that any fees and costs that they expended as part of that role benefited the trust. Otherwise, they're going to be obligated to repay those fees to the trust. The Knott, K-N-O-T-T decision, 45 Florida Law Weekly, 1391. This is a second DCA decision from June of this year. Is just an example of dismissal of a case or a count within a case dealing with tortious interference. And it was dismissed because there was a pending will contest going in probate. Third DCA has issued the Spear, S-P-E-A-R decision, 45 Florida Law Weekly, 1397. This one's June 10 of this year. This is a case in which fees and costs were awarded in an estate. The court looked only at hours and hourly rate. It was challenged on the grounds they were claiming that that effectively was a lodestar determination. And in fact, based upon Florida case law, the court is required to consider the West Coast hospital factors, that only reviewing two of those factors is bad and therefore is improper. Second DCA said no, just because that is similar to a lodestar determination does not mean it was lodestar. And more importantly, that a court is not required to consider all West Coast factors as long as it considers some of them. The Lefkowitz case, and I think this is the most important out of the current new cases. This is a fifth DCA case, 45 Florida Law Weekly, 1430. It was done June 12 of this year. This was a standard creditor's claim case in which the creditor asserted a constructive trust remedy against an estate and said that because I have a constructive trust, I don't have to file a claim against the estate. Again, citing the prior case law along those lines. Here, the fifth DCA significantly narrowed the ongoing attack on that provision and said that just because you have a remedy of constructive trust regarding a claim against an estate does not mean you don't have to file a claim against an estate. That application of a constructive trust remedy does not give you priority over general creditors, and basically confirmed prior case law and ruled that the trust exception to filing a claim is limited to those situations where the decedent clearly held the property on behalf of the actual owner, either by way of an express trust or by some other clearly defined means. If you don't have that particular manner in which property was held, notwithstanding satisfying the elements for a constructive trust remedy, you still have to file a claim against an estate. Finally, there's the Martino case out of the 2nd DCA. It's a July 8, 2020 case. This was a case in which the ward's daughter was a holy terror with respect to guardians and guardianships. In fact, she was so abusive and disruptive, the first guardian resigned and specifically testified she had decided, that's it, I'm done with it, I can't do this anymore. When a second guardian was appointed, the daughter's reign of terror continued against the second guardian. She basically objected to any fees to be awarded to the guardians or their lawyers, and the appellate court ruled, daughter, because you have been so bad and so abusive and so improper in this guardianship, that even if you were an interested party, an interested person, through your conduct, you have effectively squandered your privilege as an interested person, and you cannot now object to the level of fees that were caused by your own behavior. And as a result, the daughter was kicked out. She had no right to object to those fees, and fees were awarded to both the first guardian as well as to the second guardian and that guardian's lawyer. That's it for me. I appreciate you keeping attention. I hope you did. I can't see you. I'm assuming that all of you are on the opposite side of a video call, and that means that 99% of you, at least those of you who I know, are sitting there with a cocktail in your hand, ready to enjoy your happy hour. I wish you the best and hope to see everybody in person soon. Please stay healthy. Please stay safe. Take care. Bye-bye.
You did it! You made it to the last presentation. Last, but the opposite of least. I am pleased to introduce Michael Gelfand, Senior Partner with Gelfand and ARP in West Palm Beach. Michael has too many accolades to mention, though a few are that he is dual Florida Bar Board certified in real estate law and in condominium and plan development law. And he is a former chair of the Reptile section. He remains an active and enthusiastic member of the Executive Council of the Reptile section. Michael will be regaling us today on precedents for normalcy, real property, Florida appellate decisions, substance, and ethics. Enjoy.
Good day. We are here for the normalcy and precedents, the real property Florida appellate decisions, both substance and ethics. For those of you who have been at these sessions before, you know we have a very fast-paced presentation for you. We'll be proceeding in order of the outline that you have, starting in order by subject matter. For example, we'll be starting with ADR cases, going through the alphabet of subject matter, ending with torts. And within each subject matter area, we will then be discussing cases in chronological order. So, as we move forward and we discuss real property issues, just something to get us into the proper framework for those of you who did not dream of being real property lawyers from the day you were born. First, we begin with ADR, alternate dispute resolution cases. First case we begin with is on page 25, the Guan versus Ellingsworth residential case out of the 5th DCA. Very interesting decision, reminding all of us to read the ADR provisions carefully in the contract in case of a breach before you proceed forward with your remedies. This declaration, which was a covenant running with the land, required that the parties first engage in negotiation, second mediation, and third arbitration. But there was a kicker. This provision also required or provided that if a party failed to go through this three-part process, then that would constitute a waiver, a release, and a discharge of the claim. What happened? Of course, one party did not proceed forward with the tripart requirement for relief. And what the 5th DCA ruled was that even though that Chapter 720, because this was a homeowners association case, permitted post-mediation arbitration, the failure to follow the contractual requirements waived the parties' claims. Moving forward into money issues, assessments, lien, and foreclosures, the first case we'll be looking at, skipping forward, is on page 36 out of the 1st DCA, and that's the Lewis versus Innova Investment Group case. In this situation, the court was dealing with the impact of a bankruptcy upon an owner who is defending a foreclosure action. The owner in the bankruptcy case filed a statement of intention, which in Chapter 7 indicates that the property would be given back to the lender. Based upon that filing in another court, the Florida court held that judicial estoppel barred the owner from contesting the foreclosure judgment because the owner had represented to the bankruptcy court that the owner was going to be turning over the property. Thus, the game was over. Also note on page 44, the BMG Realty Group versus U.S. Bank case came to a similar conclusion. Page 36 was a game changer for the Florida Consumer Collection Practices Act. For those who are not aware, chasing consumer debts in Florida can be problematic, not only because we are aware of the federal Fair Debt Collection Practices Act, which limits many of the actions that a debt collector can undertake, such as you can't call in the middle of the night, you can't threaten an individual with personal harm, you cannot provide a paper that looks like a complaint when it really isn't a complaint. Many attorneys are not aware that there's a similar parallel act in Florida, the Florida Consumer Collection Practices Act. In this situation, the president of an association, and don't ask me why, but it seems like condominium associations constantly get themselves into trouble, but it's good for many of us because it gives us an idea of where the boundaries are for our other non-association clients. Here, the president of the association allegedly violated the Florida Consumer Collection Practices Act, going to an owner and saying, you owe the association money. First matter that the court held was that a condominium association assessment is a consumer debt under the Florida Act. Since the Florida Act is broader than the federal act, it's likely that it would also encompass under the federal act. Note also the Williams versus Salt Springs case, which is a June 12th case, which was published after the date of the outline, also dealt with the same issue, came to the same conclusion. And also note the Trinchell versus Midland Credit case out of the United States 11th Circuit. That's Trinchell, Tricchell, versus Midland Credit Management. This is a July 9th, 2020 case out of the 11th Circuit again. And this case narrowed the application of the federal act by providing that there must be an Article 3 U.S. Constitution case in controversy at issue for standing. And if, for example, in the Trinchell case, just sending a letter that did not cause harm to the debtor, that does not give the debtor a cause of action against the credit collector. Next, we have the question of where do you draw that line? The Denton versus HSBC bank case out of the 4th DC on page 38 dealt with a requirement in a mortgage that there be 30 days notice of a default, a somewhat standard provision if you've ever heard of a standard provision. In this case, the bank gave notice, but the bank gave only 24 days notice. For those of you who are real lawyers, and you don't have 30 fingers and toes, we'll do the math for you. It's 6 days short. What the court held was that the difference really was not material. It was substantial compliance because the borrower received so much close to what the borrower bargained for that it would be unreasonable to deny the bank of the benefit of providing notice. In this situation, the court also drew a line on the burden of proof, and that is that the owner-borrower, who is the defendant, carries the burden of proof of prejudice that the short notice caused harm. In this situation, there was no proof by the borrower-owner that they couldn't refinance in 24 days, and the court also noted that the loan was in default for 11 months afterwards before the suit was filed. Lost note. Page 39, the Wells Fargo Bank versus Brycourt matter. What do you have to do to prove a lost note? Or alternatively, if you're representing the borrower, what is there that may stop the bank from moving forward? In this situation, the bank's witness testified that they undertook an investigation to find the lost note, and also that there was no record indicating that the note had been transferred or seized. That's critical because if the note had been transferred, then as negotiable paper, someone else may claim a right to enforce it. The fourth DCA stepped back and said, to establish a lost note, the witness only needs to testify that they conducted a search and could not find the note. That is what I would call, and many would call, the magical words proof. Just parrot the words required in the statute for the proof, and then ipso changeo, you've proved up the lost note. Would say as plaintiff's counsel, you need to be very careful as to coaching the witness to testify something that really isn't in the witness's personal knowledge. Moving forward, assuming that there is a judgment in a foreclosure action, is the For People's Choice versus Acanelli case on page 40 out of the second DCA. In this situation, after the lis pendens was recorded, a third-party Jupiter House moved to intervene. And what the court held is that a title owner does not have standing to intervene in a case when they've acquired the property after the recording of a lis pendens. Remember, the lis pendens, you have a certain amount of time in order to intervene, but if you've purchased now after intervention, all bets are off. Though the court didn't discuss it, I would dare say that this does not address the issue of a foreclosure sale purchaser who needs to intervene to protect the monies that have been deposited in the court. Next, we have the Marketable Record Title Act on page 42. We friendly call that MRTA, because if you don't pay attention to the Marketable Record Title Act, your client may feel as if they've been murdered. In this situation, though, very seriously, there was a claim against a law firm that was alleged to violate against the Florida Collection Practices Act. And the allegation was that the law firm knew that the declaration of covenants upon which assessments were based had been extinguished by the Marketable Record Title Act. And here the court held, the third DCA, that if the declaration is not enforceable because it had expired, then whatever privilege there was, a litigation privilege to proceed with litigation, does not apply because the defendants had no basis to proceed to collect assessments. Let's move into another area, attorney's fees. Dex and Such Marine versus Dake on page 43 out of the first DCA dealt with a contractor's lien dispute. Who is the prevailing party? A little bit unusual from the normal situation. We had the property owner, we had a mortgage holder, and we had the contractor's lien, the mechanic's lien holder. The contractor lien holder sued both the mortgage holder and the property owner in order to obtain clear title, and this was a subordinate lien holder. The subordinate lien holder was able to prove that their lien was not subordinate but actually had higher priority and obtained a summary judgment. That subordinate lien, that lien holder then moved for attorney's fees as the prevailing party pursuant to the contractor's lien laws prevailing party attorney fee provision. That provides that the, quote, the prevailing party is entitled to a reasonable fee. The first DCA took that language exactly, including the article. For those of you who remember third grade grammar, the article here is the, THE. And the court held that you have to read the prevailing party means one prevailing party, the one that prevails in the action, and then look back at the intent of the statute, which was to assist the lien holder versus the owner. And this was not an issue really for lien holders. And the court held that providing attorney's fees to a junior lien holder would upset the statute's balance. Question is, if you have a contract that provides for the prevailing party, would they also provide such a strict reading in that circumstance? Right of redemption, moving forward, is the Earl W. Johnson roofing case versus Hernandez out of the 4th DCA on page 44. An unusual situation that the foreclosure judgment, while awarding the principal amount, reserved jurisdiction for the amount of attorney's fees to be awarded. What did the attorney, but the foreclosure judgment also moved forward with the foreclosure sale even before attorney's fees were awarded. In this situation, the owner, I don't know if this was intentional or not, but paid the amount of the judgment to redeem the property, which was only the final judgment principal amount, but did not pay any part of the demand for attorney's fees. And the 4th held that the owner could proceed to redeem the property on the basis of the judgment amount without paying attorney's fees. This is a word of warning to proceeding forward in a piecemeal fashion. You may want to obtain a judgment for the principal amount before proceeding with attorney's fees, but beware of moving forward to seek a sale before you have liquidated all money amounts due. Civil procedure, the cartoon shows the armies moving forward to the castle. An arrow comes out and the knight says, "Beautiful, that's all we need to sue them into oblivion." A number of civil procedure cases moving forward. Basically, these come mostly out of the foreclosure process. And this year, there is a number of service cases that will be of interest to the practitioner generally. The Magnolia Court versus Moon case on page 77, skipping forward a bit, out of the 3rd DCA, was a situation where there was a foreign limited liability company. That company was not able to be served by the plaintiff. The plaintiff realized that that LLC was not registered to do business in Florida. By not registering to do business, that foreign LLC then came under the LLC Act, providing for the Secretary of State is entitled to receive service of process, and that is the equivalent of personal service. Beware, attorneys, for your clients that are foreign LLCs or other entities that have not registered to do business in Florida properly. Another service of process issue is the Katz case on page 85 out of the 3rd DCA. There, they were trying to serve an individual in Venezuela. The defendant was not at the location. There was a, quote, roommate at the location, and the roommate said, "Yeah, maybe a roommate, but my roommate actually lives in Colombia. That is her place of abode." And those were magical words for the 3rd DCA, because that links into Chapter 48, which provides that service is to be at the usual place of abode if it's substitute on an adult living there. And the court held that unlike perhaps a residency, you can only have one place of abode, which is that the place where they are living, not at the time of complaint filing, not at the time of judgment, but at the time at which service is made. Moving forward into the house of straw that is so many construction matters, we're moving into construction land. And the first case we'll refer to as Surety's Choice, to take a name from the movies perhaps. The Sea-Watch case, skipping forward on page 90, is out of the 3rd DCA. In this situation, Sea-Watch discovered that the contractor's work had defects, and as a result, Sea-Watch terminated the contractor from the job. Sea-Watch then made a claim on the surety, and the surety contract provided that the surety may elect to undertake to perform and complete the contract itself, through its agents, or through independent contractors. So the surety had 3 choices according to the contract. The surety hired the same contractor to do the work. You can only imagine what Sea-Watch's response to that was. Well, in court, they tried to stop it because presumably they'd been through this one before and didn't want to have a reprise. The 3rd DCA, in a trend that I think you're probably seeing through the cases that we've presented to this point and in the future, looked at the language of the contract and construed it. It was clear, and there were no restrictions on who the surety could use to complete the project. 2 lessons for the practitioner here is: 1, look at the contract, presumably before your client signs it. 2nd, if you're involved in construction work and you have a surety situation, I don't know what type of negotiating power you have, but you may want to take a look at the actual contract that the surety is going to be issuing, not the 1-page bond that they send out with the facsimile signature. Next, we move into NIMBY land, or not in our backyard, as the woodpecker next to the robin reads. So we have a case out of the 3rd DCA, Miami-Dade versus Publix on page 90. Publix sought a variance to allow a liquor store to be closer to its main grocery store. And the question was whether or not Publix was entitled to a variance. As you may imagine, there were some objections, especially from a liquor store in the neighborhood. And the question was, on a 2nd level certiorari review at the 3rd DCA, was what is the burden of proof that a local government must follow if they are not going to grant the variance? And they held that once the applicant meets the initial burden that the statutory criteria are met, then the variance is to be granted unless the opponent, this would be the other liquor store owner, produces competent, substantial evidence that it would be adverse to the public interest. In this situation, the court adopted in large part the dissenting opinion of Judge Moore, one of our reptile stalwarts, and where she noted that the court could not just concentrate on what the opponents were saying, but first look at whether the applicant met the criteria, and then the burden shifts. Moving forward into contract land, again, we are coming back to the theme of the year, and that is, it says what it means. The Corporate Creations versus Marriott case on page 93 dealt with specific language concerning termination of a contract. You may want to read along on the screen. The termination provision provided that it could be terminated with or without cause and without liability by providing written notice of termination to the other party at least 90 days prior to the renewal date. So, we get to year 5 of 7. The termination is triggered at that point, giving 90 days notice. The 4th held that the language was clear and unambiguous. No extrinsic testimony would be provided or would be accepted unless reasonable minds would differ as to the meaning of the contract. And here there was no provision saying that the termination clause would kick in only in the last year or only in the last 6 months, but the termination provision without having any date could be triggered at any point. At what point can you raise unclean hands or lack of equity in a contract case? Again, on page 93 is the Collections versus Patel case out of the 5th DCA. very interesting circumstances here, and depending who you may represent between different partners, and remember, if you're representing an entity that's going into development or any type of business, you need to be very careful as to how you approach representation and who is your client. I would urge you to review the Reptile CLE tapes that we undertook about 2 months ago, and Mike Dribbin made an excellent presentation on what happens when you represent entities and partnerships. But in this situation, you had two partners. One partner purchased a judgment against the corporation, and then that one partner proceeded to execute against the ex-partner. Rule of Civil Procedure 1.540 allows relief from judgment when it is no longer equitable to present it. And in this case, the 5th DCA seemingly has expanded the role of equity in contract cases by holding that misconduct is not necessarily required to evoke equitable powers. Because in this situation, the partner purchasing the judgment did everything apparently according to the book, even though it may stink. And here the court held that it would not be equitable to allow an ex-partner to execute on the judgment from the corporation where they were both together in business. Waiver of protections. Note the Castro Bank on page 97. This may cause you to go back, running back to your form bank. The guarantee on a promissory note, and you may want to read the language on the screen, read in boldface, perhaps conspicuous language, the guarantor hereby consents to the attachment of garnishment of his, hers, its earnings. Obviously, from the pronouns, you know this was from the drafter's form bank. But returning back to the case, the 3rd DCA held that that language was unambiguous. As a result, the head of family exemption from garnishment was waived. Note for your future cases, for your future contracts, is this something that you want to put in your contract? From a public policy perspective, there is a substantial question, but the court did not really believe that the public policy, or did not use public policy to override the clear language of the contract. Moving forward into the next area, real property contracts, the graphic is of an early home inspection with a bear in the corner, and there appears to be a checklist that was being written on the wall by a new inhabitant in this cave. And it begins, make certain cave is empty before you move, and then it sort of ends. So, let's talk about writings. Mediation agreement terms for a real property contract. The Cohen versus Cohen case on page 101. And don't we love when siblings go at each other? And that's what the Cohen case provides. In a mediation agreement between the siblings, there was going to be a sale of jointly owned property. And the mediation agreement said that they would accept any contract not requiring seller financing. The court, the 3rd DCA, held that just because the two parties felt that the language meant different things, in other words, one of them didn't want to accept the other's offer, the court said that doesn't mean that the agreement is ambiguous. The parties were required to accept any contract that was provided as long as it meant the minimum price and as long as it didn't have financing requirements. The fact that it was offered by one of them did not mean that the other did not have to accept it. Leasing, on page 102, the Wave Blast versus Pompano case deals with what happens when a contract may not have an essential term. In this situation, the water sports company had a hotel beach concession, and the concession for these beach items would, quote, terminate on the demolition of the property, unquote. What happened to the hotel? Well, just like this week, the hurricane did come to shore and demolish it, so the owner, in essence, just renovated the hotel, but the parties recognized that it was not demolished. So now let's shift from the beach to the actual lease terms. The lease was for a term of years, it appeared, but the lease did not state how many years. It did not state an end date. And what the fourth recognized is that if a lease does not have an end date, that creates a tenancy at will, terminal in essence at any time. And in this situation, the term demolition of property was an uncertain term. Parole evidence was allowed to ascertain the intent of the parties. And the president admitted that the lease was to end when the hotel was to be torn down, which was an indefinite term. Moving forward on page 102 is the Corey versus Newfer case, dealing with that boogeyman of an agreement for deed. So, when you have an agreement for deed, that should put the hair on the back of your neck up. Always seems to be a problem with them. So, the holder of the agreement for deed foreclosed on that agreement. As a result, after the sale, there were surplus proceeds available. Chapter 45 provides that the owner of record is entitled to surplus proceeds after subordinate lien holders are paid. Again, the owner of record. The second analyzed what estate, if you would, did the heirs have for this property. The court noted they're not owners of the property, they're not assignees of the owner, they're not subordinate lien holders. This goes back to, as the court noted, an agreement for deed places ownership of the property in the seller. The buyer does not obtain ownership. Therefore, though it may appear unequitable, the holder of the agreement for deed gets the surplus proceeds, not the owner or the owner's heirs who actually paid in and created the equity. Right of first refusal was dealt with also on page 103 in the Acquisition Trust versus Lauren Pinebrook case. This situation, Publix had a right of first refusal on property, shopping center property. Publix exercise of the right of first refusal was for the same price as the third party was going to be paying for the property, but the exercise of the right had different due diligence terms and different terms on closing. In essence, as the second recognized, Publix did not give a point-by-point recitation of material terms. So the first item that the second came in was that simply notifying the seller that the holder of the right is going to be exercising the right is sufficient to trigger it. Next, once the right of first refusal has been triggered, at that point, the seller and the holder of the right can negotiate the terms that they want. They are not bound to the contract terms for the third-party purchaser. And that sort of makes sense because if the owner of the property is willing to change the terms, the owner is getting what they want. Unfortunately, it does leave the contract purchaser out to dry, you may say. Risk of loss. The Rivas versus Singh case, also on page 103, deals with what happens when you sit on your hands. In this situation, the owner knew that there was a wild deed out there and did nothing for 2 years, and after the sale to what apparently was a bona fide purchaser for value. And the court held that in this situation, there were two potential parties that they had to rule for. The BFP, the bona fide purchaser for value, who didn't know about the problem, or the original owner who knew about that deed and didn't do anything about it. And what the court said was they are going to protect the person who is innocent. The least innocent, the one who could have prevented the misdeed by acting further, that's the one, as the court said, should suffer. So by passively watching even with the recording requirements of the Recording Act, the owner may not be protected. Corporate procedure issues. Defamation. If you say it, you got to live with it. On page 105 is the Hulak versus Gibraltar case. The chief operating officer made statements to corporate executives and managerial employees, and the court held that even though some non-employees were board members present, the fact that it's made to the board of directors gives a protection, a privilege, and that does not constitute publication to a third party. Moving forward into covenant enforcement, as someone is being wheeled out on a dolly, apparently with their feet in cement and tied up, the statement is, let's just say the HOA doesn't think giving a second chance or a second notice should be necessary. By the way, we try to give a second notice before the death penalty is issued. But let's first start with covenants. Alternate dispute resolution covenants, the Hayslip case, which is reported on page 110 out of the second DCA. Some of you may recall the great hubbub when it first came out. U.S. Home, in its builder's deed, provided that all conditions and covenants in the deed run with the land, and also provided that this was a matter of interstate commerce, and further, the deed, not just the purchase agreement, but the recorded deed, that any dispute would be subject to arbitration, and also had the buyer sign the deed. So there was a sale of the property from the original consumer purchaser to a resale purchaser. So we are now dealing with a remote purchaser from the original purchaser and the developer. And there were alleged stucco and construction disputes. The owner filed suit to enforce. U.S. Home demanded that the matter proceed to arbitration pursuant to the deed ADR requirements. The court held that occupation and enjoyment of the home required then the parties proceed with their procedure to remedy building defects. The court also has certified this case as a case of great public importance, and I would imagine that the Florida Supreme Court would be looking at what point is a statement in a deed, particularly for a remote purchaser, actually a covenant running with the land as opposed to just a personal covenant and not binding on a remote purchaser. Interpreting covenants is the Beach Towing versus Sunset case, page 112 out of the third DCA. In this situation, the covenant required that the property will not be used as a parking lot, storage yard, facility, or garage or tow truck company. The court focused on the last language, or for a garage or a tow truck company. And the court held that nouns or verbs in a series, when there is a preposition or a postpositive modifier at the end, that will apply to everything beforehand. And they use the Latin term associus socialis, which means it is known by its associates. So words that are grouped together in a list should all be given related meanings. So in this situation, they held that a tow truck company or garage meant that it would be a company for garage purposes, but would not prohibit a garage from being built. Private cause of action from zoning. The Chapman case on page 113 may be a game changer. The court held that a private citizen has standing to enforce a zoning ordinance when that owner proves special damages. And in this case, the owner was adjacent to the land at which there was an alleged zoning violation. And by mere proximity, there may be special damages that then allows that property owner to bring suit to enjoin that violation, or alternatively, perhaps for damages. Termination. Dania Beese versus Forcier, page 115. This is condominium termination, not an Arthur Schwarzenegger termination. The declaration of condominium requires that all owners, lien holders, mortgage holders must join in termination of the condominium. After the condominium was declared, the legislature amended the termination statute, section 718.117. That provided a lower percentage for approval for termination. The court held that unless the declaration of condominium has Kaufman language, that's language that says that in essence that changes to the Condominium Act are incorporated into the declaration of condominium, without that language, the court would not require that the condominium association utilize the current law, but was required to utilize the original provisions in the declaration of condominium. Note also reference to the Tropicana versus Tropical case out of the 3rd DCA. That was a 2016 case dealing with a similar issue. Reasonableness. This is reasonableness concerning an alteration in a covenant-controlled community. This was a homeowner association, but also presumably would apply to a condominium association. Is the Royal Harbor Yacht versus Marsima case on page 115. The association denied the application to install a boat lift because of its, quote, disharmonious appearance, or at least anticipated, and that it would be anticipated to obstruct view. Because reasonableness under the business judgment rule is an issue of fact, summary judgment could not be granted. Pre-suit arbitration as a requirement was dealt with in the Seawelt case on page 116 out of the 3rd DCA. A unit owner sued to declare a leasing amendment, an amendment that limited leasing, void. Sometime later, the association counterclaimed to enforce that provision. After the association filed its counterclaim, the unit owner then moved to dismiss the counterclaim on the basis that the association did not undertake mandatory pre-suit mediation as required by Chapter 718.1255. What the court held was that by filing suit in the first place in court and then waiting 3 years until the association counterclaim, the unit owner waived the right to contest the mandatory pre-suit arbitration requirements in the Condominium Act. And my apologies if I refer to the Homeowner Association Act a few moments ago. Furthermore, the association's filing of the counterclaim does not create a new threshold for requiring pre-suit arbitration. Alterations in the condominium context were the case in the Bailey versus Shelburne case. This case is not in your outline. It's a brand new case, July 15th, 2020. It's out of the 3rd DCA, Bailey, B-A-I-L-E-Y versus Shelburne. This case is important because it deals with ratification. The Condominium Act is, as the 3rd DCA, clear as it addresses material alterations, substantial additions to common elements, allowing only for 3 exceptions to an absolute prohibition on those in the condominium context. One is if it's provided in this section, 718.113, if it's provided for in the declaration, or if 75% of the owners vote for it. In this situation, the section itself, subsection 1, requires that associations maintain common elements. So in this situation, there was a requirement that the association undertake repairs. So as repairs that may also be alterations, no vote is required for those options. Said in other words, if work falls into 2 buckets, an alteration bucket and a repair bucket, the requirements for repairs will prevail. You don't have to get a vote as required for alterations. The association, though, got the 75% vote for items that were not repaired, but obtained the vote after the work was done. And the 3rd DCA held that it would be absurd to allow a vote after the fact to ratify the work. You have to have the vote before the work's undertaken. Question: if the work's been done, how do you deal with the situation if you can't ratify it? And further, if the contractor would lien to be paid, doesn't the association have to pay the contractor and the assessment still needs to be paid? I don't know if the 3rd has thought out all the potential implications of this. Eminent domain cases, note the Manatee versus Mandarin case, page 117 out of the second DCA. This is important dealing with the statute of limitations for challenging an ordinance. The timeline's on your screen. The ordinance was adopted in 1990. Suit was not filed until 2015. If the statute of limitation began on when the variance was denied, potentially would have been within the statute of limitations. But what the court held is when there's a facial, not an applied, but a facial objection to a ordinance that is unconstitutional, that challenge must be brought within the statute of limitations of original adoption. Ethics decisions, page 120. You know, if a case begins with the Florida bar versus, someone's in big trouble. So in this situation, dealt with trust accounts. The bar complaint alleged commingling and misusing of client trust funds. The court specifically noted that the attorney showed no remorse, undertook nothing to redeem the situation. And the court held, this is the Florida Supreme Court, that when a lawyer intentionally misappropriates client trust funds, the appropriate sanction is disbarment. No ifs, ands, or buts. So, no matter how hard up you are, you stay far away from your trust funds. Insurance issues, residency requirements, Arguelles versus Citizens on page 121 out of the third DCA. Very important for your clients that may be absentee owners, especially if they're leasing. The insurance policy, the casualty policy, provided that the residence premises was insured, and that was defined as where you reside. The owner moved to New York and rented out the premises. It was no longer a residence under any definition. The third DCA, again, clear and ambiguous reading of the contract. Coverage was only there if the owner lived in the unit, and they looked at the dictionary definition of reside, to live in a place permanently or for an extended place of time, and that the owner was not doing. Big problem on this case for the owner was the owner didn't know about the lapse of coverage until after the loss. Subrogation in the condominium context was the subject on page 122 in the Universal versus Loftus case. This is one of those situations when water comes from the upstairs owner to the downstairs owner. Can the downstairs owner, or perhaps more importantly for this case, may the downstairs owner's insurance company exercise a right of subrogation against the upstairs owner? And the court held that while the Condominium Act 718.11111J requires that an owner pay, that does not create a private cause of action. The right of subrogation provided in the statute only was there to not disturb an existing insurer's right of subrogation, but there is no private cause of action. Named perils, though this arose out of a condominium, it may apply to any property owner's windstorm, rain, or other casualty coverage. In the Citizens Kings Creek case on page 125, the third DCA noted that the association filed suit 3 years after the loss. Maybe they were a little bit, shall we say, disenchanted with the claim. The court also noted that there were 3 roofs that were installed, one on top of each other. But the key here is that the policy was a named perils. It only insured for wind and rain. And under a named perils policy, the burden of proving the cause of the loss is on the insured property owner. It is not an exclusion. It is not a burden for the insurance company. Statutory interpretation issues. I have one case in this area, page 127. Please note the State of Florida versus Poole case. This case is a game changer all across the board. Though obviously because it's State of Florida, this is a criminal case, and you're going to say, what does that have to do with real property law? Because of course none of your clients are criminals, but very seriously, the court rewrote the rules on stare decisis, or what is the role of precedent in the law. And what the court said is that because the court is bound by what it called a higher legal authority that if the court thinks that a precedent is wrong, it should not be followed. Up to this time, this court, as well as the U.S. Supreme Court and most Supreme Courts across the land, held what was used to be called a precedential view. And that is, even if the court today may think it is wrong, unless there are substantial reasons to change it, the need for certainty in the law, as well as having public confidence that the law doesn't change every time you change who's ever on the Supreme Court, does not mean that you just flip-flop, if you would, on cases and change precedent. We will see what this does in the future for challenges. It may also undermine the effectiveness of 57-105(1) and 2 in challenging on a frivolous basis. Taxation issues, homestead seems to be the key in the Baldwin versus Hernandez case on page 129. If you don't live in the house, you are not entitled to a homestead. Also, to homestead, the Fitz versus First case on page 129, through something not of the Florida owner's mistake. The Florida owner also had listed a homestead in Ohio and therefore could not claim the Florida homestead and lost it retroactively. The Gannon versus Airbnb case on page 130, Airbnb is not required to collect and pay the best bed tax because it is a mere conduit, but it is not the holder of an interest that is a leasehold. Title issues, note the Dania versus Elias case on page 134 for prescriptive easements, and the 4-point test that is there, even though parties may have used a common driveway for 60 years, if they did it friendly, it is not adverse, it is not prescriptive. Page 135, the City of Miami case deals with certified copies. An electronically filed code lien, not one that's physically stamped certified copy, is entitled to certified copy status, and as a result, that now becomes a lien. Anderson versus Latowski, page 136, another homestead case. This was a case, whether a homestead is protected against creditor claims after death. The homestead was rented, but only 3 of the 4 bedrooms. The decedent lived in the 4th bedroom. The court held you cannot devise a homestead. The fact that 3/4 of the bedrooms were leased does not remove the homestead protection. Tort cases, the Walters case on page 144 out of the 3rd DCA, there was a hole in the condominium association's common element doc. Condominium association may be jointly and severally liable with the contractor that did properly repair or fix that hole, but importantly, the association has a non-delegatable statutory duty to maintain and repair. Timing, the Frederick case on page 147, if you're dealing with commercial properties, 41 seconds after the spill, someone walked into the place and fell. The manager saw it, and in between that time went to get cleaning supplies. What the court held was that while there was not a breach of the duty to maintain because the manager rushed off to get the supplies, there was an issue as to whether there was a proper warning in that 41-second time period. The last case is literally the spoofing schmuck case. And this was a cyber stalking case. And what the court held was that if someone posts on their own media page, that is not being directed at you or a specific person. And the court also held that by looking at those items, a objectively reasonable person would not have suffered severe emotional distress or substantial emotional distress as a result of the tweets. And therefore, no cyber stalking claim would be allowed. As we finish, as the bells go off, a reminder. Some of you have had the opportunity to meet my daughter, Sarah. She understands that being from a family of attorneys, she is a person in many ways of privilege. When she graduated, as shown here from law school, she had many mentors. Many of them are you. What we need, individuals like you specifically, to go out and mentor someone who does not look like me, like her, like you, someone who grew up in a different place, went to a different school, may speak with a different accent. Because if we do not mentor others who do not have the opportunity, then the law will not reflect society and will not be able to protect society the way the law has in many times. As we move forward, we understand the importance of the law. Recently, we've just observed the passing of Congressman John Lewis. John Lewis wrote, recognizing what the future would bring, an opinion that was published on the date of his funeral. He recognized the words of Martin Luther King when he remembered that King said, "We are all complicit when we tolerate injustice." King said that it's not enough to say it will get better by and by. He said each of us has a moral obligation to stand up, and speak out. When you see something that is not right, you must say something. You must do something. Democracy, as Lewis wrote, is not a state, it is an act. And each generation must do its part to help build what we called beloved community, a nation, and a world society at peace with itself. And in Lewis's final words to the nation, a man that was revered by individuals on both sides of the aisle for many decades, who literally put his life on the line for the values of the law, an effort that thankfully many of us will never have to be called on to do. He urged us to answer the highest calling of your heart and stand up for what you truly believe. He wrote, "In my life, I have done all I can to demonstrate that the way of peace, the way of love and nonviolence is the more excellent way. Now it is your turn to let freedom ring." The law has allowed many of us to live in freedom because places where our forefathers, our ancestors came from would not allow it. It allowed us to prosper in ways that others don't. It is up to us to stand up and be counted, and I urge you to do so. Thank you.
Thank you for attending the 40th Annual Legislative Update. We hope that you enjoyed the program. Next week, we will be sending a survey to you in your email, and we hope that you'll take the time to give us your feedback. It helps us all to do our jobs better. Thank you for attending, and we hope to see you next year at the 41st Annual Legislative Update at the Breakers.
Mary Ann and Hillary, we on the Legislative Update Committee for 2020 want to thank you both for all of your hard work. This was not easy for any of us, and we really appreciate all of your efforts. So we all wanted to, in unison, say,
thank you, Mary Ann. Thank you, Hillary.
Thank you. Great job. Great job. Bye.